You're rocking with the best. You're rocking with the best. You're rocking with the best.
They studying the source now. Supreme Elite. New Empire Talk. Came on reading numbers, they were reading memes. He was reading filings, planning out the dream. Turn every late fee in the case law heat. Judge bang gavel, he don't skip a beat. They like how you flip stress into assets. How you turn a loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is a blueprint. Supreme Elite team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. Supreme Elite team, university. Turn the credit score into currency. Turn the closed door to a first key. Turn the side job to a legacy. He beat odds, then he beat litigation. Now we teach law like a new translation. From confusion into consultation. From survival into foundation. They log in, lights on in their eyes now. Section this, call that. They reply now. He like, know your rights, then apply now. God, that's the real drip. Let it dry now. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite team, that's the school stamp. Wave it. From the first lay bill to the full camp. New culture empire, watch the flag plan. From the bench to the block, he reversed that. Put the power in the pen, yeah, he birthed that. Every mind that he frees, that's a verse that. Whole culture on the rise, you can search that. Hey. Thomas is the blueprint. Write that in the sky, let the blueprint. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. They studying the source now. Supreme Elite. New Empire Talk. Came on reading numbers, they were reading memes. He was reading filings, planning out the dream. Turn every late. Supreme.
You're rocking with the best. You're rocking with the best.
Started out with a stack of bills. Hand-me-down suit, no fancy skills. Library card, late nights, cheap coffee. Highlighting on every page he copied. No letters on the wall, just notes on the floor. Scratch math running down the old front door. Every question that the others let fade, he turned into a rule in a plan he made. Time started teacher. Built it all from broken pieces. Read the books, the words got weaker. Turn confusion into secret.
You're rocking with the best.
Who's the man behind the speakers? Tell them that's my quiet leader. Time and started teachers. Yeah. He could turn a red line black in a week. Balance out the numbers while he barely speaks. Spreadsheets open like a map of his mind. Sees a hidden pattern where the rest go blind. Court dates circled in a second-hand phone. Drafts every filing like it's carved in stone. Plain white paper but the case shines through. Judge starts seeing what he already knew. Time to start the teacher. Build it all from broken pieces. Read the codes, the words got clearer. Found a taught the teacher's teacher. Oh, no cap, no down, no
You're rocking with the best.
but he wrote every page. Self-taught, self-made, self-drive. That fire turned out into something higher. We don't just follow, we climb behind him. He draws a map, we rise inside it. Thomas taught the teacher's teacher. Build it all from broken pieces. Turn those late night scrolls and research into freedom, into defense. When they ask who shapes the future, who we call when things get deeper, we just point and say our leader. Thomas taught the teacher's teacher. Started with a stack of bills. Now he's signing better deals.
You're
From the
rocking
back
with the
row
best.
to the speaker, Thomas taught the teacher's teacher.
Okay, so just as expected, I was removed from the group.
Welcome to another episode of Are You Afraid of the Dark? In this episode, Thomas breaks down the difference between the court filings that you see from sovereign citizen social media gurus like Pernell Elliott Williams and the use of the Uniform Commercial Code like it's the court rules. You will, once again, witness the masterful display of Thomas' court filings and the unprecedented motion for summary judgment filed on behalf of his client, and how no social media guru can ever get to the summary judgment stage as the filer and not the defender of it. And don't forget, the Supreme Elite Team University enrollment is now open.
As expected, I was removed from the group. Hey, yo, hey, I scalped him in his own comments. Look. He removed me from the group. So this guy was talking about his cases are unmatched. His lawsuits of Pernell Elliott Williams. He said his lawsuits and filings are unmatched. Now, you know, anytime someone comes and says that and they are not a legal professional, you know I'm gonna feel some type of way. Because in reality, my lawsuits are unmatched.
You're rocking with the
And
best.
no one wants to stand toe to toe with me in pro se litigation filings. Everybody runs. As you can see here, he ran. Content isn't available. Remove me from the group. Now he posts his case, Pernell Elliott Williams versus LVNV LLC. I have plenty of cases regarding LVNV when they were scalped by the judge. Of course, these people, this is the mindset. They bring the UCC sovereign citizen mindset into the courtroom. They don't file lawsuits in conjunction with the court rules and procedures and relevant case law. They file lawsuits based on their beliefs of the system. Hold on, don't tell me. Hold on, give me 1 second, y'all. Let me see if I can pull his cases up. Now let's read this. Oh, by the way, Pernell Elliott Williams, if you're going to post your case and you post this, because he posted on his Facebook page, my lawsuits are unmatched. When you're going to purposely lie to people, make sure you block out the case number so people can't look it up. Complaint for damages and injunctive relief. Number one, it's not even a legal caption. Plaintiff, Pernell Elliott Williams is a secure party agent for the estate of Pernell Elliott Williams. Right then and hold on. represented by this UCC1 finance statements, and is a non-citizen state national who has fully secured rights all over his legal fiction, including the use of a social security number. Right there, he lost his case, sovereign citizen. Right there, the judge sees it,
right there.
sovereign citizen. Right there. Paragraph, lost his case, frivolous, sovereign citizen. That fast. And this is the person that said, my lawsuits are unmatched.
You serious?
The UCC to these people, that's the court rules to them. They think the UCC applies in court in the way they cite it. Remember, us professionals, we do motions and pleadings. With them, they do affidavits and notices. How can you grant the court's jurisdiction over the relief that you seek when you say you are a non-citizen state national? When the 14th Amendment clearly says anyone born or naturalized within the United States or within the 50 states, you are a United States citizen and a citizen of the state where you reside. It's not if you want, or it's not, it was non-negotiable. That's how they look at you. Regardless. Not about you can choose your citizenry.
No.
Right. You cannot choose your own citizenry. It's non-negotiable. If you are born in the United States of America or naturalized, you are deemed a United States citizen, regardless of how you feel. And this is the difference. They do things based on what they believe or what they feel versus what it is. And this is why 99.99% of these people just floating around in these spaces are not going to get any closer to the results they seek in 2026, just like they haven't for 2025. There's nothing that's going to change in 2026 for these people. It's all going to be the same thing. They're going to waste 5, 10, 15 years in these spaces just wasting their life away on frivolous ideologies and beliefs that has no legal basis in law or fact. Defendants, LVNV LLC, Resurgent Capital Services, have willfully violated plaintiffs' legal rights, including the misuse of plaintiff's social security number and other identifying information, which plaintiff has secured under common law copyright, a commercial security agreement, in a UCC1 financing statement. So the common law copyright, the commercial security agreement, and UCC1 financing statement, that comes as when you buy the redemption manual, the version from 1998. When you buy that version, it comes with those exhibits in the back that you could just tear off and file. It comes with it. See, that's the thing. Everything that he's studying is nothing but the old, there's nothing new here. Common law copyright, we're not in common law anymore. In order to copyright, you have to go to the United States Patents Office, and the headquarters are in Alexandria, Virginia, and do it the legal way. But they think we still reside in the 1800s where everything was common law, not knowing the courts don't, or the government, they don't operate under common law. There are no more common law courts, because if they would have read the Erie versus Tompkins case, I think 1938, that was one of the cases, and the years right around those years, so from 1933 through 1940, actual common law courts have been taken out. And this is why you have civil courts and you have criminal courts, because the civil courts is where common law can be applied and you can get equitable relief. This is why foreclosures are equitable reliefs. Mortgage, autos, these are equitable reliefs. But they actually think there's an actual common law court that you can step into to get the release. And this is all matter of public knowledge. So if you don't even know this today, it's like you're never going to get it. And someone said, well, if I'm so wrong, tell me where I'm wrong and tell me. I said, no, I'm not supposed to tell you. I'm not telling you anything. You're supposed to know. If you don't know it by now, go back and research, or you're never going to get it. See, they think they can bait me in on giving up the sauce. And this is how you know how far these people are falling from grace. When I cite court cases that disputes the same post that the gurus is posting, and I don't believe all of them follow him, because some people in those posts was like, yeah, this is sovereign citizen. You don't know court. So when he filed and said, hey, look, they're trying to sanction me, y'all. It was like, because some people was like, you don't know law because you're doing that sovereign citizen stuff. So there was some people was like, man, that's cold-blooded BS. This court has jurisdiction under 28 U.S.C. 1331. No, they don't. Not over those sovereign citizen claims. In 1332, the cause of action arises when defendants violate plaintiff's rights under federal law, including Social Security number privacy laws, UCC 1 security interests, and common law copyright protections. None of those have legal validity. The courts have jurisdiction over those frivolous claims. They have no jurisdiction over those claims. They're frivolous. There's nothing in law and fact that supports his contention that they have jurisdiction. Venue is proper under C-39 because the defendants do business in the district and is a substantial part of events giving rise to the claims occurred here. Plaintiff, Elliot Wood, defendant. Plaintiff sent an official cease and desist notice and Scott Gutierrez on around May 2024, demand that defendants cease the reporting, use, or dissemination of plaintiff's Social Security number and any unauthorized use of plaintiff's collateral. Number one, how is reporting the obligation that you owe violating the law?
If you're doing it, stop it. Get some help.
Remember, all they do is say they did it so wrong, but where is the factual allegations to back it up? And do I really want to know why they never have case law to back up their sovereign citizen claims? Because none exists.
You need help. You need serious help.
We're all denying the same claims that they're about to attempt to use. So what do? Remember, it's a mindset and belief system for them. So they can read a court case, multiple, that's denying the same claims they're about to attempt. Instead of going back to the drawing board and not submitting it, since they believe it's true, they're going to submit it anyway and then act surprised when it gets thrown out. Because when their sovereign citizen claims gets thrown out, they all believe that the courts is trying to stop them from their expressing their rights. Like it's one big conspiracy theory against them now.
This is just a conspiracy. It's a conspiracy.
And more than likely, this all stems from a just trying to get out of his debt and not trying to pay a bill. They use the sovereign citizen methods as a cover up for not paying a bill. And this is the mindset of hundreds of thousands of people in this space. This notice was duly served via certified mail to the president, yet defendants failed to comply with the notice because you didn't follow the proper chain of title. What makes you think that the president is going to read any letter from you that's unsolicited? In order to send, you have to go through the president's secretary. They have to know it's coming. You cannot send, a consumer cannot send unsolicited mail to the president of a, look. This is the difference between people with a professional mindset, because we already know these things. Plaintiff sent a debt verification request to the CFO on May 16, 2024, pursuant to the Fair Debt Collection Practice Act, 15 U.S.C. Section 1692, requesting verification of the claimed debt. Now, here's the thing. I guarantee you it was some wet blue ink signature. I guarantee you it was some identify me. That's not me. That's the all caps. That's the corporation. Identify me as the human being. My name is spelled in all caps. That's not me. I got a UCC 1. I own that. That not me. See how stupid these people sound? And all that's going to drop to the wayside if they hit the lottery for $5 million. That sovereign citizen shit going to drop to the wayside, and they're going to go back to being a major consumer. Defendants continue to report the debt and plaintiff's social security number to third parties, violating plaintiff's rights under federal law. What federal law did they violate?
We have no idea what you're talking about.
I mean, I'm pretty sure in every agreement, they're going to report whether you're making your payments right to the credit agencies. So what do you mean? Defendant sent copies of the plaintiff's credit card statements from his creditor. Defendant sent copies of plaintiff's credit card statements from his creditors and not a contract or debt with LVMV LLC. Nobody knows what it means. Violation of UCC 1. UCC 1 is not even a statute. It's a form.
You need help. You need serious help.
Violation of UCC 1. I told you, they think UCC 1 is the law. It's the holy grail. They think the UCC is the holy grail of court actions. A UCC 1 is a financing statement between a legit debtor and legit creditor. And debtor is never the creditor's name spelled in all caps. But the redemption manual and the ideologies have told people for the years, take control of your straw man. File it as a transmitting utility. What does transmitting utility mean? I don't know. It's just part of what I was taught. A public finance transaction. Oh, so you are a electric company that doing business in the state? That you issue bonds and stuff? You raise municipal bonds and stuff for this? Is that what you're doing? No, it's just my all caps. What's your collateral consist of? My driver's license. Oh, let me guess. That's a contract too. That's the security too. Your driver's license, right? Your application, right? Let me guess. What else you got in there as your collateral? Your social security number. I bet you got the back letter and the 8 numbers on the back of it too, don't you? Federal Reserve Bank trace number, huh? You got that on there too. What else you got in there? Oh, you can't forget this. You got your birth certificate in there too, right? Oh, you got your registry number on there too, don't you? What else you got in there? Your security agreement. Between you and yourself. Yeah. That's a decent financial statement. Defendants have used plaintiff's SN and other identifying information without authorization in violation of plaintiff's secure party interest as established under plaintiff's UCC 1 finance statement, which was filed in 2024. So you give them your social security number, filled out the application to get whatever transaction. So you gave it to them. And if you probably read the contract, it says that we're going to report to the credit bureaus and all that. And then they have the notice of the fair debt, credit reporting act. So you already knew they was going to do it. But ever since you filed the UCC 1, when you become woke, now you could just unilaterally change the terms of the contract. Amazing. Amazing. Common law copyright violation. None of that can ever be enforced in court. It's a googly gop. It means nothing.
Emotional, damn it.
Defendant's actions, including the unauthorized use of plaintiff's legal fiction. Plaintiff's legal fiction. Can you just imagine a legit, I know every time these sovereign citizen gurus file lawsuits in their own name or behalf of their clients, I know they're licking their chops. If I was a lawyer defending it, oh my gosh, I'd be in heaven every time I see a filing like this. Damages to creditworthiness as a direct result of defendant's fraudulent actions. Still hasn't said what was fraudulent. Plaintiff has suffered significant damages to his creditworthiness due to incorrect and fraudulent reporting to the major credit bureaus. This violation has led to severe financial injury. No, it didn't. No, it didn't at all. Because look at this section. We had 12. Look what he filed it under. Factual allegations. Okay, I thought it was factual background. Okay, so let's see if he gets to the standard of review. Let's see if he gets to the case citations. Let's see if he gets to the case citations now. After you got the factual allegations, now you get to your arguments. Now let's see if he has case law. Let's see if he has case law to support all 12 claims. Let's see if he has case law to support it. Let's see if he has authoritative case laws and court precedents to support his claim. Let's see. Nope. He goes straight to claims for relief. You want to know why? Because they never find case law to support their allegations because they know none doesn't exist. This is all sovereign citizen belief filing.
Checkmate.
Where's the case law at? You got factual allegations. Well, if you're filing a complaint, all your allegations have to be backed up by factual evidence and case law to support it. These are the federal court rules. So you've already hasn't complied with the federal rules just by filing this. Where's your case law at? Where are case law where courts have agreed that damages such as the ones LVMV committed towards Pernell Williams have been awarded to other plaintiffs? Where's the case law at? You don't see no case law because none exists substantiating this garbage.
What?
Claims for relief. Look at this. Violation of cease and desist notice. Where's the case law supporting violations of cease and desist notices? What case law can you pull up that when you send a cease and desist notice that they're supposed to just stop or it's a violation? What is a cease? What type of legal enforcement does a cease and desist notice have in the court of law? Absolutely nothing. It's just a request to stop. There's no violation of it. Either they're going to stop or they're not. If they don't stop, then you just bring a lawsuit alleging the damages that were communicated in the cease and desist. You don't bring a lawsuit because they violated the actual cease and desist notice. The correct term would be a gag order. But obviously you ain't getting a gag order with this garbage. You see how we can just pick these gurus apart, y'all, effortlessly? That we just picking them apart, just picking them apart. And he ain't the only one. Pernell Elliott Williams, there's about 150, 200 groups on Facebook. They're all saying this garbage. And they all lying to the people like they're going to get them a win. Plaintiff alleges and incorporates by reference all prior paragraphs. Defendants continue use of plaintiff's Social Security and reporting of fraudulent debts despite receiving a cease and desist notice constitutes a violation of plaintiff's legal rights under federal state law. What federal and state law did they violate, and how was the debt fraudulent? How, you haven't even substantiated how the debt was fraudulent. Oh, they have all the talks. And you know one thing I noticed? When they're making these posts on Facebook and other platforms, they can explain left and right how the debt was fraudulent, how you don't owe the debt. But as soon as it gets to court, it just becomes very vague. Why didn't you get into detail like you always get into detail in your Facebook posts? Oh, because you can't find any legal citations to substantiate it. Oh, I get it. So you're just talking to the people, painting a picture from them. But when you go to court, you're very limited. Not one case citation. Damn gurus. You've been researching this stuff for, you look like you just started. This is old 1995, 96 type of arguments here. You ain't even step up to the late 2000s sovereign citizen arguments. This is 1996 shit here. I done seen common law copy. That shit's like the early 90s. But let me guess, they think it's something new they just researched. Violation of UCC-1 financing statement. Where's the case law on that? How can you prove in court through factual evidence that violation of a UCC-1 finance statement is a violation of state law? You know what's a violation of state law? filing a false and frivolous financial statement, which I believe that that financial statement was rejected and stricken from the record. I totally believe that was the case. But y'all know they'll never show you when they strikes their fraudulent UCC1 statements. But I will give him credit for posting the motion to sanction him, even though he tried to spin it like, look what they just tried to file against me.
Yeah, I don't get the point of why he did that.
Well, I don't even know why he even posted it. But I'm glad that he did. At least he was being a little bit transparent, because all these other teachers, they just would have swept this under the rug and continue teaching. And this is the part what they do when they stop trying it on their own. But this is the part when they stop trying it on their own and they just trying to make a profit off the ideology now. A lot of them go for that. Trust me. A lot of these teachers, they've already tried it, lost, know they're not going to win, and they just sell it to people who believe in it. That's all they do. Violation of SSN privacy laws. Defendants' unauthorized use, sale, distribution of plaintiff's SSN constitutes a violation of federal privacy laws. How did they violate it? What did they do? Who, what, when, where, how? You said the word fraudulent, like fraudulent debt. So now the pleading standards have been heightened. Where's the fraudulent? Where's the fraud at? You have not alleged fraud. I mean, you have alleged fraud, but you have not pled fraud and met the heightened pleading standards under federal law when you allege fraud. Where's the who, what, when, where, how? Who did what? When did they do it? Where and how did it damage you? And you don't see not all vague. He's not the only one. Every single one of these gurus filings are going to look like this. And the ones who got a little bit of understanding of case law but don't really understand, they're going to misquote statutes, misquote the context of the cases that they citing. I told y'all, less than 1% of pro se litigants ever win in court. That's not a joke. Less than 1% ever wins. Do you know how many things you have to know before you even think about filing a lawsuit about court? Do you know how much ground you have to cover? Like I've been in the court system, like documents and stuff, since 2012. You see, I get what I'm saying? Since 2012.
Absolutely.
Pro se, I had a lawyer. I just didn't come out the blue with this. I've been knew about court. Even when I first started, I've been knew about court rules, court procedures. Common law copyright infringement, of course. No case law. Defendants unauthorized use of plaintiff's legal fiction. That's not even, y'all know that has no legal law basis. That basically he's saying straw man. So when the judge gives this order of opinion, all he's going to do is says, it appears that the plaintiff has adopted the sovereign citizen redemptionist theory, in which courts have consistently rejected as frivolous. He knows that was the order. So they threw the case out and they probably gave him 14 days to file an amended complaint. In violation per month. You know what this means now, damages? You know what this means? Broke, destitute, in a financial bind. Just everybody that files stuff like this with these outrageous numbers, they're in a financial bind. Every single one of them. Because even if we just go, let's say I give them the Fair Debt Act. The statute poses limitations. I think it's like a fine up to $1,000 per violation. So the statute calls for a limitation on the amount of damages. It's called a money mandating statute. But he'll come in with a $15 million per month on a cease and desist violation with no case law to support that violating a cease and desist order gives you a right to monetary damages in court. See, they file lawsuits based solely on belief systems, not under the court rules and procedure. As a result of defendant's action, plaintiff has sustained the following damages: $15 million per month from May to January 2025 for violating the cease and desist notice and UCC1 financing statement. Once again, it's a frivolous assertion. There is no case law to support there is not even a term violating the UCC1 finance statement. That term has no legal basis. $25 million for the violation of plaintiff's common law copyright. That is a fraudulent term. You have to get a copyright through the legal means by copyrighting it with the government. And then if anyone violates your copyright, you can send a cease and desist notice for copyright infringement. If they don't stop, then you can what? Sue them in court for copyright infringement. But you got to have something to copyright, not your all caps name. And I'm telling y'all, these people will never figure the system out. The way they think the system operates is totally different from how the system really operates. The problem is they're so far gone down in their frivolous belief systems that they can't admit to themselves that everything they've been studying has been wrong. They refuse to admit it, and they're going to hammer it down. Total damages, $265 million, which includes all damages outlined for violation. Look at this. Look at this. SSM privacy, copyright, copy law. Right. Now, guess what? Look, he thought he was doing something too. And this case was dismissed. This case was dismissed as frivolous.
For real.
Look at it right here. Order signed. Case terminated December 23rd, 2025. Case terminated. Oh, over. See that order? That's the one I wanted you to get right there. Look, response to defendant's motions for Rule 11 sanctions by Pernell Williams. You see that? That was the when he posted on Facebook, the one I shared to my page, and he took it down and removed me from the group. They filed a motion to sanction him for filing frivolous claims. Look at this. This is him, LVMV. This when he filed the case. Okay, yeah. Look, order proposed. Now look at this here. Response to defendant's motion for Rule 11 sanctions. I would love to see that. Now look at this. Notice of power of attorney. Order for proposed scheduling order. Right. Look at this. Disclosure statements filed. Answer to complaint by Resurgence Capital. That's what I wanted. A response to the answer to complaint. Status report. Notice of change of address. Now all this right here, he got this thrown out as well. He got the other one thrown out, and that's the Rule 11 sanction where they sanction them at. Now let's get to real law. So, and this is the part where they're really, well, not this part yet. I'll let it play on. I'll let it play on. So we have client. They had a summons against her. You are hereby summoned in a complaint, a copy of which is here to attach and made a part of, has been filed against you in this court by the plaintiffs, Velocity Investments. You are required to serve before the plaintiff's attorney, boom, 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 within 28 days of this summons. She came to me damn near, like, by the time I actually got to it, she came to me 10 days before. By the time I actually spoke to her, we was like 3 days before.
He don't have no background, it's all self-taught. These online gurus, they all copy his style. He said, Thomas, lead the team, let's go to the top. Thomas, lead the team, let's go to the
what do I always say? It's nothing more than a belief system and a theory to these people. They don't even believe it themselves. They don't truly stand on it. Everybody that's out here that's talking this admiralty jurisdiction, I don't gotta have my courts registered. I tell you this. I will tell you this. If you were so happy to rear in one of them, I mean, someone, a normal, everyday thinking citizen who has insurance and their vehicle is registered the proper way and they got Geico, since they don't deal with corporations, remember, corporations aren't only allowed to deal with other corporations. Corporations can't deal with private individuals, right? Okay, so we're gonna make you stand on that, right? How much do you want to bet that if someone was to rear end them and the person that rear end them was 100% fully liability, all that, right? How much do you think that these same people that come online talking this sovereign, these L's, these bays, these patriots, these redemptionists, these American nationals, these sovereign to the land, indigenous to the land, Siri jurists, how much you want to bet that all of those people will be taking down the other party's insurance information and suing their insurance? How much you want to bet they won't be giving them a fee schedule? Uh-oh, we're going to talk about it today. They're not going to give them a fee schedule because TikTok, y'all going to learn. And a lot of you are going to learn the hard way. I'm not your flash buy pen over the night. I just didn't pop out of nowhere. Oh no. I just didn't pop out of nowhere. So, and I've been around long enough to know that every single person who was so bent on the feds, the Moorish Americans, the Patriot Redemption, whatever you want to call it, those are the ones that chase the fiat currency, Federal Reserve notes more than people who don't have that ideology. They're the ones who chase it the most. They're the ones who are money hungry the most. Because before we get into this admiralty talk today, I always found it interesting how these same teachers always accept the same money that they say has no value. It's just a piece of paper. It has no value. It has no worth. It has nothing. But they will accept that same species of currency and go pay their bills with it while they'll give you a fraudulent instrument to go pay your bills with it. I find that very interesting. And you, international promissory note, Miss Bay, Diamond Bay, your ass is coming about them clouds today too, girl. Oh, I ain't forgetting about your ass is coming about them clouds too today, girl. Yeah, let's get into it. Your ass is coming about them clouds today too, girl. I got something for your international promissory note, getting the titles and the vehicles back to your car. I remember, girl, I got memory like an elephant. Don't forget nothing. And shout out to her. She wasn't being disrespectful. She was not being disrespectful at all. She wasn't. She was just defending her position. So I'm not going to blame her 100%. But Bay, Diamond Bay, I need to tell you this. Just as much as I can take it, I can dish it out. But I would tell you this, ma'am, you did not get your vehicles back 100% free and clear with the international promissory note. I just want to tell you that because you was accepting people's emails, you was accepting people's money, flashing through those documents like you won, and you said you had the title and you showed the title in your live. I don't know if you reposted the live, but ma'am, you had the application of title. You didn't have the certificate of title, and you moved fast so people wouldn't see it. But I caught everything because I got eyesight like Gambit. So let's talk about the sovereign. We're not going to say sovereign. Let's talk about, let me share my screen. TikTok, we are over here live at the New Culture Empire. But let's share my screen and let's get in. Let's read something. Let's read it all together This is the title is The Sovereign Citizen Movement and Maritime Admiralty Law. Now, most people may say, well, Thomas, this is biased. This what you're about to read is biased. Okay, I will give you that. But does it make a difference if I'm reading from this right here? If I can just go straight to the Admiralty statutes? As a matter of fact, let's go to the Admiralty Court statutes first. Let's do that. Let's go to the Admiralty statutes first. Let's go to the Admiralty statutes first, because I believe, let's start it off with the law. Oh shit, what am I doing? Admiralty Court procedures. Let's start it off with what they say first. Let's start it off with what the federal courts say first, or the courts say first. Okay. All right. Admiralty Court, also known as Maritime Court, is a court that exercises admiralty or maritime jurisdiction. Okay. Jurisdiction. And here's civil cases related to admiralty and maritime law. So that for my detractors and opposed adversaries, that's called context. Just in case you ain't know. See, over here at the New Culture Empire, we don't read things in a literal sense. Authorization in the United States. The admiralty jurisdiction is authorized by the United States Constitution. See Constitution, Article 3, Section 2, Clause 1. Conferred by the U.S. Constitution, meaning the Constitution granted the federal courts the jurisdiction. Federal district courts have original subject matter jurisdiction over any civil cases of admiralty and maritime jurisdiction. Federal district courts. So, if what y'all were saying was so true, if you got pulled over for suspended license, no plates, unregistered vehicle, then by default, if what you're saying is true about admiralty jurisdiction, you will be going into a federal district court and not your state local court, at which the jurisdiction is within the, parameters of the location of the alleged civil or criminal violation. If what y'all saying is so true, everyday life, so you don't have to go to a book to prove me wrong, just look at your everyday life. If they're saying admiralty jurisdiction is so true in the sense on how they explain it, then by default, then by the Admiralty Court own federal statutes, the procedures, you will be going into a federal district court. That's one indicator that you're not going into an Admiralty Court. Federal courts are called Admiralty courts when exercising admiralty or maritime jurisdiction. See 28 USC 1333, y'all. And this is and the reason why I'm bringing this up, because they will never see or point to these things to prove that they're right. It's going to be some offshoot document, some biased sovereign citizen pamphlet, or some manifesto posted online, or some old 1980s groups of these old outdated gurus. They're never going to go to the letter of the law. And when they do, they even misinterpret that. The district courts have original jurisdiction exclusive of the courts of the states of any civil cases of admiralty or maritime jurisdictions, saving to suitors in all cases all other remedies to which they are otherwise entitled. Any prize brought into the United States and all proceedings from the condemnation of property taken as prize. I'm not even going to get into what that means because it's clear. They're not talking about you as a prize. They're not talking about your all caps. They're talking about vessels, maritime. You're at the seas, high waters, oceans, Pacific Ocean, the Red Sea, the Atlantic Ocean. Like, come on now. It's getting to the point where it's starting to get pathetic. The law adopted by Admiralty courts includes the general maritime law insofar as it is acceptable to the courts. Modifications of that law by congressional amendment, the common law of torts and contracts, and international prize law. The body of law is always subject to modification by the paramount authority of Congress acting in pursuant of its powers. The scope in the United States, the Admiralty Courts exercises jurisdiction over all admiralty and maritime actions comprising two types of cases. Two types of cases. Now, the video that I posted on TikTok about the Admiralty, listen here. All I got to say is for all you detractors and everybody who just commented saying I was wrong and left and never showed the results of their case, this is how it's checkmate right here. Checkmate on all of you right here. TikTok, we are live at the New Culture Empire on YouTube. We are live at the New Culture Empire on YouTube. Comprising of two types of cases. Those involving acts committed on the high seas or navigable waters, including prize cases and torts, injuries, and crimes committed on the high seas.
You're rocking with the best. You're rocking with the best.
Committed at the high seas. And those involving contracts and transactions connected with shipping employed on the high seas or navigable waters. Now, where is the legal connection to you getting pulled over for suspended license and not having a vehicle registered and your sovereign citizen paper license plates that you bought online for $50 from the USAR website, them little license plates? When you step into court, in your mind, in your own mind, what makes you think that you got pulled over on the high seas? In your mind. Because now I'm just trying to understand the mindset. What makes you think, by reading the jurisdiction of Admiralty, federal laws right here, Cornell Law School, y'all go to this for everything else. Don't try to invalidate it now. Y'all go to UCC on here. So don't try to say, what is the connection? How do you make that connection? And listen, throw your script away, throw your manual away, throw all those 1922 Black's Law Dictionary versions. Throw that out today. Courts don't even use the Black's Law Dictionary 3rd edition, 4th edition, 5th edition. Those were written in times where the words and transactions and the words were spoken and it was different then. Courts are going to cite the 11th or 12th edition. Y'all got to come back to planet Earth. You got to get out the 1800s. You got to come to 2026. I know y'all want to stay in pre-1933, but the reality is it's just not going to happen. We're in 2026. Oh, by the way, the Emergency Banking Act. You remember that emergency? Remember the Emergency Banking Act, March 9th, 1933, the banker's holiday. Yeah, that y'all still like to put on your documents. Y'all know that emergency ended in 1978. It's no longer any emergency related to the
March 6th through March 9th, 1933. It's no more emergency. And everyone that through the executive order, April 1st, 1933, when they passed the executive order to prohibit the hoarding of gold and silver and gold coins and gold bullion, they made everybody turn their gold coins and gold bullion in, and the gold certificates and silver certificates, because the gold and silver, there was no point of having them being used in everyday transactions because the government went to a fiat currency system. They got off the gold standard, meaning gold was not backing the dollar anymore with the passage of HJR 192. So when they told everybody to turn in their gold, they gave them legal tender in exchange. And the reason why they gave them legal tender in exchange is because of the Fifth Amendment of the Constitution. They had to, private property may not be taken for public use without just compensation. They compensated them with the equivalent in legal tender. So the argument that, oh, they took the gold and silver from us, we can't pay our debts, that falls as a matter of the executive order. You see how we just sniping what you believe so much down? We got to tear you down to build you up. Now, admiralty courts operate under unique maritime law rules and have differences in procedure from civil courts. The most significant one is that admiralty courts do not impanel juries. Without a jury trial, the cases are heard by a judge. So this is the key thing I want y'all to take away from this, is that admiralty courts hears two types of cases: acts committed on the high seas or other navigable waters, including prize cases and torts, injuries, and crimes committed on the seas, and those involving contracts and transactions connected with shipping employed on the high seas or navigable waters. So after reading this, if you still saying that the video that I posted was wrong, it clearly means that you are so far gone in your theories that this is nothing more than a belief system for you now. You don't care about winning and getting the job done. You just care about defending your belief. If that is the case, then I don't win there. This is nothing more than a belief system to a lot of people because it helps them escape the realities of their real lives. Now that we got the official interpretation of admiralty in maritime courts, this is, when I first came across the concept of sovereign citizens, I was intrigued as I was puzzled. Their unwavering belief that they're free from government authority struck me as both rebellious and unconstitutional. Sovereign citizens claims they don't have to obey laws because they aren't legally bound by them, due to an old set of rules they interpret as maritime admiralty law or the law of the water. One particular conversation led me down this rabbit hole. At dinner in Helena, Montana, I met this interesting individual who began passionately explaining why we don't really need licenses, permits, or even taxes, all supposedly rooted in our maritime origin. According to him, legal terms we take for granted every day, like dock and berth and ship, have hidden meanings tracing back to naval and maritime traditions. And it turns out these beliefs aren't entirely fringe. They're part of a broader movement with a surprising number of followers. Understanding how people interpret law, authority, and freedom can open our minds to fascinating insights. One of the more controversial yet captivating ideas gaining attention is the intersection of maritime admiralty law and the sovereign citizens movement. While these topics may sound esoteric, they hold deeper implications for how certain individuals view personal sovereignty and legal authority, making them important to grasp, even for entrepreneurs, investors, and ambitious individuals seeking clarity and navigating today's world. Now, here is the thing I want to tell you. I'm not against having our own personal sovereignty in our own right, being able to live our life on our own terms, being able to do what you want, the freedom to choose your own destiny, the freedom of not having the government encroach on everything. I agree with all that. I by all means, I agree. But once you start to transition into what you call your rights and freedom that leads you down financial turmoil, criminal cases, then you got to start to readjust how you see the way you exercise your freedoms. Because exercising true freedom should never lead to you getting hit with fraudulent filings, frivolous filings. They're coming to take your stuff. It should never be that. Now, we know there's always a price to pay for freedom. But if you're going through all those things, but in the end, you're not getting any closer to the freedom that you think you deserve, at some point, the blame can't always be on the government. At some point, maybe you have to look at how you're, maybe you were just wrong. There's nothing wrong with admitting that, you know what, I fell down the rabbit hole. Hundreds of thousands of people fell down these rabbit holes. A lot of people have been bit by that bug. There's a lot of people that I had to bring back to reality. You won't be the first. It's not a bad thing. But the more you keep denying the reality, and we're talking about the reality that you see every day, argue with the police officers on the side of the road, the court still holding the hearings, even though you're challenging jurisdiction, saying it's an amnesty court, that it can't just be that the judges just don't want to follow the law anymore. It has to be more than that. Now, what is maritime admiralty law? Maritime admiralty law, often referred to as law of the sea, governs legal issues related to ships, navigations, and marine commerce. It originated from ancient times when trades between nations was done mostly by sea, and agreements were needed to regulate disputes among sailors and merchants. This body of law is global, shaping everything from trade routes to the conduct of ships at sea. Admiralty courts were established to resolve maritime disputes, and these legal systems have persisted, influencing modern international trade, shipping regulations, and even insurance. Now, for most of us, admiralty law probably seems to have little relevance unless you're a sea captain or shipping magnate. But this is where things get interesting. Sovereign citizens believe that admiralty laws apply to everything, not just matters of the seas, but also their personal freedoms, taxes, and even their citizenship status. Listen, do you not think that I would love to cancel my contracts and not be responsible for a lot of things? I mean, I get why people believe it. I mean, do you not, I hope you don't think that I wish that there wasn't a secret account in our name. I mean, a lot of, listen, in a perfect world, hell yeah. Shit, let's get it. But the reality is none of it's true, because I don't try to shove the law in your face. All I got to say is, all you have to do is look at your own life and ask yourself, does that reflect of someone who's accessed their multi-billion-dollar estate created by the Social Security number? Is your life a living reflection of someone who's been successful in the pursuit of that? I won't hear about no third parties. You. Is your life a living reflection of it today, in this very moment? In this very moment? If the answer is no, I need you to seriously ask yourself why it's not if that account really exists. And then ask yourself this. If they let me, if they gave me access to mine, and this is not a known secret. Everybody knows about the story. So it's not like, oh, only the few will know. It's all out in the open now. There's blogs on it, government. It's no secret anymore about that ideology. So ask yourself this. If everybody, because the government grants one, they got to grant all. But ask yourself these questions. If everybody accessed their state, what type of country do you think we'll have? Who would work? Where's the separation of classes at? Everybody will be a billionaire with the money devaluing even more. Nobody's going to work at the factories to create the cars you love to drive. Nobody's going to grow the foods that you love to eat. Nobody's going to come cut your grass. Everybody's a billionaire with nothing to spend it on because everybody has the same. Now the value has significantly decreased. Just think about it. Let's say all of us accessed our billions. Nobody's going to build a house. Why would they build a house when they got billions? And since everybody has the same purchasing power, the bidding wars, you'll be paying $575 million just for a house. And whatever is left to be bought is going to be purchased. There will be nothing left. Can you imagine a country? See, in reality, you really don't like that scenario. You really don't like it. Also, no one can open up an account in your name without your permission. And by federal law, any name, an account, or secure, whatever that's on the books at the Treasury or the government, they have to send you a monthly statement. Have you ever received a monthly statement for that account? Have you received the account agreement letting you know how it can be used? You get your government charge card for your estate. I mean, these are all things that they do every day anyway when you got an account open at a bank or with the government or you buy Treasury securities. They send you a monthly statement of your securities, your yield to date. The government sends them faithfully. You get them paper, you get them electronically. You can go right into your TDA account and see the status of what's going on. Why is the Treasury account, secret account, which is in our name, which is an account, which brings it under federal law, why haven't we ever received an accounting statement? I know Pastor Tony wants you to think that if you get a bill and it's the positive sign and it's not a negative sign, then it's a positive number. If I really owed, it'd be negative. I know people want to think that when they look at the bill as well. But the reality is, in the financial world, if it's money that you owe them, you get a bill. If it's money that you owe them, it shows up as a positive number on our end, and it shows up as a negative number on their end. When you pay the bill, let's say it's $300, you're going to get a bill for $300. It's going to show minus $300, meaning this is what they expect to be coming in from your payment. Now, when you pay the $300, their negative $300 goes to zero. And when you pay the same $300 on your account, it's going to go to zero. You see how when you make your payment, both accounts go to zero. The money that they're entitled to now goes to zero. And then the amount that you owe goes to zero. Now you're starting to see how real life operates. Ask yourself, when you got that contract, was there any stipulations or agreements? Because you can put it in the clause now. Not saying you can argue that it be in the clause. Did you have in the clause alternative methods of paying the bill, paying the debt, paying your mortgage, paying your auto, paying your credit card? Did you tell them you was going to use an international promissory note? Is that in writing? Is that stipulated in writing? Or it's the normal, everyday, acceptable means of cash. You know, the same cash or debit or credit that you use when you go to the mall and buy something that you want to buy, that same money. We talk about that same money. When you went to go buy those shoes at the mall or get that outfit on Shein, did you give them an international bill of exchange to pay with it? Did they accept it? Did you get them a 1099-A to pay with it? Because my belief is, if this is what you believe, go all the way with it. Live your whole life like it. Don't pick and choose the spots that you want to do it. No. Walk, even if you're buying a soda. Hand them an international promissory note for a soda. You should have them all on deck. See, I mean, if we're going to go with it. Don't just, I'm going to use it just for this. I'm going to pay regular. Nah, be consistent with your position. Be like that with everyone. But when you start to pick and choose when you want to do it, it kind of comes off that you're being disingenuous. I mean, you know you're being disingenuous. I'm just saying. To the rest of the world, it looks like it as well. And then ask yourself, if someone is teaching you how to discharge your auto with the international promissory note, obviously they know how to get it liquidated. Obviously they know how to get the value recognized. Why don't they allow you to pay them with the international promissory note instead of paying your hard-earned money in exchange for the international promissory note? You get what I'm saying? If you know how to liquidate these international promissory notes, and you know how to cash them, you know how to get them recognized, a financial institution is a financial institution. Why don't they accept your international promissory note as payment for the service? Exactly. Questions, and all I'm doing is asking questions that you all want to ask them anyway, but you're too scared because you know they're going to block you. That's all I'm doing. I'm just asking questions that you want to ask. I am the voice of y'all. Some of y'all may be a little too timid in the hard questions, the gurus. I'll ask them for y'all. Hey, I've been blocked by 40 gurus. Ain't nothing surprise. So, sovereign citizens, a loose group of individuals who reject the authority of governments, often argue that the government unlawfully imposes its power on individuals through hidden contracts and legal jargon. To them, these hidden contracts fall under the jurisdiction of maritime admiralty law, not common law. They believe that upon birth, individuals are unknowingly entered into a contract with the state through a birth certificate, which, according to their views, is linked to a fictitious legal identity and corporation, distinct from their natural sovereign self. To unravel their reasoning, admiralty law is global governance. Since maritime admiralty law governs international matters, sovereign citizens sees it as a shadow legal system used by governments to exercise authority. Birth certificates as contracts. Sovereign citizens often claim that a birth certificate represents a corporate entity created by the state, which places individuals under admiralty jurisdiction rather than common law. Language manipulation. The idea of word magic comes into play when sovereign citizens argue that the legal language is deliberately deceptive. They believe that certain words in legal documents have hidden meanings that bind individuals into contracts they didn't consent to. So while the rest of us may see admiralty law as an arcane legal relic, sovereign citizens consider it the cornerstones of government overreach. And this is why I attack the cornerstones of their beliefs, the foundation of their beliefs. The methods, we all know the methods they use, but I attack the origins of their beliefs. These are the things that they believe to the core because it shapes their processes. Look, the birth certificate shapes their processes. The secret account shapes their processes. Because, especially the secret account, because so many processes spring from that. The negotiable instruments, the withholdings on tax returns, sending these stuff in to pay your bills, going out to purchase, make large $1.7 million purchases. I just think the idea of having it, it's like a rush to them. Like the chase of it. It's like they start spending that money in their mind. You notice how everything is over the top with them? $500 million tax return, $1.7 million home. You notice how everything is over the top? Right. The sovereign movement can be understood as a form of legal dissent or even personal rebellion. Those who identify as sovereign citizens reject the legitimacy of federal, state, and local governments, claiming that they operate under fraudulent authority derived from admiralty law. At the heart of their belief is the idea that governments operate more like corporations, and that through documents such as birth certificates, taxes, and licenses, they attempt to exert control over an individual's natural rights, even though the federal government has nothing to do with the driving laws of each state. Let's get it. Let's get it. Let's get it. Shout out to Lux Private. Oh, your name is cut off. Where? Lux Private Media. You are officially...
You're rocking with the best.
Let's get it. Shout out TikTok. Shout out to Lux Private Media. Appreciate you for that, broski. Or sir, man, I don't know what your gender is, but it doesn't even matter. Shout out to you. At the heart of... They claim the only valid law is common law, not statutes or regulations that they see as part of a deceptive legal system. Now, here's the thing about that. Ladies and gentlemen, I swear I'm not even trying to troll. The federal common law, it's not like you can walk into a distinct common law court. Common law is a doctrine and a creature of equity, meaning doing the make the parties whole. That's all it is today. It's a doctrine. Courts can apply it in specific cases to grant equitable relief. But even the federal courts, being courts of limited jurisdictions, they're always going to look to the state law when applying common law as a doctrine. So when y'all putting UCC 1-308 on your documents and your affidavits of truth and your 5,000 notices and your $1 trillion fee schedules, I know you think you're doing it under common law, but the mere fact that you cited the UCC, you're actually citing statutory law. Because as I said in my video on TikTok, the Uniform Commercial Code is statutory law. The UCC that you go on, type in on Google, the UCC, that's not the law. That was the blueprint in which each state adopted their own version. So when y'all filing y'all court filings, y'all be citing like UCC 1-304. You're not even citing the law. But since you're sui juris, the courts kind of know that you don't really understand. So what they'll do is they'll take your UCC 1-304 and they'll just look at the state law's version, because it's the state law's version that controls. So the Uniform Commercial Code for the last time is statutory law. It's not common law. Never was, never will be. And just because you believe it is, doesn't make it true. And it tells you that when you go on the UCC. As a matter of fact, let me YouTube, I'm about to show you exactly what I mean. It tells you right here. And this is the problem that I'm trying to get people to understand. We can't get so far into our beliefs that we just overlook things that are right in our face. Right here. Right? Here we go. Our collection aims to show each section of the UCC. Oh, hold on. My bad. Our collection aims to show each section of the UCC in the version, which is most widely adopted by states. That means we will not always display the most current reversion, if that version has not achieved widespread adoption among American legislators, meaning your state law. So you may be citing an outdated version when you go straight to Google UCC, Cornell Law, UCC. Like little stuff like that. It's really coming down to, that's a matter of just common knowledge. But you will skip over that and go straight to UCC, UCC Article 9. So, can we all be in agreement? Can we all be in agreement? And can we at least agree that the Uniform Commercial Code is statutory law? Can we at least agree to that? And then give me a second to acknowledge some of the members. Shout out to the one who said LT is your teacher's blueprint. Take notes, like and subscribe. The one, oh my God, that song. He loves that song. Self-made in the building. Says facts. The brother, Miss Doris Myers, the lovely Miss Doris Myers, the matriarch of the Untouchable Empire, the lovely Miss Doris Myers. Hit the like button and subscribe to the channel, please, ladies and gentlemen. So, the rise of the sovereign citizen movement. The sovereign citizen ideology took shape in the 70s and 80s. Y'all hear with that? In the 70s and 80s. I went back to the earliest versions of sovereign citizens. It was in the late 1969s. And I think in 1969, and I started researching the origins up to present day. So when people come online with their private bonded promissory note and their registered discharge and bond, posting on TikTok, talking about this, what I'm about to file, and I comment, you know, they've been filing those for 40, 50 years. Nothing's never happened. This is why. But, you know, influenced by tax protesters and those seeking ways to circumvent government authority. And I agree. I don't really necessarily like the government all up in my stuff. I get it. Trust me. The government all up in my stuff. Yeah, I get it. Nobody does. That's not even an argument there. I think we all, businesses alike, I think we all agreement. Nobody wants government encroachment. Nobody does. We can all agree to that. That's a common ground. It has evolved over the years, especially with the advent of the internet, which has given rise to self-taught legal experts sharing advice on how to avoid taxes, evade fines, and challenge court rulings. You know, the thing that frustrates me about the sovereign citizen movement is that a lot of them are very persistent, very determined, won't take no for an answer, will stand and defend what they call their rights. And those are the traits that are absolutely needed when you step into these courts, but doing things the right and correct way. The traits that they display are the traits that I wish a lot of people displayed in their lives. Right there, that determination, that drive, that not taking no for an answer, not falling victim to the BS answer that the finance company may give them. If it was just channeled with the proper arguments, the laws would have had to change in our favor, because we got everybody, they're all on the same page, but they're all on the same page with nonsense. Can you imagine if they were all on the same page with properly structured legal arguments? Oh my gosh, it would be woo!
You're rocking with the best.
So, you know, I just wish that it was just channeled in a different direction. Now, while sovereign citizens often claim that they are peaceful and merely exercising their rights, the movement has also attracted controversy due to encounters with law enforcement in the court system. Many sovereign citizens challenge traffic tickets, refuse to pay taxes, or even refuse to acknowledge the legitimacy of court proceedings, leading to arrests or legal conflicts. Some have even gone as far as filing fake liens against judges or government officials, which has led them to be classified as part of the paper terrorism movement in certain legal contexts. Controversy and legal disputes. Sovereign citizens' refusal to recognize government authority often leads to legal confrontations, with members using a variety of tactics to challenge laws, taxes, and court rulings. This has led to frequent litigation. Sovereign citizens file unconventional legal documents in court, which are often dismissed as frivolous, which I've covered extensively. Courtroom defiance. They often use pseudo-legal arguments like refusing to acknowledge a court's jurisdiction by claiming they're not subject to admiralty law. Violent encounters. The most sovereign citizens are peaceful. A small subset has engaged in violence encounters with law enforcement. For entrepreneurs and business leaders, understanding how sovereign citizens think can be instructive. While their rejection of government authority is extreme, the underlying theme of questioning authority, resisting control, and carving out personal freedoms resonate with many people who strive for autonomy in business and life. Word magic and the power of language and law. One of the most fascinating aspects of this discussion is the concept of word magic. According to sovereign citizens, legal language is intentionally crafted to deceive the public. They believe that the government used specific terms and phrases that seem benign but carry hidden legal meanings that bind individuals into contracts unknowingly. For example, they argue like the terms like person in a legal document don't refer to a human being, but to a corporate entity created by the state. By manipulating language, sovereign citizens believe that governments impose a system of control that most people are even aware of. But here's the problem. You think that the government uses word salad? You don't understand corporate finance. And even with your mortgages or your autos or your credit card disputes, I hear a lot of people always want to talk about exposing a system. We're talking about exposing the system. You are talking about a $16 trillion a day industry on the secondary market. What system do you think you're going to topple? And I will say this again, and I'm going to go on the record of my personal opinion about this. Securitization is a necessary evil. I know you don't like it from your lens, being sued, you're trying to defend yourself, but I tell you this, without securitization, there would be nothing for you to defend because you wouldn't have had the property to defend unless you brought it outright. And it's not just financing. Securitization runs the world. The whole world operates off it. The whole world operates off it. Every music production company, Apple, Google, all the health insurance company, the chemicals, science, they all engage in it. It's one of those things where it's bigger than you and I. This is how the world operates. So when you're talking about shutting down securitization, what you're really saying is, I'm going to shut down the world. That's what you're saying. Now, are you equipped to shut down the world? Because you will feel the negative effects from that same world that you will be trying to shut down. Because obviously you have not gone off the grid like sovereign citizens back in the day. You're not building your own homes. You're not getting your own pipeline. You're not having your own land. You're not living in one big community. The women are not homeschooling the kids. You're not growing your own food. You're not creating your own electrical grids. You're not living off the grid. You are more dependent on the system than what you want to admit. You, me, we are all a part of the same system. There's no separate system for you just because you believe a certain way. You are a part of the same system. They're not tapping into your Sesta Key account, or when you fill out your application, you're going to sign the same application. You're going to sign the same promissory note, and you're going to be entitled to make the same payments just as any other person who didn't believe like you. There's no secret system. It's the same big system. And when you're talking about anything financing, you are talking about the corporate world. There is no such thing as a consumer transaction. Uh-oh, I'm about to ruffle some feathers now. Uh-oh, a lot of belief systems. Hold on. What the hell did you say?
You're rocking with. You're rocking with.
There is no such thing as a consumer transaction. Oh, I know. Well, we got TILA. We got FDCPA. We got the CFPB. They established that. They established those things for us. Why can't it be a consumer transaction? The CFPB, the FDCPA, TILA was one of the biggest smoke screens ever perpetuated on the American population. They were only established to keep you blinded and keep you in a box. FDCPA claims were expressly created for unintelligent and unsophisticated consumers. That's what the courts have consistently said. So by you filing the FDCPA claim, you are reaffirming that stereotype. Number two, when you're filing the FDCPA claims, but you're online saying you have a beneficial ownership in the securitized proceeds, you're the third-party investor, right? I hear all of y'all, a lot of you say that, not all. A lot of you believe that. Well, if that is true, why are you foregoing the claims that which investors and third-party beneficiaries were raised against the finance company for a measly $1,000 per violation statute? When the investors settle out with the finance companies, they're settling in the millions. So you mean to tell me that you can come online and tell all your audience that everybody's a third-party beneficiary? We got an equitable interest in the proceeds of securitization, but yet you're going to file an FDCPA claim? Why don't you file an investor claim? If you're really a third, because you're online telling people this. So I'm expecting you to practice what you preach. So if you're telling them this, why you then start talking about FDCPA? There's no third-party beneficiary protections there. Why don't you bring an investor-like lawsuit since you're a third-party beneficiary? It's because they don't believe the stuff that they're telling you to do. The FDCPA is nothing more than a mind trickery statute to keep you from raising the low-level $1,000 per violation claims instead of taking them straight to the box and winning off the merits. The FDCPA only means two things. I'm being sued. That means you're not aggressive, you're not the plaintiff, and you're not suing them while you're current. And the other, they violated my rights while attempting to collect the debt from me. That means you're on the defensive. The FDCPA teaches you to stay on the defensive. Wait till you get sued and try to catch them in a mistake. And these teachers, all they tell you is to bring FDCPA claims, FDCPA, 15 USC, 15 USC, 1692, 15 USC, 1581, 15 USC, 1540, all that. What they not telling you is to step into the corporate world. What they not telling you is to bring claims just like you were a class action lawsuit. What they not telling you is to bring the lawsuit while you current, because you have more leverage, more credibility. The judge is going to be more inclined to entertain your equitable claims. And when you win off the merits, you get not just a little $1,000 in measly violations, but you end up with a piece of your American pie back into your hands, in which you can now legally transfer that asset into trust. What they not teaching you is how to snatch your asset out that securitization trust and put it back in your family's name. That's what they not teaching you.
You're rocking with the best.
What do you really win on an FDCPA claim? What are you really winning? What do you really, what do you really win? Oh, I don't have to pay this credit card debt anymore. Oh, I don't have to be accountable for this debt anymore. Oh, they violated my statutes. I got awarded $3,000. Oh, part of the settlement, they waived the remaining balance. That's a win. You really call that a win? What happened to own nothing but control everything? What happened to creating generational wealth? What happened to being sovereign and owning our assets outright, putting them in a trust so nobody can come encroach on them? What happened to that? Why settle for that? If you're going to step into play the game, why aren't you playing the game to get the asset back in your name? I mean, think about it. Let's talk in context of a mortgage. Say you win that. You get an asset back in your name free and clear, and you never have to worry about anybody coming to take it. And now you actually have something to pass down. You can leverage it if you need to. You almost guaranteed is going to get access to credit with that asset. You can use other people's money to make you money. Using other people's monies through your receivables that you're creating and making other people pay back your debt while you collect the profit at the same time. Isn't that what the corporations do? I mean, think about it. Don't corporations get into hundreds of millions of dollars of debt just to turn around and make billions off it? Ain't that what they do? Don't they always seem to be making hundreds of millions of dollars a month? Do you think they make that money by loaning you their money? Millionaires and billionaires don't even use their own money. They get into debt. Because debt is what makes you rich. Debt is what gives you the opportunity to snatch the property back out of their securitized trust. Debt is what opens the door for you to have opportunities. But the mindset that they want you to be in is to get into consumer debt. They don't want you to take it to the next level. Consumer debt. Like, let's take the gloves off for a second, because I really get tired of these people that always want to tell people to run away from debt get out of debt, get out of debt. No, you need to get into the much debt as you can. But the caveat to that is when you get into debt, just kind of ask yourself, why are you getting into debt? Are you getting into debt to make money off the debt? To leverage the debt? I mean, that's something to think about. I mean, let's be 100% honest here. You don't get your financing unless the corporation goes into debt themselves. Uh-oh. You don't get financing unless the corporation goes into debt themselves. So in a mortgage, when you are getting a mortgage, you best believe that corporation went into debt. You best believe they went into debt. You don't get your mortgage unless they go into debt. You know what that means? Somebody put the money up for you. Oh, somebody put the money up for you. The investors put the money up for you, y'all. Once again, that's a matter of common knowledge. You were already in debt before you even realized, before you even signed that promissory note. You were already in debt. See, that may sound crazy, but like I told you, I'm looking at this from the system, how they see it. Only thing that they needed is to assume the corporate debt. This is why we were used to be called consumers of corporate debt. Then they sliced it down to consumers of debt. Now you're just consumers. But make no, no, I'm not going to sit here and jerk your chain here. You're any mortgage, auto, credit card, any type of quote unquote consumer transaction, it's nothing more than a corporate transaction. 3 transactions took place before, in which you are a part of, before you even realized you was a part of the transaction. 3 transactions of which are important to us already took place. The last transaction is us. And as I tell my Supreme Elite Team group, you don't even get to understanding your transaction until you fully understand the intricacies of the other 3 transactions that took place before you even filled out the application. And this is more the reason why you should.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
And so let's not kid ourselves here now. The corporations know what they do, and they do a great job at it. Hell, you don't even get to even starting to take a dip into your mortgage till you get about year 10. About year 10. If people en masse will understand what I teach in my Supreme Elite Team University, if the corporations knew that people en masse understood that, they would have to change the game. They wouldn't be able to survive in this manner. Everything that you think your transaction went has nowhere near close to the reality of what actually went down. Hell, You're not even paying a mortgage anymore. And this is why I can't stand the consumer mindset. I can't stand that label because it actually keeps you in a box with your arguments. It keeps you secluded in a box. It keeps you so much in a box that the reality is sitting right in our faces, but we have not developed the mindset and the discernment to even acknowledge that it's there. Because we're moving off what we believe is true instead of evaluating the facts from an objective standpoint. I have no personal feelings about it. It is what it is. And I'd rather deal with what is and navigate, because I'm going to tell you this from experience, not another online teacher talking. I'm talking from someone who's been there and done that already. You are not going to step into that corporate world and think you're going to navigate successfully unless you know it from how they see it. Your consumer contract is just that on your end. And yes, I've recorded this and I documented this, and this is in my Set You University. The 5 lenses of the contract. The 5 lenses. And as long as you're still thinking like a consumer, you won't even acknowledge the other 4. The way the courts see the transaction, the way the regulators see the transaction, the way the investors see the transaction, the way the corporations view the transaction. And all 4 of them don't see it the way we see it. And this is the disconnect. That's the biggest disconnect. Do you actually think the corporations give 2 rats' asses about the total of payments, the APR, and the finance amount? Do you really think they give a rat's ass about that? Oh my God. They could care less. That's not what they're viewing. They don't view that. They don't care about that. They don't care about, they know they're never going to get all that up out of you. And this is why understanding how corporate structures work. Now listen, this is not for the weak of heart. Anybody that's trying to apply a more simplistic form of how it works, put cotton swabs in your ears and don't listen, because this is one of the most highly complex sectors in this world, the secondary market. They take accounting, negotiable instruments, securities, trust law, and merge it all, subsurge each other within each other. So you think they're talking about this. Oh, no, they mean that. Oh, it means that. Oh, no, to them, it means that. This is why your debt validation letters are getting nowhere, because you are asking them for things that you know you can't prove. And it's only one standard that's applied to your claims, whether the corporations are applying it or anyone else. It's only one standard that determines whether your claims are sufficient or not. And that is the legal standard, meaning the way you letting the judge know what happened, they're not viewing it from your lens. They are applying the legal standard to your claims. Does this claim pass the court sufficiency test? based on all the facts and circumstances, taken in as a whole, and on court rules, procedure, case law precedent, and the procedural history of this court. Does this claim pass the court's legal standard? What we say went down doesn't mean nothing. It's the legal standard that's being applied to it, which matters. Why do you think they always move for Rule 12b-6 motions? Why do you think they're never going to address exactly what you said? Because top litigators in the world knows this. Court is 98% about the rules and procedure, and the other 2% are about the facts of the case. And when you let them sue you first, then here is the deficit that you're putting yourself in. Number one, you don't choose the venue. Number two, they're coming in with a contract that you've already confessed judgment on. Whenever they have the clause that we can repossess if you don't pay, default, events of default, acceleration, in court, that's called a confessed judgment. So when they take you to court and you agree to pay and you didn't pay, the question remains to the judge is, why should I not uphold the centuries-long doctrine of contract law? Well, it's not a doctrine, but uphold the centuries-long binding contract law provisions of court. And one of the things that you cannot do as a defendant is say fraud. Because when you bring a fraud claim, you better be the plaintiff. Do not bring a fraud claim as a defendant. And when you bring up the word fraud, the judges is going to get the micro lens to view your complaint, and they're going to scan it, and all 5 elements has to be fully satisfied. Not 4 out of the 5, not 3 out of the 5, all 5 elements: the who, what, when, where, how. And all of those elements that you cite must pass the court's heightened pleading standard. Because when you bring the word fraud into it, your pleading standard just went through the roof. Now you got to be 1,000% spot on with your fraud claim. And I've seen many online gurus teach about fraud, and they've never talked about the 5 elements to prove it. They think fraud is based on how they feel they've been mistreated. And why is this important again? Because it all cycles back to what? The consumer mindset. The sovereign citizen's perspective on legal terminology: person versus natural person. Sovereign citizens often feel that legal documents refer to a person as a legal fiction rather than a living human being. Contract and consent. They argue that by signing legal documents without fully understanding their meanings, individuals unknowingly consent to government authority. Well, here's the thing about it. This is why it's not fair. Court is not meant to be fair. The corporate world is not fair. It is the most diabolical, blood, guts, and gore sector of this country. It is a dog eat dog, and them lawyers are not going to have compassion on you. See, y'all think that, oh, they're supposed to do the right, that's that consumer mindset level of thinking. Well, they're supposed to do the right thing. They didn't do this. Well, it's not right. It doesn't matter about what's right or not. It matters about what is and what can you prove, and can you prove it by passing the court's sufficiency test. It's the only thing that matters. Your feelings don't matter. How you feel about the situation don't matter. They don't care. And suing the judge because you did not pass the court sufficiency test does not get you anywhere. You'll never win. Stop throwing hissy fits and suing the judge because they ruled against you. You're not going to win. And don't come on TikTok talk about you violated your rights. Oh, it was a void judgment. No, it wasn't. Unless a judge voided it themselves. And that is what this sovereign space, they think that when they believe a judge is void, it's void. When there's a law that they don't agree with, now that law is unconstitutional. And then they throw Madison versus Murdoch in it to justify it. Do you think they would ever pass a case law and statutes that would give us the right to void or declare any law unconstitutional? Do you think that's what Madison versus Murdoch really meant? I mean, come on, you gotta be kidding me. Let's say that was true for the sake of conversation. All I had to do was just disagree with a law. And in my eyes, that law is unconstitutional. The same thing that they do today. Every law that they don't agree with is unconstitutional now. Refusing a contract. Many sovereign citizens attempt to opt out of this system by refusing to sign legal documents by writing no contract on them. I haven't seen any of y'all go off the grid yet. Let's just be honest. You need this same system that you complain about. You need this. You need someone to cook your foods at the restaurant you want to go to. You need someone to create the cars, make the cars that you want to buy. You need someone to design the clothes you like to wear. You need someone to build the water parks that you want to take your kids to in the summertime at the pool. You need someone to clean the pools that you want to swim in. You need someone to deliver your food when you get on Uber. Let's stop acting like you don't need this system, like you don't benefit from this system. You only hear these arguments when it gets down to being financially accountable for the debts that we contracted for. You don't hear this when life is good. You don't hear these arguments when everything is up. And you damn sure don't hear these arguments when they're current. Besides me, what other person have you seen in this space bring a lawsuit while they were still current and not in default?
You're rocking with the best.
When everything is FDCPA, when you're being sued, telling you're not paying, make them prove it. See, with the Supreme Elite Team University, we don't make them prove they own the debt. We prove by preponderance of evidence that they don't own the debt. We don't send them a debt validation letter asking them to prove accounting. We send them documents telling them this is how your internal accounting operates. It's a difference. That's a difference. That's what the Set U does. And since we don't have a complex over here, we know that there's behind the scenes stuff that goes on every day in the corporate world that affects us. And we know that we don't live in that world. I mean, we operate from that world, but we wasn't like born into that world. Like we haven't spent time on Wall Street. And by me knowing this, I said, no matter how much you may be interpreting these laws and these transactions and their internal operations, you've been batting 1,000 on it so much. Don't ever get so big over your head that you think you actually know it all to the point where you won't seek wise counsel. Here comes, and with that mindset, here comes the ex-SEC attorney. Here comes the ex, I ain't gonna say the bank, examiner. Here comes the Fannie Mae, Ginnie Mae IT specialist that processes the payments to the investors. Here's the Series 7 securities broker. Here's the CPA for 25 years. Here's the network with the professionals that not only takes our understanding and interpretation to the next level, but we got an inside sneak peek on their operations, which is never disclosed publicly. And we never use that information to bury them because I understand business. I did go to college, business management, applied science at IT Tech when it was up. I did. I didn't finish it, but I was there for a good while. I made the honor roll in the quarter. I got the Pell Grant from Obama back in 2011. I got the Pell Grant. Y'all know what I'm talking about for those with school. Y'all know what the Pell Grant was. And I understood the nature of business. This is never personal with them. How can it be personal? How can you take it as a personal attack on you when you're just one account amongst 40 or 50,000 that's in any given pool? They're making 78 to 100 something $1 million a month. Do you think they're worried about you? You think they're worried about me? Do you think Credit Acceptance is worried about me? They don't give a damn. It was a smart business move for them to settle. It was a high risk, low reward for them to fight. And you think that the remaining balance was like almost 50,000 remaining? Do you actually think that that wasn't already paid? Remember, my account was amongst a pool. They wiped the principal balance away as part of the settlement, but do you think that everybody else in the pool ain't make up for my payments? That's why it's a pool. Everybody's helping each other pay their debts. Just why your interest rates go through the roof. Why? You know, they got to make some money too. Hell, you fund your own default. You know, the first 90 days when you in default, they don't say nothing to you. Or whatever there. If autos may be like 60 days. You do, man, yeah, man. Whew, the truth gets far more sinister. Woo-wee. Everybody is paying everybody's default. They still got money in reserves from pools for like 2 or 3 years ago that they just transferred to the next one. You really think that they not gonna have money set aside in case you default? I know where the money goes. I pinpoints their accounts where the money's sitting at right now. Like the actual names of them. Like where they're at right now in this moment. But what did they tell you when you in default? Did they send you a letter say, hey, your next 90 days have been paid. You might want to get back on track after it's over. No, they send you past due, balance due, severely. We're gonna sell your house. We're gonna take your vehicle. Why are they doing that? If they really know, like what I'm telling you behind the scenes, they're doing something totally different. Why are they telling you that? Because it goes back to my same points. They use trust law to siphon our property from us. They use accounting to hide the true economics of the transaction from us. And they use contract law to stick you with the debt.
You're rocking with the best.
That's the only reason why they're still playing that angle with you. Because you agreed that they could. Hell, we all agreed that they could. But if you really think that the total amount of payments that you got to make, I'm talking about mortgage, autos, credit cards is just revolving. But if you really think, well, you got a $400,000 loan, you got to pay $950,000 back. You got a $25,000 card, you got to pay $70,000 back. If you really, oh my God. Woo-wee. If you really think that balance is legit, I'll just say that you're not, then something they're not doing out there online, these gurus. But why would I expect any more? Why would I expect any more from these gurus? Why would I expect any more from them when they don't even know it themselves? Like, ask yourself this question. Let's just be honest. Just be honest. Just be honest for 2 seconds. Let's all be honest with each other. Why do you actually think these gurus can accurately break down to y'all their internal operations, the stuff that's not disclosed publicly? Do you think they would even know where to start? Then why can I? And it's not because I made some glorious appearance. It's not because I'm smarter than the rest. It's not because I'm more intelligent. None of that even matters. Because even the smartest, sophisticated investors still get hoodwinked, still don't fully understand what's going on these people's internal accounting balance sheets and stuff. They still don't get it. The only reason why is because, like I said, with the Supreme Elite Team University, we actually have professionals that used to work deep on the other side who we are in cahoots with. So me getting that information is nothing but a text or a phone call away. This is more the reason why.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
That's just what it is. I always said I needed to network, but they found me. They found me. They found the Supreme Elite Team. They came to us. They came to this group. And I'm not saying the attorney per se came, but a person that came to our group has connections with all these people. And by his great relationship with them, I was able to benefit from the connects. Now I got access to them. This is why part of the discovery, I had about 4 pages of gas, but then from, my connections, they gave me another 7 pages to incorporate. This is the same level of discovery that the SEC attorney would request when he's bringing a suit. And no, 98% of those extra discovery requests, I didn't even know exist. It's that deep in the well. It's that deep in the well. I wouldn't have thought to ask for those. It's that deep in the well. It's past the lender. It's deep into the well. The things that they would rather settle with you before giving that information to you. Meaning it's the things that they would rather settle with you before they give you that information.
According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
So, once again, I don't listen. You can make all the decisions that you want to make, and we about to move on to the next because we pretty much know about the soccer citizens at this point. We can go on to the next, but I do want to tell you this. The way these people play these dirty games, I would be remiss to tell you that you don't have to get dirtier than them. This system does not operate the way we think they operate. They operate from the way they've been operating. It's new and groundbreaking to us. It's just another day at the office for them. And when they settle, their structures are designed that they don't take any losses. Once you sign that agreement with them, mortgage or auto, the so-called lender, they could care less if you ever pay it back or not. That's the whole thing. They could care less. The only reason why they foreclose or repossess is because the investors told them to. Oh my God.
You're rocking with the best.
Oh my God.
You're rocking with the best.
It's because they told them to. That's it. And they were like, nah, just forgive this person. Nah, we'll be all right. You'll be getting a letter talking about, hey, you have no more obligation. That's it. Now, my Alberty legal beagles over there on TikTok.
So I'm sorry, I didn't know you had a motion. But I was going to ask for your input before we finish this. I'm just trying to deal with his issues on child support.
Okay.
He seems to be under a misapprehension that this is a contractual relationship, and it's not. It's a statutory relationship.
Okay.
Front of the court is following their statutory authority to collect child support on behalf of the child. So that's what's necessary, and they will automatically follow their rules in the.
Hold on, did he thought it was a what contract? Remember we were doing about they think everything's a contract.
Your input before we finish this. I'm just trying to deal with his issues on check. What papers you filled out? I don't have them. Okay. So I'm sorry, I didn't know you had a motion. But I was going to ask your input before.
You should have been getting some paper. I did all this stuff.
Well, that motion would be automatically denied because we do not revoke parental rights in a family law case. That has to be done in a neglect case.
In a what case?
An abuse neglect case.
So why did they have me filling out the papers?
I have no idea. I don't know what papers you filled out. I don't have them. Okay. So I'm sorry, I didn't know you had a motion. But I was going to ask for your input before we finish this. I'm just trying to deal with his issues on child support.
Okay.
He seems to be under a misapprehension that this is a contractual relationship, and it's not. It's a statutory relationship.
Okay.
Uh-oh. Statutory relationship. Not everything's not in it. Oh, contract. Uh-huh. For you, child support legal beagles.
Front of the court is following their statutory authority to collect child support on behalf of the child. So that's what's necessary, and they will automatically follow their rules and the statutes in doing so. The court tells them when or if child support should be reviewed. And again, I've informed you, sir, Mr. Miller, you have the right to ask for a child support review if that's what you're asking for. But yeah, if you're not paying support, they're going to be hauling you in to explain why you're not paying.
Well, I also was sick.
Okay, that's fine too. But again, you're going to have to explain why the payments weren't being made and why you owe.
Payments wasn't being made because I was under
You're under a misapprehension, not an understanding. So that one I can tell you you're wrong on. So the best you can do is ask for an accounting to make sure that all money is accounted for and all payments are accounted for. Now, do you want this to the front of the court for a child support review?
I want this case closed. And
It's not going to be closed, and it's not going to be dismissed.
I want to dumber down the ticket.
So even though they were receiving the full monthly obligations, it's okay for them to.
If you owe, they're going to haul you in to find out why you're not paying the amount.
And we wasn't receiving I wasn't receiving a full amount.
Well, ma'am, part of this, you're not going to receive the full amount. You're on state aid. The reason that this case was brought, it was brought by the state of Michigan because of your state aid. When you're on state aid, the state mandates the child support be paid in accordance with the law, and then they confiscate portions of that child support to reimburse the state for what they're paying on behalf of the child.
Is this Admiralty Maritime Court law?
No, it's not Admiralty Maritime Court law. This is
Admiralty Maritime Court
for what they're paying on behalf of the child.
Is this Admiralty Maritime Court law?
For what they're paying.
Now, we went over quite a few. Went over the document, then we went over the statute. Remember we went over those things. Now the question remains. Now, let's see how this. Everybody that was on my TikTok, that Admiralty video I made, and everybody saying nope, wrong, nope. Okay, well let's see it live. Let's see how it plays out.
Paying on behalf of the child.
Is this Admiralty Maritime Court law?
No, it's not Admiralty Maritime Court law. This is the state of Michigan. We are not in the middle of an ocean.
Because
we're not in the middle of the ocean. So now I want y'all to go back. It's the first video that's pinned, and look at the comments where everybody's saying I was wrong. Now you see why they talk with beliefs and feelings with no factual stats, factual case law that's applicable to today's time to back it up. Told you, it's all beliefs and feelings. It's never about factual evidence. And this is why none of them could show that they actually won on this argument either, because I made a challenge to every single 70 of the 90 comments. None of them came back. So you already know how that goes.
Flag in the back got a gold fringe on it.
Yeah, don't.
Because the flag in the back got a gold fringe on it.
Yeah, don't even do that bull. That's a bunch of bull.
You have
it is United. I don't know what you're receiving, ma'am, but this case was brought by the prosecutor's office on behalf of DHHS because of state aid involvement.
Oh, I don't receive anything. I haven't since.
Okay, well then once you stop that, then you should be receiving the full amount, but the state will confiscate part of anything that's still owed to them from any child support collected. Right now, I'm not sure how much the arrearage is. Obviously, there is an arrearage. So, no, the UCC, the Uniform Commercial Code, does not apply to this court, sir. This is a family law court.
That you don't have on the gown either, so
you're right. That's because I'm an appointed judicial official, not an elected judicial official.
Which is legal and lawful. I want to hear you legal beagles. No, they can do that. Yes. It's like magistrate judges. Yes. By each state statutory law, they can do it. I want to hear it. If you don't like it, go to your state legislator and tell them to change the laws more favorable to your beliefs. But don't argue me down, because I didn't make the law. Like, I don't make the rules. I just follow protocol. But all the ones want to fight. I don't see them getting titles to their assets back free and clear and debt wiped away. I don't see them popping up with that. So who's really right here? Of course I am.
So yes, I have a full authority. I am sworn in. I am an attorney prior to being this in my judicial capacity. So yeah, I have full authority. And the authority is given to me by statute as well. So I follow the statutes, the laws that I have to follow.
So this statutes and codes, it's not actually law.
It's not code, it's law. It's statutes. It's
the statute, that's the law. Prime example, you got like in the federal statutes, like this, you got Title 26. Well, I'm not going to use that example because everybody want to argue that, but whatever.
So you got, let's say, Title 24. You'll have those statutes there. And then you'll have Title 24 CFR, Code of Federal Regulations. The statute is evidence of the law that was, the statutes is evidence of what Congress passed into law. The regulations are there as this is how the law is going to be administered and regulated. But the actual statute, like the USC, Title 12 USC, that's actually what Congress passed into law. The regulations is how the law is being carried out. It's like the rules and regulations that govern the law. That's all it is. See, it's always these deep, esoteric, eye on the pyramid type meanings that they want to apply to normal, simple, basic things.
It's the laws of the state of Michigan.
Statutes and codes.
Statutes, no codes.
It's a statute.
The Uniform Commercial Code does not apply to this court.
Ouch.
All right. Do you want the child support review or not, sir?
I do want the child support review.
Okay. In that case, I will send this for a child support review. Ms. Cry, any questions, ma'am?
Nope.
All righty. I will look at your motion when I do receive it, ma'am. I don't know when it's scheduled for, but it was not scheduled for this morning. Okay.
That's what I thought this was for. Okay.
Yeah, no problem. This was for his motion.
Oh.
All right. All right. Have a good morning to both of you. I'll send this to the front of the court for child support review. Have your most recent current pay stub available. Both of you.
I'm under the impression that there's a warrant.
Yeah, you do have a warrant.
I didn't notice a warrant, but that wouldn't come up on this file for this motion. That would be a separate issue. You might want to call the warrant department if you believe there's a warrant, because you can deal with that.
I wasn't properly served on.
Again, the court has no paperwork concerning any of your warrant. I don't have her paperwork for her motion. I can't advise on things that I don't have before me because I need to look at them before I find out if they're properly served or not. Call the warrant office and find out what's going on if you believe there's a warrant. This is the first I've heard of it.
This is the motion for support.
This is the motion for support, and that's why I'm sending it to the front of the court for child support review.
And this all is under the same thing. Why they issued the warrant?
No, that's separate issues. This is ongoing support. Your warrant is about back support, if there is one.
Damn, bro. Yeah, you got to get yourself in order.
Who's participating by phone?
On and for the record, I'm Houston LaShawn DeYoung, more beneficiary. I'm here in my proper person.
What's your first name?
Oh yeah, see the thing about it. See the thing about it, TikTok. See y'all thought that over here, I'm just gonna tell you, you're wrong. Now I'm gonna let the judge tell you you're wrong too over here. If you don't want to listen to me, I will let the judge tell you.
My first name is LaShawn DeYoung. My surname is Houston.
All right.
I'm here in my proper person, my own right, and I've haven't reached the age of majority. I'm a Moore Aboriginal, America's Aboriginal, Illinois national.
Is
but
Kimberly
not a citizen of the United States?
So he says he's not a citizen of the United States. Once again, you can call yourself Inspector Gadget for all I care. None of that matters. It's how you are treated. This is why these gurus are leading peoples up shit's creek. Because there was a Supreme Court case, and y'all know the case I'm talking about, that made slaves property. Fred Dred Scott case. The African American, well, I guess they would, where the slaves were considered property and not really human beings or citizens, which would bring them the protections under the Constitution. Well, to address that issue, The Dred Scott case was overturned by the 14th Amendment.
You're rocking with the best.
Without the 14th Amendment, slaves and their descendants would not be considered citizens, will still be considered property or not humans. So, if anyone that says they're not a United States citizen, then that means they are reaffirming their status as just nothing but mere property. And this is what happens when you adopt belief systems without doing the full research of the origins into why they believe this way. If you were born or naturalized in the United States or born on one of their territories like Puerto Rico, the Virgin Islands, Guam, you are a United States citizen regardless if you want to be one or not. Because if you don't want to be a United States citizen, you need to stop all this virtue signaling and go be about that life and expatriate yourself from the government and go move out the country if you don't want to be a United States citizen. This is not Morocco. It's the United States of America. If you don't want to be here, go expatriate. Oh, before you do that, the IRS is going to make you pay all your taxes before. But anyways, that's a separate matter because we know most of them ain't filed taxes in 25 years. So they're going to have a hard time leaving on that issue alone. But yes, the 14th Amendment overturned the Dred Scott case. Now, I know what some of you are going to say. He don't know what he's talking about because once again, what he's saying is going against what I was studying for the last 50 years. So here we go. So I want you to, YouTube, I want you to see it for yourself. TikTok, you can read along. H.R. 127, joint resolution proposing an amendment to the Constitution of the United States. 14th Amendment, May 29th, 1866. And the 1857 Supreme Court decided Dred Scott versus Sanford, a historic case in which Scott, an enslaved African-American, sued for his freedom. The court ruled that enslaved individuals and their descendants were not citizens and couldn't sue in federal courts. It affirmed slaveholders' rights in Western territories, heightening tensions that sparked the Civil War. During Reconstruction, Congress protected African Americans' rights through legislations and constitutional amendments. The 14th Amendment nullified the Dred Scott decision by constitutionally guaranteeing African Americans citizenships. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. And you can catch this at the National Artifacts and Museums, the official documents down in Washington, D.C. Now, any other myths that I need to debunk today? Oh, I'm going deep into the Sovereign Citizen Playbook today, boy. Yeah, we going deep into that today. Everything that they believe, I guarantee you, I can invalidate it with case law and authoritative evidence to support it. Not my opinions.
Is Kimberly available?
Not a citizen of the United States.
Is Kimberly
Or
available?
the United States for the District of Columbia. Age majority. I'm a more Aboriginal, America's Aboriginal, Illinois national.
Now, after we just read that, TikTok and YouTube saw that. Now listen to what he's about to say and keep in mind what we just read.
Is
but
Kimberly
not a citizen of the United States?
Is
my own right, and having reached the age of majority. I'm a more Aboriginal, America's Aboriginal, Illinois national.
Is
but
Kimberly
not a citizen of the United States?
Is Kimberly available?
Not a citizen of the United States.
Is Kimberly
Or
available?
the United States for the District of Columbia. Houston Kimberly Denise is deceased. I am the sole beneficiary and real party of interest in this matter.
All right, just a moment. Before the court this morning is the landlord's complaint to recover possession of property. The person entitled to possession of the property is the plaintiff due to a sheriff's deed of redemption.
I object.
A sheriff's deed. Ma'am, please don't interrupt. I'm reading.
Not a ma'am, excuse me, I'm a male.
Okay.
I object and
Sir.
deny.
Sir, please don't interrupt. I'm reading from paragraph.
You're trying to put something on the record that has not been proven.
I'm going to have to
I
mute
object and
you
deny.
if you continue to interrupt the court.
If you mute me, then you are violating my right.
Told you. So remember, this goes out the playbook. When they don't get what they want the first time, they start becoming belligerent. And then whenever they take actions against them to gain control and order, now their rights are being violated. Same playbook.
You haven't even proven you have jurisdiction over this matter.
Okay, let me end this jurisdiction crap for once and for all. This how courts operate today in America. I don't care about your 1857 case law. I don't care about your 1970, 60 way of arguing jurisdiction. I don't care about your 1906 court cases that you read from your sovereign citizen packet. I don't care about that. Today, if you want to challenge jurisdiction, you're going to file a motion challenging it. Not a notice, not an affidavit, not an affidavit of non-corporate existence, none of that. You're going to file a motion that's accordance with the court rules of procedure or whatever jurisdiction that you're in. If you're in state court rules and procedure. And then you're going to file that with the court. And then attached at the bottom of it, it's not going to be notice to principal and notice to agent. Notice the agent is notice to principal. What it's going to be is a certificate of service. See, that's how we do things in the real world. We're not on Jupiter right now. We're on planet Earth. And then you're going to attest that you serve the other party a copy of the motion. The court is going to give the other side a deadline to have their response to your jurisdiction. And I can best believe that they're going to scalp you from head to toe on the statutes and the authority of the state, which the judge is going to agree with because it's a matter of common knowledge. And then once they respond, then the judge is going to have a ruling. And once the judge rules that they have jurisdiction, the case is going to proceed. That's how it goes from a procedural standpoint.
You haven't proven you have
judges don't prove things.
Subject matter jurisdiction.
Judges don't prove things. Parties prove
things.
She said judges don't prove things. Parties prove things. Judges don't prove the jurisdiction. The parties do. Goes back to what I said. You're going to file your challenge with the court, your motion. The other side, you're going to serve a copy on the other side. The other side is going to respond, and then the judge is going to make their ruling from there. That's how it goes, and the judge just affirmed it. But no, keep following these private administrative law, private trust people. Keep following them.
Judges don't prove things.
Subject matter jurisdiction.
Judges don't prove things. Parties prove
things.
That's correct.
No, the court has to prove that it has subject matter jurisdiction and personal jurisdiction over the subject matter.
You are now being muted.
You don't have to prove that.
Officer Denham. Thank you. As I was indicating, the complaint to recover possession of property received by the court on October 25th of this year and signed by plaintiff's attorney, who was present on the record, indicates in paragraph 5F that the plaintiff has a right to possession of the property because of a sheriff's deed and the redemption period expired on September 8th, 2022. Is that correct, counsel?
That is, Judge, and the court will note on the complaint, we actually attached a copy of the sheriff's deed too. I believe it's the next document under the actual complaint.
Yes. So can you give me the history of the tenancy?
Yeah, can I do it informally, Judge, without having my client sworn, or does Your Honor want it to come from my client directly?
Anything that he says is impermissible and it's prejudicial. Statements of counsel in argument or in brief are insufficient for granting of a summary judgment or dismissal.
Sir, you are procedurally misinterpreting everything that you read. This is the counsel for his plaintiff. You dingbat.
Your objection is over.
Matter. He is a third party in this.
He's not a third party. He is the counsel for the people who wants to put you out because you didn't pay. Most likely the house was sold or you didn't pay your rent. Now you want to bring this pseudo-legal, judicial, political stuff in court as a stall tactic. He has every right to speak on behalf of his client. He's not a third party. He's a lawyer.
This matter, I want my objection on the record.
Your objection is on the record. Your objection is on the record, and your objection is overruled. You're again being muted.
Is a third party.
I need her muted or him muted. Thank you.
Anything that is said scandalous and prejudicial, and
I am removing Mr. Houston from the hearing because of continual interjections, interrupting the court's proceedings. I will later consider whether to find him in contempt of court.
Judge, I removed his chance ability to unmute himself if you want to.
Thank you. That'll be fine.
Yeah, he can't unmute himself anymore.
All right. Okay, counsel, what I was asking for is basically.
Now, is this how you really want to learn how to argue law? Because I think that's what they teach people, to be belligerent, be loud, have no courtroom decorum. Do you think I was able to get these professionals that I'm in cahoot with if I had that attitude? You see the attitude that they take towards lawyers? You see the mindset that they get y'all to believe, and it's only leads you deeper in a ditch, way farther than you really want to be. But don't listen to me, just see it play out in real time.
When the tenant took possession and the historical facts as to the sheriff's deed and the redemption period.
Right, Judge. So the way, and I can have my client sworn in to identify for the court the specific
sure.
The actual scenario is the homeowner, which I believe are the Houstons, were residing there, and they had a mortgage. The mortgage fell into to default, and the property was placed. For foreclosure, and it went to a sheriff's sale. And my client was a successful.
It went into default on the mortgage or on the tax bill?
On the mortgage, Judge.
Okay, and who held the mortgage?
Genesis it's Genesis Credit Union, as reflected in the sheriff's deed.
All right.
And my client, when it was put up for public auction, my client actually was the highest bidder, concluded that transaction through Oakland County, and then the sheriff's deed on the mortgage sale was issued and then ultimately recorded after the 6-month period of time. So we're here today. No, there's been no participation, and the court will note, I mean, you heard a little bit this morning on the record, which is why you muted the defendant. There were some.
Okay, so what happened was they didn't pay a mortgage. Well, he didn't, whoever, they didn't pay their mortgage. They sold the house. So it looks like they're in a non-judicial state. They sold the house. The lawyers representing the person who brought the house. So since they brought the house now, they're the owner of the house. Now they got to go to eviction court to put them out. Normally, this can happen when they buy the house. The owner will show up and be like, hey, do you want to rent this from me? I truly believe that if that opportunity presented itself and you had no other lines of defense or you don't know who I am, I think you should rent the house for them. and until you get yourself situated. But this is normally what happens. They sell the house, the new owner comes by. This person probably filed about 5,000 documents, probably taped up his house with notices and fee schedules and trespassing that never gets honored. Like your fee schedules never, you really think they're scared of your frivolous fee schedules with 1-UCC-1308 at the bottom of it? You really think they're scared of your frivolous $5 trillion fee schedules? They don't care. You're not scaring no one. All they're going to do is wipe their ass with it. That's as much value as it has. Your fee schedules has as much value as a used piece of toilet paper.
Documents filed in this matter by Mr. Houston and
all sovereign citizen, all sovereign citizen, the shit that you can go on Scribd, all the shit that you can go on Scribd, they go right on Scribd, remix the words, come back online and sell it. That's all it is. A whole bunch of babbling.
Why you muted the defendant, there were some documents filed in this matter by Mr. Houston, and if the court has read them, that's great. But it's pretty much it's the kind of things that he's saying, nobody has jurisdiction over him. You can't take away the property and whatever. Bottom line is he had a mortgage, went into default. We were the successful bidder at the sheriff's sale. 6-month period of redemption has passed. No payments were made, and we want to take possession.
Okay. So, ladies and gentlemen, let me just be honest with you here. Once none of those ramblings that you're filing in court is working, at some point, when do you shift into a plan B and plan C? Well, you got 6 months to redeem. If it's too much, then you can't. Listen, let's say you don't know anybody else that can help you. You know you can still sell your house, even though you're in default. You know you can sell your house. There's corporations that will buy your house from you. And I know I got a partner that knows people that they buy homes. They do investment. They will actually buy your house from you, give you about $10,000 location, and they'll order the U-Haul trucks for you. Hey, if you got to move into an apartment, start over, but it's better than this. Would you think life is going to be 100% peaches and creams? You got to start over? I had to start over. I had to build it back up from the ground up. I done had it all, lost it all, had it, lost it, got it back again. That's life. But this is worse than that. Because not only are you about to be put out the house, you have nothing to fall back on. At least sell the house, recoup a little bit, and even if you just pay the bank off, you can always start back over again. Everybody acts like it's either going to be the Big Bang Theory or nothing at all. I mean, golly.
Okay, thank you. Mr. Houston, I have a question for you, and that is whether within the 6-month redemption period, you did anything to redeem the property.
Nope.
Officer Denham, we need Mr. Houston unmuted.
I've entered onto the record in that first case that third party was just talking about, proof that mortgage has been discharged by Genesis Credit Union.
Okay. Now, this is where it gets tricky. Unless you satisfy the lien yourself, if someone comes and buys the home, the banks or the credit union, you got a credit union at that, even worse, because credit unions don't sell securities on the secondary market. So you really got to hit them from a balance sheet standpoint. Like you really got to hit them hard. So when that takes place, it's either they're going to, when they buy the home, they're going to issue you a satisfaction of lien. Now, the difference is when they send you a satisfaction of lien, because that's probably what he's talking about, the escrow is going to determine whether you got the satisfaction lien yourself or the other party paid it, the title company. They're going to give you the information to the party that paid it. So the discharge that he's talking about is the fact that they sent him a satisfaction of lien. But the satisfaction of lien was because the person bid was the successful bidder. And I guarantee you the escrow documents are going to substantiate that.
And it was discharged before October. It was actually discharged in July.
What do you mean by discharged?
It was discharged. The mortgage is paid in full.
No, see, there you go. Once again, because they use this word discharge online. Discharge means, yes, there was an obligation to pay, but you're no longer obligated to perform under the contract. Discharge is a term that is synonymous with bankruptcy court. Discharge doesn't mean paid in full. Stop using that term unless you're in bankruptcy. Golly.
Discharged. And it was entered into the record of the first case.
I have several
Before the redemption
filings.
period was even over.
Did you file
Before
that?
the redemption period was over. I didn't file it over. I filed it in the first case. It's still evidence in that first case that he referenced.
One moment. Attorney Hirschfuss, am I saying it right? Hirschfuss.
I still object to him even speaking in this matter. He's a third party intervener.
No, that only applies when you don't show up to court, but your lawyer shows up to court on your behalf. Something like an emergency went down the day before. Your lawyer will come in and make a special appearance on your behalf. It doesn't mean you show up and say, I'm here, but I'm making a special appearance. It doesn't apply in that context.
Going to speak. That's my decision.
Everything that he
Please
said
don't
is
interrupt.
scandalous and
Okay, you're muted again.
prejudicial.
Sir, did you obtain a copy of the original file?
No. Let me just indicate for the court what the discharge he speaks of.
Yes.
The Genesis discharged the mortgage because we paid it off.
You're rocking with the best.
Nah, new culture, you don't know how the procedure works. You don't know how it goes. You just be talking. You don't be having lawyers verify you in real time, judges verify you in real time. You don't know what you're talking about. Hell nah. That's not how it goes.
Let me just indicate for the court what the discharge he speaks of.
Yes.
The Genesis discharged the mortgage because we paid it off. So there is by the way, it's not a discharge, it's called a satisfaction of mortgage.
Nah,
you're rocking with the best.
Nah. You still don't know what you're talking about, new culture. Who cares if you've been right all day? You still don't know what you're talking about. I know.
Yes.
And it's dated on May the 24th, 2022, and recorded in Oakland County Register of Deeds office on June 2nd, 2022.
All right. I have not yet adjourned it to continue, sir, but go ahead. You were going to read the discharge?
It says satisfaction of mortgage. Know all men by these presents that Genesis Credit Union of Auburn Hills does hereby certify that a certain mortgage dated May 3rd, 2018, made and executed by LaShawn Leon Houston and Kimberly B. Houston, husband and wife, to Genesis Credit Union and recorded in the Register of Deeds office for the County of Oakland, Michigan. The lot and everything, the tax parcel and all that is fully paid, satisfied, and hereby discharged as of today's date, 5/24/2022.
Oh my gosh, you cannot be this dumb. It's because they paid it. It's their home now. Like, what is so hard for you to understand that? Oh, you think that they just paid the debt for you. I told you, they always think everything is theirs. Like, everything is just theirs.
Thank you. And that is the same document that the attorney for the owner has read into the record, sir. And so he's indicated that it's his client, Mr. or Shepherd Properties LLC, who satisfied that mortgage by paying it off. In what amount, sir?
A
In
deed
what
or
amount,
bond.
mister?
Judge,
A deed or bond found with the debtor is presumed to be paid. He has no mortgage with his name on it. He has no proof that he's an adverse party or that he's a bona fide party to this matter. He has no proof that he gave any consideration to the sheriff and the.
Oh, just stop it. Just fucking stop it. He bought the house at a sheriff's sale. This is what people like him think like. They think that just because you wasn't the original party to the mortgage, he's basically saying, thank you for paying my mortgage. I'll have my home. I'm about to have my home back for now. Thank you. Thank you for paying my mortgage, though. I appreciate you paying my mortgage. Thank you. It doesn't work like that in real life. Oh my gosh, he cannot be. That's where that sovereign citizen bug. You get bit by that bug. I'm telling you.
Sheriff gave any consideration to me in order to sell my private property in the first place, which is actually owned by a trust, and the Oakland County Register of Deeds and the Oakland County Treasurer has been notice of that property has been transferred into trust.
Okay, what it means by the property being transferred into trust is what they come online and teach you. They think that you can take your deed of trust, a copy, or your mortgage, transfer it into your trust, while it still has a lien on it, knowing that you ain't fully paid off yet, whether it's your auto too. And since that it's now in your trust, that no third party can collect now because the trust now owns the property. What they forgot to tell y'all when they was selling these packages on y'all how to do it, it's called piercing the corporate veil. Meaning, you cannot transfer any property into a trust that you do not have free and clear title to, because the trust ownership would not be recognized in court. Now, you follow my teachings and you get title to your property free and clear. See, now you can transfer that into a trust because now it has no liens on it. So now the trust will now be the owner free and clear, meaning nobody can come take that because the trust has the priority interest in it. But I guarantee they didn't tell y'all when you go do that, you got to pay like the transfer fee. See, that's when it's legit. Not this transferred into the trust while you still got 20 years of payments left on the mortgage. That one stays off the foreclosure.
As of 2021. So at what point in time did the sheriff give consideration to me or my trust for my property in order to sell it in the first place?
Sir, you would have to consult an attorney about that process.
I don't need to
However,
speak to an attorney. I'm here my own proper person in my own right.
And that's the biggest problems. And 98% of these pro se sui juris legal beagles, they don't want to seek professional counsel. That's the problem right there.
I'm suing you this. I don't need no attorney. He's no guardian over me. I'm not a minor.
All right.
There you go. The 1666 Cestui Que Vie Act. I was minor, I was lost, but now I'm found. Yeah, a British law that never had any applicability in the United States. The 1666 Cestui Que Vie Act was a British law. You know what that's considered over here? Foreign law. And foreign law has no force or effect over United States law. But continue with your 1666 Cestui Que Vie Act.
thank you.
Now, furthermore,
You're going to be muted now in order for me to address
Can I have
some
your
of
name?
what you.
Can I have your name, please?
My name should be on the screen. Or you're on the phone.
I don't have the screen open. I'm on a telephone. Can I have your name, please?
Yes, when I'm ready to
The
give
name
it
can't
to
speak.
you. When I'm ready to give it to you. Please mute Mr. Houston so that I can address his issues. All right, so we will adjourn this until, or continue it on January 18th, 2023 in the afternoon. The docket time will be stated on the notice of hearing that is mailed to the parties and council.
Very good, Judge.
And the reason for the continuance is for the plaintiff to present the satisfaction and the recorded deed. And Mr. Houston, my name is Judge Sheila Miller Martin. All right, we can unmute Mr. Houston before closing for today.
Could you repeat that, please? Repeat that, please. You said Sheila Miller Martin?
That's correct.
Have you taken an oath to uphold the Constitution?
Told you. When everything else in the playbook runs out, now he's about to start trying to attack and sue the judge. I told you. I told you. Whenever they ask for an oath of office, it's always at the point when none of their ramblings has been recognized by the judge. So in his mind, he thinks the judge is violating his rights. But for people who understands law, understands court proceedings, everything has been by the book.
Judge.
Sir, I don't answer those types of questions. I'm not a witness or a party.
Have you taken an oath? That is a question for you, Judge.
Goodbye.
All you have to do is say you've taken an oath.
Peninsula Place versus Trellis Lane.
Lawrence Craftsman for the plaintiff, Your Honor.
All right. I got that out the way. All right. Are you more legal beagles?
86771.
Thank you. And Mr. Michaud, your name for the record, sir.
I am the beneficiary of the.
There you go. I told you. There you go. Already. The beneficiary of what? Of what? And y'all be thinking I just be saying this stuff. I told you, TikTok, YouTube, I told you, it's this court case and they're all doing and saying the same thing that they come online and teach and tell you how to buy, and none of it works. Now you're getting real life action.
Frank Anthony Michaud, Junior Estate, making a special appearance, not general. And I appoint you as my trustee for the record.
There you go. A bunch of babbling.
And Mr. Michaud, were you able to hear Mr. Sullivan indicate that he is standing by as shadow counsel?
I heard him.
Okay. This case is scheduled this morning for PCC. How are we proceeding?
I'm here challenging the jurisdiction for the record, ma'am.
Another one, different court case, same sovereign citizen rhetoric. What does he come and do? I'm here on your initial PCC visit, but it's not even the right time to bring it up. And the first thing you want to do is challenge jurisdiction. Do you think they ever want to do it according to the court rules of procedure? Number one, it's not the right time. Number two, it has to be put in a motion, not your notices, affidavits, a motion. And then you have to serve the other party again. And then the judge sets a hearing on it. The parties argue their positions, and then the judge makes a ruling. And then they continue with the proceedings because it's not getting thrown out.
Judge, the people are prepared to set a preliminary exam in regards to this matter.
And you notice how they just clearly ignored him. I told you, they just steamroll right over top of you. They don't even pay no mind.
Mr. Michaud, you're able to raise that at the exam date.
What did I say? It was too premature, too early for him to raise it right now. What did I say? It was too early. But nah, I don't know. I don't know court rules of procedure and timing. Oh no.
The allegations that these events occurred at Detroit Metro Airport, which is located in the city of Romulus. Are you ready to have the exam scheduled, sir?
Got your tongue?
I'm not here to
Mr.
have an
Michaud?
exam. Still trying to wonder why we moving forward with even having an exam, especially after not having by the due process even having a probable cause hearing.
This is exactly where it's at. That's exactly what you're there for. Like you just got locked up. You got locked up at an airport. You didn't get locked up in the seas. You didn't get locked up in the ocean. You got locked up at an airport. And this is the closest court that's in the jurisdiction of the airport. Why do people want to fit a square peg in a round hole so bad? Godly.
It's not a problem. It's probable cause conference, sir, at which time the parties will indicate if they're ready to proceed to exam, if there's a plea or a waiver or some other resolution. So at this time, the assisting prosecuting attorney has requested that an exam be set. Are you prepared to have the exam scheduled?
No, as me here challenging the jurisdiction for the record, I want to put on the record that once the jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That's Mello versus U.S. for the record.
Mello versus U.S. for the record. Once again, they think that they recite that ancient old case and that they could that just bypass the rules. So they think that means you just go into court and challenge jurisdiction. Right. Of course it does. Okay. Right.
And that's Mello versus U.S. for the record.
And sir, what is it that you find, what is your allegation regarding the jurisdiction?
Well, what is the jurisdiction that the court is operating up under, ma'am? The Sixth Amendment
The court has already,
the right
Mr. Michaud, the court has already indicated that the allegation is that this event occurred at Detroit Metro Airport, which is located in the city of Romulus. Are you indicating that this event that brings us here to court did not occur in the city of Romulus?
That's your jurisdiction right there. That's your jurisdiction right there.
Well, I would like to know what jurisdiction is this court operating up under, so that.
Oh, let me guess. He wants to know whether it's common law or admiralty or maritime jurisdiction. Let me take a wild guess.
I can properly defend myself and represent myself for the record.
Okay. And this is the part what makes them disingenuous. They all know it's a criminal case. They all know it's a criminal jurisdiction. They all know he's brought under the criminal statute. They all know. But what they'll do is say, I need to know what jurisdiction this is so I can properly defend myself. It wouldn't matter if Moses slapped you in the face with the hand of God. You still wouldn't be able to know how to adequately defend yourself with your sovereign citizen babbling.
So the Sixth Amendment grants me the right to know the nature and causes of these actions. So I would like to know, what jurisdiction are you operating up under?
Sir, what the file indicates is that there's an offense dated February 23rd, 2021. And again, that the case happened at Detroit Metro Airport, which is located in the city of Romulus. That is a jurisdiction within this court's parameters. So that being the case, would you like to have an exam scheduled?
Told you. Go steamroll right over top of it. This is, there you go, right over top of it.
No, I would like to have, under what jurisdiction are you proceeding with, so I can properly defend myself?
You don't even know how to defend yourself, even if you do. But y'all, this is the delay and stall tactics that they teach people to do. So he's going to keep saying it, and y'all do know when they this is what takes the cookie here. They will ask the judge, is this admiralty or maritime jurisdiction? And the judge says neither. And then they'll proceed to tell the judge that the judge is wrong. Well, if you were already right, why did you ask the judge? Oh, God.
On what?
I've said it three times already, Mr. Michaud. If you have indications or information that the event as alleged did not occur in the city of Romulus, I'll hear it at the exam date.
That's not a jurisdiction. The jurisdiction has to either be one or two. Is this common law or admiralty jurisdiction, or for the record?
What did I just say? What did I just say? That's what they all do. When a judge gives them an answer, they tell the judge is wrong and say, no, it's either this or this. You ask the judge gives you the legal answer, then you say, no, judge, you're wrong. And then you wonder why these people don't win. Is if there's any reason why you need to doubt why these people don't win, no need no more. And trust me, you sovereign citizen legal beagles, we will deliver you with.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume, what stories in the fine lines.
You gave me a location,
Michelle?
a jurisdiction.
Mr. Michelle,
For the record, you gave me a location. It has to either be one or two.
that the event as alleged did not occur in the city of Romulus, I'll hear it at the exam date.
That's not a jurisdiction. The jurisdiction has to either be one or two. Is this common law or admiralty jurisdiction, or is for the record? You gave me a location, a jurisdiction.
They go to semantics games. Oh, they love to play the semantics game.
Mr. Michelle, respectfully, what we'll do this morning is either schedule an exam, adjourn the PCC, or waive the exam. One of those three things.
Well, the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. That's Higgins versus Levine. So I still would like to know under what jurisdictions.
How much you want to bet that these case laws that he's citing are not the case laws that are in the state that he's in right now? Because one thing about this community, they'll love to be in Arizona and cite a Maryland case, which has no legal binding effect. They'll love to be in Texas and cite a California case. They'll love to be in Philly and cite a South Carolina case. You know, they never cite cases that are within their jurisdiction that are authoritative and are persuasive and have some procedural precedent history around it. Oh, they don't never understand the procedural posture of the jurisdictions that they operate. Oh no, that's too much like right for them.
So that I can properly defend myself, not the location. I need to know what jurisdiction is this court operating up under.
Mr. Michelle.
It wouldn't be a violation of your oath of office to tell me.
Oh, look at that good script. Tell them, oh, Judge, it won't violate your oath of office to tell me. Look at that straight from the script. That's a script.
Mr. Michaud, for probable cause conference, and I'm sure that you've heard this before, we're doing one of a few things. We are scheduling the exam, we're adjourning the PCC, or we're waiving the exam. How are we proceeding?
We can't proceed until jurisdiction is proven on a record so that I can fully have an understanding of what's going on. I still don't understand what is going on without jurisdiction being proven on the record.
What don't you understand, sir?
I don't understand what jurisdiction are you operating up under. I have the right to know. And are you denying me my right to know what jurisdiction are you operating up under? Because it is your constitutional oath to let me know what jurisdiction it is that you are operating up under. And you still have not yet given me my right.
This is the 34th District Court, Mr. Michaud.
That's not a jurisdiction.
It is a jurisdiction, you dingbat. It is a jurisdiction. She gets her jurisdiction by the 10th Amendment. Then she gets her further jurisdiction by the state constitution and then the legislator. It took place in the 34th District where the airport was located. You was arrested at the airport. This is the closest court to the jurisdiction has been established. Matter of fact, jurisdiction has been established before you was even born. Like, move on.
That's not a constitutional jurisdiction, ma'am. Is this?
You idiot. Did you not hear what I just said? Didn't I say the 10th Amendment and then the state constitution? Do you not hear what I just said?
Common law or amnesty? Is this criminal or civil?
It's a criminal case, sir.
Okay. If it's
a criminal case, where it's alleged that you were a felon in possession of a firearm and that you carried a concealed weapon.
This is why he's fighting so hard.
Makes sense. Trying to duck that federal case, because you know the ATF coming. Possession of firearm by a convicted felon. Oh, you going straight to the feds for that. And you was at an airport too. The feds will be picking this case up. The ATF will be the U.S. Marshals will be there and take them to the nearest federal holding detention center. That's where you're on your way to. And I think you know that. And this is why you're fighting. I told you behind all these arguments is always some underlying reason why they're really doing it. Yeah, I understand you.
And then count 3, felony firearm. Those are the allegations. I've given you the 3 counts in this matter. I've given you the date of the offense, and I've given you the location of the offense. We can do one of 3 things this morning, sir. We can adjourn the PCC, we can schedule the exam, or you may waive the exam. Which would you like to do this morning?
I want to have my rights given to me, and my right is to have the jurisdiction of the court. That's just for the record.
I've already indicated to you, sir, what the court is.
Is this common law or amity? That's the only jurisdictions that we can, that I know of. You still haven't acknowledged neither one. And
so notice that what we've been going over this whole live stream, how we started off the live stream covering amity. Don't it just hit different now when you see people come and make these arguments now? Like they know they just walking themselves off a cliff, just like everybody that was in my comment on TikTok talk about I was wrong on the amity thing. Doesn't it just feel New Culture Empire? Doesn't it just feel so vindicated? Don't you feel vindicated for me?
I still don't understand what's going on. Until you acknowledge one or the other, we still haven't got jurisdiction on the record.
Mr. Michaud, do you intend to represent yourself in this matter going forward?
I would like to know jurisdiction so I can properly proceed to present myself properly. I can't properly present myself or defend myself without knowing what jurisdiction that you're operating upon. And you said it was criminal, so if it's criminal, then for a crime to exist, there must be an injured party, a corpus delicti. There can be no sanction imposed or penalty imposed on one because of this constitutional right. So if this is a criminal, where is the injured party? Who have I injured? I have the right to face my accuser.
No, see, once again, you still think this is 1844. We're in the 2020s. The injured party is the state, the people, and the citizens as a whole. This is why the state prosecutor, on behalf of the state, you broke a law that was statute. You broke a law, which is evidenced by the statute. The law is what was passed by the General Assembly or the legislator per their state constitution, granting them authority. They got further federal authority by the 10th Amendment, because anything that's not expressly listed in the Constitution is reserved to the states as the state of California, or to the people as the people of New York. The state legislators pass laws to protect the safety and well-being of each state citizens or residents in their state. So when you break the laws in a state, you have violated the laws of that state, and it's the citizens as a whole who the state is representing, because it is implied that you're living in the state, you're going to follow all the state laws. So you violated the state law, they're prosecuting you for it. It is as simple as that. There's no deep esoteric meaning. There's no gold fringe that matters. There's no secret amity jurisdiction where they're trying to contract with you. None of that crap matters.
Face the one who is bringing these allegations against me, ma'am.
Mr. Michaud, if you wish to be able to defend yourself and hear witnesses against you, the court is happy to schedule the exam. Is that what you're asking this morning?
No, as I appointed you as my trustee, I demand that you dismiss these actions for no corpus delicti, no proper jurisdiction.
I'm so tired of that damn corpus delicti. Just shut up.
No proper crime. Injured party.
Mr. Muhammad, your response to Mr. Michaud's request that this case be dismissed.
Judge, the people's position is we would object to dismissing this case on the basis of lack of jurisdiction. As you mentioned earlier, this crime did occur in the county of Wayne, and thus we do have jurisdiction.
And that's as simple as it gets.
There is no jurisdiction without an injured party, for the record. So I would like to have to face the injured party, for the record.
And Judge, my response is, then we should
Yes, sir.
then I believe we should set this for a preliminary exam.
I object to that, ma'am. You cannot proceed without jurisdiction being provided on the record. And you being my trustee, for the record, ma'am, you have to dismiss this case as I
See, this is another thing that I don't get with these people. They think they could just unilaterally appoint titles of nobility to themselves. They could appoint offices to the judge. Like and for these people that always want to cite trust law, they probably never talked to a wills and estate attorney, a trust attorney, which I have. What you don't do is just unilaterally appoint someone a trustee. There has to be an appointment and an acceptance of the office. So nobody's accepting your frivolous trustee offices. The judge will have to accept that office. If the judge does not accept that office, there's no legitimate trustee there. But I don't know what I'm talking about. Once again, just continue to follow the script.
I demand, for the record.
Your request to have this matter dismissed is denied. Mr. Michaud, my question will remain the same. Would you wish the court to schedule an exam? Do you wish to waive that exam and have your case bound over to Third Circuit Court, Frank Murphy Hall of Justice? Or do you wish to adjourn the PCC? Those are your options this morning, sir. They're going to stay the same.
I would like for jurisdiction to be provided for the record, and that if not, I demand dismissal, for the record.
This case will not be dismissed, sir. Would you like the exam scheduled? Would you like to waive the exam, or would you like to adjourn the PCC?
Again, jurisdiction, for the record. You cannot proceed without, when once jurisdiction is challenged, again, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That is.
Well, the problem with that is there's no evidence that this court does not have jurisdiction. Just because you're reading right now from a sovereign citizen script that you got sent through the mail, or some type of law library, or some type of legal beagle that told you, say this in court and you're going to walk, it doesn't change the facts.
Mello versus U.S.
Mr. Michaud, this is the last time that I will say this. I've indicated to you that this court is the 34th District Court, that this case is criminal in nature, and the allegations that it occurred at Detroit Metro Airport, which is located in the city of Romulus. If there's something you wish to present, you may do so at the exam. You may present your motions at the exam date. So do you want an exam? Would you like the case to be waived? Or would you like to adjourn the PCC to confer with Mr. Sullivan?
No, I would like for this case to just be dismissed because the lack of providing proper jurisdiction would make it seem like there's some secret jurisdiction being held against me without me knowing.
What do we say from the document we read earlier? What we read earlier. What did we say? It's always, admiralty always has to be some secret jurisdiction. It just can't be cut and dry as civil or criminal. Notice how admiralty, from what we read from the official statutes that navigates the high seas and the waters and the oceans and the crimes and paths and contracts that's related to shipping goods. Notice how that's the legal definition of admiralty, but the way they apply it has to be the secret jurisdiction that they have to use against you. Typical sovereign citizen mentality, playbook, rhetoric, theories, decorum, behavior. He got the whole outfit on.
And I don't consent to any jurisdiction that you have presented. I reserve all my rights, for the record.
Understood. And that being the case, Mr. Sullivan, is there anything you'd like to add, sir?
Judge, I don't know what to say. I'm not sure that that I still have authority to represent Mr. Michaud. I will say that Mr. Michaud has made his arguments, a couple times, and I think that the arguments have been, or the motions have been denied. And I've explained to him that those motions, his arguments are preserved on the record, and that he maintains the ability to appeal any denial of his motion to dismiss. He would be able to appeal that first at the circuit court level and then up to the Court of Appeals. So I've done my best to advise him of his rights to continue making that argument. I will also, I think the court may already be aware that Mr. Michaud is not in custody on this case. He's in custody on a contempt of court that Judge Oakley sentenced him to back at the end of January. So I don't know that there is, unlike clients that are in custody, a reason to expedite the setting of the preliminary exam. So I really, I want to defer to Mr. Michaud's stated interest, what it is that he wants to do with this case. I've given him advice, and I don't know what I can do beyond that.
Of course, you was giving him the legal rules, procedures, but sovereign citizens like him, they don't ever want to hear that. They want you to make their frivolous claims for them. And this is why they want to represent themselves, because any lawyer that would represent those frivolous claims that they may lose their license. They may get referred to the bar, and they damn sure is getting sanctioned and getting hit with a fine. The only way he's getting away with this garbage because he's pro se. But no licensed attorney will ever sit in court and make a fool out of themselves by raising these frivolous sovereign citizen arguments.
Again, I don't want to create any conflict in my representation.
And Mr. Sullivan, the court wasn't asking you to. The court has heard Mr. Michaud's arguments. The record has been made. Your statements have been preserved, Mr. Michaud. And at this time, the court can do one of two things. We can schedule you for an exam next week. We have space available next Wednesday, the 28th. We can adjourn this matter for another PCC next Wednesday morning at 8:30, or you may waive your exam. Your response is one of those three things, please, sir.
Well, my response, I want to ask you a question. Are you honoring your oath to the Constitution today?
Well,
yes, sir.
Isn't that the second one who's asked that question when he gets to the end and realize they're not budging? Isn't that the second? We 2 for 2 today, ain't we? Ain't we 2 for 2? That's the second one who asked that question when the judge not budging. See, TikTok, this is what they're not going to show you when they talk about these arguments on TikTok. New Coach Empire YouTube, y'all already hit, or y'all should be hit. But TikTok, we trying to get them into the fold. This is what they're not going to show you. Real live cases where people have been sitting for damn near 30 minutes trying to raise those same claims and it's going nowhere. See, this is what they're not showing you. See, they're not going to show you case law, live cases where people have made these arguments and won. And I don't want to hear, they're not going to show it. All this stuff is Zoom. All this is public. I don't want to hear it. Go over 200 some cases of people making these arguments dating back to the early 80s. Early 80s. And none of them has won. So I ain't hear that, they're not going to show it. See, they're going to deny you in public, but honor it in private. They get the crap out of here with that garbage.
Hey, and I accept your oath, and upon you honor your oath.
Then Mr. Michaud, no. I've answered your question. I've now given you your options multiple times. The court has other cases. Are we scheduling an exam for next Wednesday? Are you waiving your right to have the exam? Or would you like another PCC next Wednesday morning at 8:30 so you have time to consider your options and how you will proceed in this case?
I demand a dismissal for lack of jurisdiction for the record.
Your request is denied, sir. The record's preserved. If you wish to appeal that decision, you may do so in writing properly filed. Again, exam, waiver, or adjourn PCC.
Dismissal for the record.
You know what she said? Put it in writing. Remember I said?
I demand that you dismiss this for not, you cannot move once jurisdiction is challenged, the court cannot proceed for the record, ma'am.
And Judge, for the record, the people would like to request a preliminary exam. There will be no plea offer. We did already have a probable cause conference in this case, so we are prepared to move forward, Judge, just for the record.
Marianne, is there space next Wednesday?
And once again, they're now offering, they're moving right along. So y'all tell you TikTok gurus when they see jurisdiction, you're going to get in court, you're going to challenge it. They got to stop it right then and there and establish it. Y'all say, we heard it live on the new coaches channel. They not stopping it. That ain't gonna work. I need y'all to tell them, I heard it with my own ears. YouTube, I saw it with my own eyes. You can't just, that ain't working. So anybody that's teaching that, advocating for that, it means two things. They just trying to get some dollars out of you, or they don't even have a clue of what they're talking about themselves as the teacher.
Say afternoon.
Yes, Judge, at 2:30.
Jack, court cannot proceed without jurisdiction for the record.
I know. You said it 5,000 times. I know.
Jurisdiction has not been provided for the record, so that I may.
Mr. Michaud, the court has responded and provided the appropriate information to you. The exam will be scheduled for next Wednesday, February 28, 2024, 2:30 p.m. in person here in courtroom number 1. If there is a motion that you want the court to consider, the court will take it up as a preliminary part of the exam.
That is the proper time to raise it. You're not going to get anywhere with it, but that is, see, once again, court is about time. Yeah, I wish that there was a simplified method of explaining court, but what the reality gets to it is, you got your court rules, you got the procedure, you got the case law, you got the procedural history of the court, you got the procedural posture of any particular case, you got the rules of evidence, you got the pleadings and motions, the stylings of them, you got the rules on how to present your evidence, then you got the rules of evidence on how to present that evidence. Your exhibits has to pass the evidence. Business records, exemption to the hearsay rule. Then it has pre-trial motions and pleadings, summary judgments, that they got their own rules for that. And then most of all, you got the nuances of court in which one gains understanding of through experience.
Anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Well, if that's nothing else for the people, we get to the flashback of this. Woo! Right here. And y'all need to, come on.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as plaintiff's exhibit.
Anise Battle appearance, especially not generally.
Not specially, not just, there you go. I told you, it's all over the world. This is how they come into court, y'all. So TikTok, don't be all scared, all in their chat, like, because first, y'all was commenting like, yeah. Well, not y'all. I ain't gonna say y'all here, but I know people out there, they be like, yeah, that's how it goes. Now, those who stuck around and watched this live, I guarantee they're gonna be in the chat, but they won't be typing no more. You'll be quiet as hell now. Because they're gonna be thinking like, well, hold on. You're going to be analyzing your teacher more now. See, at least what I do is I get the students to start thinking more. Like, hold on. I get you to start challenging. And you may not like it, but you know, I be asking the same questions that y'all be thinking you just don't want to say.
Thank you. All right, we're here for the continuation of the hearing today. Battle when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you.
Let's get to it.
All right. Mr. Fantira, I believe that we're in the middle of your, well, actually it was Ms. Battles. Direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to terms in writing?
Oh yes, with that gun case, it's most definitely going federal. It's most definitely going federal. I'm actually look up his case. The ATF always picks those up. 65% of federal inmates are probation violations and possession of firearm by a convicted felon. They passed the act back in 2013 where normally gun charges would be state and the feds pick up gun charges left and right. Feds pick up gun charges left and right. Trust me, I think I know what I'm talking about on that one. For those of you who know me.
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Sir, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease?
And that's as simple as it gets. So normally, y'all, this is a situation where this person's back against the wall. Obviously, you can see there's kids, hear kids in the background, probably about $3,000-4,000 behind on rent. And when you're in a desperate situation like this, you're pretty much going to throw whatever you can at the wall and hope it sticks. And instead of being in that position, in that mindset, you will be better served.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying, unlike me.
So her right to rescind the contract is based on common law, YouTube. Common law.
I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England. Your
No,
Honor,
I stated it under common law
Everyone, please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am, and that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not.
that sounds
Uh-oh.
tenant acts.
from the 12th century.
Uh-oh. Uh-oh. Did y'all hear what just took place?
Law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
Hey, did they still tell y'all to pursue that too? They tell y'all to put that on your documents still today? Don't tell me they tell y'all to put those Magna Carta on there.
Your
No,
Honor,
I stated it under common law
Everyone, please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am, and that's a part of the problem with sovereign citizens. They think they know the law when they don't.
Landlord-tenant acts.
They know the law when they not, we're not under common law anymore, ma'am, and that's a part of the problem with sovereign citizens. They think they know the law when they don't.
Well, what do you got to say about that? It's coming from the judge. It's the problem with sovereign citizens. They think they know the law, but they don't. They have no clue of the law. It's all pseudo legal package pushing documents, templates, ebooks. Join my class. I'm going to help you get out your debt. We're going to wait for them to sue you. Then we're going to challenge the debt. It's a 90-day thing. But I'm going to give you the documents to go file. Why? They're going to teach you about court rules and procedure. They're going to teach you about timing. They're going to teach you about motions and pleadings. They're going to teach you how to structure your motion. They're going to teach you what arguments to raise. Are they going to teach you how to research authoritative case law, binding case law? Are they going to teach you about the nuances of court and only which one can gain through experience? Are they going to give you the whole thing, or are they going to give you a magic bullet of a document and that's going to get you out the debt that you really don't want to pay anyway? You tell me.
That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them. And
Okay. One of the things that you know when you're dealing with a sovereign citizen is call them a sovereign citizen and wait for their response, because nobody calls a sovereign citizen just because how they look. It's the words that you use, the lingo, the frivolous cases and laws and doctrines that they cite. But when you call someone a sovereign citizen, this is how they're going to respond. There's no such thing as a sovereign citizen. You can't be a sovereign and a citizen. A sovereign citizen is an oxymoron. That was from the early 1990s scripts that they was telling their groups, because they were first coming in saying they were sovereign citizens. But when they realized they started getting more pushback from the courts, they said, when you're called sovereign citizen, you respond in one of the three ways. So people who I've called that today, that's always been one of their responses, not knowing, they don't even realize that their response is coming from the script that they don't even know the origins of the same script that they're using as a response to being called a sovereign citizen.
that I am not.
Well, whatever you're using as your basis is still not correct. It is not.
It is. It's still under MTL and it's under the Landlord-Tenant Act.
Overruled.
my objection is overruled, Your Honor.
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because
rescinded?
that's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated.
My ruling, I'm not arguing with you anymore about it.
Right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to asking these questions. I will continue.
No, ma'am. You haven't stated any law or basis. The judge and the lawyer is correct. And I'm being objective. I'm the procedure of court in the letter of the law. You have stated frivolous arguments already. And some of the things that you stated has been the things that they've been stated for the past 40 years. This is why she assumed you're a sovereign citizen. Because everything you said, they said it 40 years ago. And that's the problem with these sovereign citizens today. They hate when I tell them that everything that just came out of your mouth was nothing more than a 40-year-old variation of the passed down script. They hate to think that it's a script. They want to think that they did authoritative, groundbreaking, revolutionary research when they know they haven't.
Okay. Did you write me a notice to quit filing this action?
That's the wrong term. It's not a notice. Never mind. I'm gonna let y'all hear it.
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
Exactly.
No, a notice to quit.
Oh my God.
No.
Right. Do you have proof of delivery or service of any notice to quit?
What do you mean proof of delivery of service? It's always going to be at the bottom of the goddamn document titled certificate of service. Oh my God.
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. I object. Miss.
She thought she ate up MCL 657, and it's getting to the point, y'all, you can't even believe them when they do cite statutes because all of them misinterpret them.
Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment.
She about to G-checker. She about to G-check on that statue.
You studied a statute that I actually need to look at. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
Yeah.
The judge is reading the statute.
Have you read that statute?
Anytime when the judge asks you, have you read that statute? It means that what the statute says is totally opposite in the way you want to argue it. Just as like all these right to travel legal beagles and all those same 5 cases that 500,000 people just spear on their documents, all those cases says the opposite of what they believe it says. And you notice that even with the right to travel, they will cite cases that took place before cars were even on the damn road, before cars were a big thing. And the Supreme Court has been very clear on the driving issue. Driving is not regulated by the federal government. Driving is not regulated by the feds. It's regulated by the states per the 10th Amendment. And if it wasn't true, then every DMV would be invalid. There would be no DMV. If state statutes were illegal, the Supreme Courts would be striking them down. But why does the Supreme Court hear cases involving state interpretation of state law every day? Why is the DMV still up and running? Huh? If it was just so true what they said. See, their own real lives contradicts their beliefs. Their own real lives. But they will ignore their real lives, and go to this fairy tale land.
Yes, I had read it when I first did this.
Means no, you never did.
It uses the term demand for possession.
Okay, everybody please stop typing. It says, a demand for possession or payment shall be in writing addressed to the person in possession and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Ma'am, it's called a certificate of service. It's at the bottom of every document. I hereby certify on this day I caused by United States Postal Service an e-file to serve. It's a simple certificate of service that's at the bottom of the page.
Nope. Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need on a demand for possession, a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, need on a demand for possession, a certificate of service. And that's what's at the bottom of the page.
Man.
You're rocking with the best. You're rocking with the best.
I mean, I ain't been wrong all day. I have not been wrong all day.
If she's looking for a proof of service, meaning...
Oh, she's definitely overwhelmed. She's definitely overwhelmed. And I mean, I'm not happy for her situation. I'm not happy for anyone's downfall. I'm gonna be honest with you. Because I've been down before. I don't like to see people go to court and embarrass themselves, especially when their home is on the line. I hate to see people pay these gurus money to defend their mortgages, and these gurus only got one trick. And if that don't work, they're gonna try to go after the judge's bind. I hate that these people take people's money knowing they're nowhere near experienced or equipped to handle the matter. I hate that they will take your money and give you a document that they know is frivolous, all for the damn dollar, while you thinking, I'm speaking in general, thinking it's legit, hoping it works, and it don't work, and you lose your house in the process, and these people have nothing for you. They're not coming to save you, and once it's over with, you won't be in contact with them again. They'll be on the phone with you all day, every day before you spend that money. As soon as you spend the money, you can barely get a goddamn kite sent to them. That's what I don't like. Inexperienced so-called teachers stepping up like they're gurus, like they're ready to step and play where the big boys and big girls play, and they lack the experience of dealing with court. But telling you that, oh, it's going to work. Every case is decided on its own facts and circumstances. No one can guarantee an outcome in any case because each case has its own facts, has its own elements, has its own cause of action, has its own procedural requirements. But the ones who follow the rules, the ones who makes authoritative, non-frivolous complaints, and are aligned with the judicial history and the procedural posture of that jurisdiction of the courts are the ones who wins way more than what they lose. That's what I don't like about
them. Somebody go to the door to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine.
Nothing to argue about there, girl. That's actually correct. You are responsible for what you put on your documents. You are responsible for what you put on your paper. You are responsible for what you file. Do y'all know that? And I really don't like to deal with people who's already been with a sovereign citizen teacher, because I find myself cleaning up their mess before we even get to the underlying issues. But because I understand people's situations and I got compassion, I do take them. And the stuff that I have on my files that they sent me, or which they paid people online for, is sickening. It's disgusting. It's literally one of my clients. I feel so sorry for the girl. She paid $2,500. You know, in a desperate situation, trying to save her home, $2,500 for a document that you can easily find on Scrib. All they did was rechange the words around. These people are wicked. They got wicked spirits. They got wicked intents. These people are wicked, but they think good fortune is going to come to them for what they're doing. They think it's going to work out in the end for them. Keep your heads up, man.
I didn't cite an exact statute, but I appreciate your objection. I just said MCL because they're both under MCLs. Both proof of service and certificate of service are both under MCL.
No.
All right, everybody,
You
so let me make my ruling.
let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service is not on the disposition. And just like she read on 657-16, was the property described on that disposition?
Yeah.
Was there a description of the property?
Ma'am, you know it's your apartment. See, these are the semantics game. You know it's on the department. Like, apartment that you in. You know this stuff. The judge is not going to throw it out because they didn't have the apartment there. This is a landlord-tenant. When you step into a landlord-tenant, deference is going to be given to the landlord. It's all about, did you pay? Did you not? What does it take to keep you in the apartment or the unit? And if they didn't serve you correctly, yes, the case will be dismissed, but the case will be dismissed without prejudice because the judge is going to give them an opportunity to do it right. And y'all online talk, I got my case dismissed without prejudice, meaning they can, and most of the times they will pursue the case again. The worst thing that you should ever, from a legal professional point of view, because that's the only angle how I look at this stuff. When you're going up against a finance company and they voluntarily file a motion to withdraw their case and the judge dismisses it without prejudice, which usually happens, because when they do it voluntarily, it's always without prejudice. You best believe they're tightening up the screws and the bolts and they're coming back again and they're closing up all those loose ends.
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Participate in HUD programs or accept federal HUD assistance.
Do you have a HUD voucher? Because that's the only reason why you should be asking that question. Do you have a HUD voucher?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this, anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence.
What's the breach? What did they breach? Yeah, listen. I'm sorry to keep it. Oh my God. You're in the unit. They pay. You paid to security deposit or whatever. You're in the unit. What did they breach? Now, if it's something like a leak ceiling or leak pipes, and you request them to fix it, and they don't fix it, let me bust down another myth. That does not mean you can withhold the rent. What you can do is you can get it fixed yourself. Then you can deduct the money that you spent out of your pocket getting it fixed. Or if you want to bring a suit against them, you bring the rent money to the court and you deposit the rent money in escrow. It doesn't mean you just get to stop paying your rent because they didn't come and fix the AC. I know it's uncomfortable. I know it's an inconvenience, but no landlord-tenant court is ever going to allow you to stop paying your rent just for the on the basis that they didn't come fix something in your house. Now, if it's a condemned house and be warned condemned, then you have a totally different argument. And if they had knowledge of the house already being condemned or the rental unit being condemned before you moved in, then you have a hell of grounds to recover and recoup everything. But rarely do you see those cases. Actually, they are extreme rarity. I think I've only seen like 1 or 2 ever. They're not moving people in condemned homes like that. It's just not happening. But this is what I'm talking about. Everything just to get out of a debt. And they're not even doing it correctly.
On why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing and you apply and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay.
Everyone does who accepts vouchers. But the only way I can make this connection to your case is if you have HUD. You got a voucher. If you don't have a voucher, this whole entire line of questioning is called frivolous. See, us professionals, we know not to raise these issues because we know if she was my client, I'd be like, we're not going to raise the argument because number one, you don't have a voucher for HUD. It's like, it's a nothing burger.
So if you're using, if you have HUD terms
Hit the likes, let's get them.
and you're,
Your Honor, I object.
YouTubers, hit the likes, share, hit the likes, drop a sub. If you haven't subbed yet, drop a sub. Let's get them likes up. Let's get them likes up.
Miss Battle is taking.
object to it. I didn't say anything yet.
Well, I'm objecting because she asked Ms. Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked a question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next question.
She said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you objected me.
Let her ask the next question.
Oh, by the way, y'all, I'm not like these other online gurus that's going to come online and beg you for money and beg you for money and beg you for galaxies and beg you for stars and beg you for the planets and beg you for Mercuries and beg you for fun. I don't do no begging. It's not this channel. I don't beg at all. Don't even ask y'all for nothing. It's not me.
And if you have an objection, I can hear it after she finishes her question.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't. Because it's not.
Absolutely doesn't mean that. It just has nothing to do with the subject at hand. It does not mean that. Don't get too big for your britches now. Don't do that.
No, because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor.
Once again, you're citing Title 42. Y'all, TikTok, YouTube, can I ask y'all a question? What is she not understanding that none of that applies to her? She doesn't have HUD. She doesn't have a HUD voucher. Like, she's not a HUD tenant. I could see if she was, that would make all the sense in the world. Probably won't help her get out of anything, but what does it matter when it's like it has nothing to do with you?
Again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear. I said either federally funded or get federal funds, which you do if you accept Section 8 and vouchers.
No, that's not true.
Why is it not correct? You have to think about it. Yes, it is correct. Because if you receive any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are, do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. This Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter.
There you go. There you go. You don't receive a voucher, girl. You don't receive a voucher. That's just like me on behalf of a client. That's just like me. She has a situation where she is current, but me going in there raising arguments about what's supposed to happen in a default. But she is current as the water flowing up a stream. Like there's no connection.
If I receive a voucher, it matters that
they be so confident. You hear the confidence, like the false sense of hope and confidence is plagued these spaces. She really thinks she's making a legitimate argument. Nobody else believes she's making an argument in that room but her. And that's the problem. The judge not buying it. The judge don't believe it. YouTube, y'all can see the look on her face. Everybody's looking at her like, what in Sam Hill are you talking about? And that's the position that none of us should ever be in. You need to have where the judge is looking like, oh shit, this is plausible. It's plausible that this happened. Like, come on, man.
You are of that type of entity that needs to go through HUD because you accept those things. So you agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
They don't. That's not, they don't. Please, let it go.
Okay. Okay. You're saying that it doesn't have to, but HUD says that these are the requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Please. You're just making a fool out of yourself at this point.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing here.
Ms. Battle, move on.
Move on. So, okay.
No, you're getting a fair hearing. It's just that none of your questioning has any legal relevance. And this is what I was talking about earlier, y'all. When you like, this is called cross-examination. Now, when you're engaged in cross-examination in court, the number one thing that you always want to do is you want to lay a foundation before you arrive to your original point. Now, if she was receiving HUD, that line of questioning would have been sufficient. Yes, yes, answer questions, yes. Then she can hit them with, well, I put in a grievance procedure, which you failed to investigate, or whatever. I don't know if it'll help her with the overall rent, because landlord-tenant cases are pretty much cut and dry. But when you're in cross-examination, you always want to lay the foundation. Like, you don't want to lead the witness, because you can't lead the witness, or you can't finish sentences for them, or you can't put words in their mouth. But you want to ask them open-ended questions. So it gets to my next point. You asking them a question that you and both of them know what the answer is. Because in law school, they teach you, lawyers know this. This is law school 101. You never ask questions that you don't already know the answer to. One of the biggest mistakes was in the O.J. Simpson trial. They had O.J. try on those gloves. You never have O.J. try on those gloves unless you know that they are going to fit.
You're rocking with the best.
And yes, that's in the court rules about cross-examining. The line of questioning. It has to be within the court rules.
Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn. My plaintiff.
I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay, Ms. Battle, move on.
Move on to
What? Now she got more. She got more. This is when she's getting frustrated now. Now the gloves are going to come off. Now the real her is about to come out. You can tell. Everything is lost. This is what happens.
what? I cannot have, this is not a fair hearing. And again, this is why
You're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all you all, because this is just not, and I told the Attorney General, and I told the IRS.
And I looked up all those cases. She filed quite a few cases against the judge, Miss Elaine Washington. She filed cases against her, and her case was thrown out because, number one, it was just frivolous top to bottom. But judges, once again, and lawyers are generally immune from lawsuits brought in the performance of their duties. She's a sitting judge on the bench. You will never win a lawsuit against her while she's making a ruling from the bench. You will never win. Judges have judicial immunity. Lawyers do too. Now, she was outside of her official capacity. That's a possibility. But don't even think about it, because you're not going to win.
And I did everything else, because at the end of the day,
Please move
all
on.
of this is not right.
I'm telling you
And
now
attorney
that I'm going to be filing criminal proceedings against you for all these frivolous things that you're filing against me.
If you feel that
So when she said she was going to file criminal proceedings, because she filed about 3 or 4 lawsuits back to back against the judge, and all of them were thrown out. And then she tried to file a false lien against the judge. Now, the reason why I'm saying this because it's important. Remember when I said when they lose on all their arguments, the very last thing they do is start attacking the judge? That is a typical sovereign citizen. So when she called her a sovereign citizen early in the proceedings, she got upset. But her words, her actions, her mannerisms, how she interprets law is all indicative of the classic sovereign citizen, where they know very little about what they think they understand. They think they know court. They know very little because instead of following the court rules, learning the basics, following the rules and procedures, they was following scripts and documents and manifestos and redemption manuals. If you want to learn how to operate in a court, you go to their rules. You don't go to this website here and you find someone that knows how to objectively interpret case law. If y'all would have made these gurus prove they knew everything they was talking about with substantive case law, applying the judicial lens to all of their arguments, none of them would have any leg to stand on today. I apply the judicial light to any claim, even my own. If I bring up anything, you best believe I can find 5 to 10 cases, all different elements agreeing with what I'm saying.
it's frivolous, that's fine. But it's not. My rights are not frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
another sovereign citizen theory that you think this is once again, they think that they could put their own notices and affidavits of truth together, and just because they found a maxim that says an unrebutted affidavit stands as truth, they believe that since they sent them an affidavit and they didn't respond, that they're true in what they're saying. They didn't respond because there is no legal order for them to respond, and courts would never order the other side to respond to an affidavit. An affidavit falls under the evidence rule. It's not a motions and pleadings thing. It's not a full determination on whether someone is accurate on the merits or not. It can be used to assist the judge in making their findings, but unless the judge orders them to respond, there's no legal reason for them to respond. And this is why they did not respond. Y'all keep thinking that them people out there, they could just send affidavits to affidavits, and since they don't respond, then whatever they seeking is granted. No. An affidavit is nothing more than a attest to the facts of any particular issue. It does not mean you win because they didn't respond. They have no legal binding reason to even respond to your affidavits. This is why they don't respond and rebut them point for point, because there's no court order for them to do so. Courts would never order them to respond to a damn affidavit. They respond to motions and pleadings. Once again, simple, basic court rules and procedure has not made an appearance in these spaces yet.
Battle, if you're not going to ask appropriate questions, then I'm just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't have a real opportunity to ask the questions. So at this point, like I said, I'm just going to have to get the federal court involved and get the marshals, because I don't know what you all are going to do. You all have not been acting in honor and with good faith. So
once again, another term, acting in honor, staying in honor. You haven't been acting in honor because you refuse to pay your rent for whatever reason, whatever reason, we past that point now, and now you're being sued in court for back rent. So we can't do things to violate our obligations or not honor our obligations and then scream that people, they're just taking advantage of your rights. Ladies and gentlemen, let me tell you this, because I'm probably going to be the only one to tell you. I will never advocate for you to not pay your bills. The safest thing you can do when you're unsure about a course of action is to, at least in the meantime, as humanly as you possibly can, pay your bills. Because if you are effective or you get with the set you, one thing you're going to realize is in the back end, we're going to get them on the back end. 16 months I was investigating credit acceptance. I paid my note $629 a month faithfully because I did not want to give them the satisfaction of using the default as a way to wiggle out of my claims that I wanted to raise. Pay your bills if you can until you're in a position to not pay. And the only way that you can just stop paying your bills is you have to justify from a point why you are not entitled to pay your bill. Pay on that contract from a legal standpoint. When I made my last payment July 1st of 2025, when I made my last payment, I told credit acceptance, this is the last payment that you will get. And you want the rest, you got to meet me in the ring. And when I sent them the email on August 18th, they took me off auto pay on their own. They took me off, put the account in non-applicable status. They stopped sending me balance due notice. They put the whole account on hold from August 20th, 2025 until it was wiped away as part of the settlement like January 28th of this year. But I didn't stop paying because, I sent them a document. I stopped paying. I showed them why I'm legally not entitled to pay anymore. And I still followed up with the lawsuit. When you stop paying, a lawsuit better be imminent on your end. You better not stop paying and send them a document and think that's going to be the end of it. When you stop paying, that is just the first step in the strategic move and the strategic planning of the whole lawsuit that you're planning to file. That's just one step. Do not make not paying the last and end all be all step and send them a document and expect them to not collect. You know the inevitable is about to happen. And if you cannot legally, from a legal standpoint, from applying the legal standards, prove to them why you're legally not entitled and prove to them that you can win on these merits in court, they are going to get aggressive collection. They're going to accelerate the loan. Do not put yourself in that situation when you know deep down inside you're not fully equipped to deal with them on that level yet. I don't want to see you go down that road. It makes it harder for everybody, which is more the reason why.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you. I don't know what that is, but you should seek some mental health. Because something.
I'm sorry.
Damn, she just like did lean on that one. Oh, she did lean.
So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you. I don't know what that is, but you should seek some mental health. Because something is wrong with you. You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. No, be specific because
No.
now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action. And I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law. That's what you're saying, right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is.
Once again, a misinterpreted case.
It's
all right.
backed in case law. And y'all keep muting me. It's okay. Because he can talk, but I can't talk.
Ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so what I'm
Defaulted on the private side, filing false liens. You got defaulted on the private side, and she thinks that's a default on the private side because she didn't respond to her frivolous liens that she sent to a judge, her frivolous affidavits that she sent to a judge. So she defaults on the private side, and she wants everybody to believe that she's not a sovereign citizen. Okay.
going to do is grant your judgment in this particular case because I've given her an opportunity to present defenses that are real, and she has refused to do that.
I didn't refuse to present defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the last piece.
Your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the subject
We're
matter.
going down the same road.
Okay, listen, stop. I didn't cut you off. I didn't cut you off. You just asked me what my defense was. And
all right, I'm done.
wow. You're asking me what my defense is.
Take her out. I've asked her 3 times to stop this. All right, I'm gonna grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes.
Thank you.
Thank you.
Once again. So you see, not only me telling you, Thomas, you could be saying anything. New culture, yeah, you just biased. You're an agent. You don't want people to have their rights. You must be an agent. I could be all the agents you want, but I end up with my stuff free and clear. I could be all the agents you want. I'm not in a rat race. This is awareness for those who still may be on the fence or probably feel like they're too invested just to let it go at the drop of a dime. So I'm letting you see how this stuff plays out in everyday court. See, they're not showing you the 50,000 judgments ruled against pro se consumers weekly down at my, yes, 50,000 weekly. They come out with the weekly orders and judgments. It's a packet that sits right at the table. You can flip through it. 50,000 judgment, 65,000 judgment, 15,000 judgment, 433,000 judgment, $5,000 judgment, 7,000. I mean, it just goes on and on and on and on and on and on and on every day. We're not winning. We're not winning. None of this stuff equals wins. We're not winning. The wins and losses is not tipped in our favor in 40 years. None of that gets you any wins.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I'll give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
Once again, asking a question that you already know the answer to. Semantics game.
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's criminal, can I ask to dismiss the charge? Because at this point, the prosecutor, there's no sworn testimony. There's no sworn.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road.
And this is what happens when they don't understand court procedure. See, they come into court thinking they know the law, but they don't know nothing about the court rules and procedure. But I'm supposed to look at these people like they're normal.
What's going on, guys? Welcome back to your favorite YouTube channel.
All right, on the telephone ending in 1336.
Sui Juris and personal persona. I'm Stephen Tyrell White, benefit.
Told you, all these unusual hyphens and semicolons to their name. That's another tell of a sovereign citizen.
I'm Stephen Tyrell White, beneficiary of sovereign. I'm here under fraud, menace, and duress. Fiduciary Daniel Williams Norbeck.
It's never because they did something to break the law or they wasn't in compliance with the law. They just knocked on their door, drug them out their bed, and threw them right in court. They never do anything to. If you don't like the court system, you don't like the police, whatever reason why do they continue to put themselves cross paths with the law? They want to do what they want to do and don't want to be accountable for those actions. And now everybody's violating their rights when it's time to be accountable. You see, the mindset of this space is why we won't win. Very few of us will ever win. And the few who has the best chance of winning are not the ones who follow someone because they got a fez on their damn head, are not the ones who pay attention to the words of what's being said by someone who got 50, 60, 70,000 subscribers or followers, or who got the bonded promissory notes and all these documents that everybody believes in too. They think that since you got 40,000 followers, that you know what you're talking about. I got barely 500 followers on TikTok alone. What it was like 1,560 on YouTube, but yet I got more receipts than many of these online gurus combined. So if we're measuring what a person knows what they're talking about based on followers and sub counts, then I'm out the game. But if we're measuring it based on what's said, measurable results, something that you can easily see for yourself, nothing skewed and shrouded in mystery, who pays attention to the court rules, pays attention to the rules of procedure, has authoritative case law, has a deeper understanding of the finance system. No, these are the people that you don't really want to follow is because these people are going against everything that you believe. And once they turned this into a belief system, that was the end of the show.
Okay, Mr. White, we're going to pop you over in the waiting room because you're just going to be a distraction for all the citizens here willing to abide by the laws of our country. So we'll pop you over in the waiting room and we'll get back to you. In case you guys have ever heard of the term sovereign citizen in the news, that's what one of them sounds like when they try to come to court. All right, Mr. White, do you know what?
This is right at the arraignment. Y'all, these judges been seeing this shit for 40 years. You're not coming in court saying anything new. They've already heard it. They've already heard it.
You hear me?
Your Honor.
All right. I'm going to read this to you so you understand what you're charged with. This says that on January 7th of this year on 2nd Street there in the city of Fenville, that you were driving while license suspended. That is a misdemeanor. It's punishable by up to 93 days in jail. And
so he's driving with a suspended license. Now, what is the root of all these claims in court now? What do I say? It's always a suspended license. Court fines up the ass, can't get it paid. Now the license suspended, has a hard time getting his license back. Now he's the beneficiary. But key word, why does he have a license in the first place? Why, if he believes in this, cancel all your contracts. Why does he have a license in the first place? Because they don't even believe in this stuff. It's just a tactic to get out of debt and escape accountability. They don't even believe in this stuff wholeheartedly. Because if he did, why ain't he turning his driver's license? Once he became woke.
or $500 fines and costs. Do you understand your charge?
Objection, Your Honor. I do not. I do not understand my charges or any
Okay,
cause.
I'm going to mark you down as not guilty, and we'll set you for a jury trial. You can continue to.
Your Honor, you practice in
Yes.
front of bench. You practice in front of bench. That's my job or my attorney job.
There you go. Practicing law from the bench. And the only time they say that is when they act like they don't understand what was said, when they know they clearly do. So now that he's entered a rule, a plea of not guilty, which they have to do by law, when you stand mute and you don't make a plea, by law, this is ancient old court law, they have to enter a not guilty plea on your behalf. They can't enter a guilty plea on your behalf. It's prejudicial. So court rules and procedure, when you don't want to just follow the simple proceedings, they are always going to enter a not guilty plea on your behalf. That's just how it is.
And I'm sui juris. I'm pro pria person.
Okay, Mr. White, I don't know where you read the stuff that you're saying, but it's legal nonsense. It means nothing in a court of law.
Because, Your Honor, just like a lot of them, they don't believe and do the research on the origins. It's just something that they was told that's going to get them out of accountability. That's all it is to them.
So if you're not willing to state that you even understand or recognize the authority of the court, my options are I can make you come in for arraignment and not give you a PR bond, and then you'll have to post bond to not sit in jail. You want to do it that way instead? Right now, if I get through arraignment with you, I'll give you a PR bond. Mr. White?
I'm asking you a question.
What's the question, sir?
I'm not arguing with you, Your Honor. I just want you to hear me.
Okay, but I don't want to listen for 20 minutes. Go ahead and ask your one question, and we'll start there and see if it's a real question.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's criminal,
Told you, they all do the same thing. It's a script. None of what he's saying is coming from his own research and understanding of the court rules. It's the same script. It's a criminal civil. It's criminal. Well, if it's criminal, it's either going to be this or this. And you're going to have this and you're going to have this. Now, the question is, okay, apply the legal standards to what you just said. Let me know where that's in the court rules. Because this is proceedings. This is procedure regarding the proceedings. Let me know if anything that you say is in any court rules in America. You won't find it. And since you won't find it, then that means anybody that listens to people like him and goes to court to say that, you're already outside and out of line with the court rules and procedure.
Criminal. Can I ask to dismiss the charge? Because at this point, the prosecutor, there's no sworn testimony. There's no sworn.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road. Arraignment is just for you to make sure that you understand what you're accused of.
Under your constitutionally protected rights.
What the penalty is, and for you to enter a plea. You're accused of driving while license suspended. I read to you what the possible penalties are, and I asked you if you wish to plead guilty or not guilty at this time.
No, Your Honor, I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace.
Oh, he actually admitted it. Now, I'm glad he admitted it. So everyone who says that this is not sovereign citizen stuff, just because you don't like the name and the stigma, but you want to follow the same script and submit the same documents. So for you people who say you're not sovereign citizens, listen to your fellow brethren.
I'm a beneficiary and I'm a sovereign. I'm here under fraud, and I'm a sovereign. I'm here under and I'm a sovereign. Your Honor, I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace, and
sir.
He said I'm a beneficiary and I'm a sovereign. There you go.
Those sentences don't mean anything. They have no legal meaning whatsoever. Mean anything. They have no legal.
Here under fraud, menace, and
sir. Those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by
so
my constitutional.
I've indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial.
So when I say they have no legal meaning whatsoever, people respond back to me in the comments. But when I always tell you, if you don't want to listen to me, I'll let the judge tell you that your sovereign citizen rhetoric has no legal validity.
Arraignment. I've entered a legal meaning.
I'm here under fraud, menace, and
sir. Those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by
so
my
I've
constitutional.
indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial. You can represent yourself free of charge, or you can hire an attorney. And now you must make a choice, sir.
You ever wonder why so many non-U.S. citizen people always want to stand under the Constitution, which is only there for U.S. citizens? You ever notice that? You say you're not a United States citizen, but you want the same protections under the constitutions that are afforded to United States citizens. You see how that works?
Bond. If we get through the arraignment with you on Zoom, I'm going to give you a PR bond, personal recognizance bond. That means you don't have to post any money. We're essentially trusting you that you'll keep coming back for your court dates. It is no driving without a valid driver's license. If you cannot get that far, in other words, if you really don't understand what's happening here, then I'm not going to allow you to be arraigned by Zoom. I'm going to set you for arraignment in person. Then you will come to this courthouse. You will not get a PR bond. You will get a $300 cash or surety bond, meaning that you will need to post $300 in cash or you will sit in jail from that day until your trial day. So I'll give you a choice. Do you want to be arraigned over Zoom like we're doing today, or would you like to come in and be arraigned in person?
Well,
Uh-oh. This is when he realizes the script ain't working. What do you do next?
I object to all of this, Your Honor, because at this point, I don't even understand the charges. I do not understand the charges.
There you go. And this is when that's what they tell you to play gang goofy. Play gang goofy. Go, I don't understand the charges. No, I don't understand. I don't understand. You see, with this ideology, you got to force yourself to play stupid. Who wants to live like that? Like you're forcing yourself to play stupid. Okay.
No,
Okay,
I'm not
listen to
trying
me.
to.
That's
I'm
fine.
not being
No, sir,
funny.
you're allowed to, sir, you're allowed to object, and I understand your sentence that you don't understand the charges. And so I will attempt to work with you for that for a second. I'm going to read the charges to you, okay? This says that it takes place on January 7th of this year. You understand that, right? The date that I just read.
I'm saying I do not.
Brilliant move by the judge to break it down slowly, because when you break it down slowly, okay, do you understand that part? He knows he understands it, but he like in his mind, him saying he understands, meaning, do you stand under the charges? It's all these stupid eye on the pyramid like meanings. It is a simple term and simple meaning, but he in his beliefs, he can't give in right now because he's gonna feel like he lost when he never won anyway.
This says that it takes place on January 7th of this year. You understand that, right? The date that I just read.
I'm saying I do not. At this point, Your Honor, it's I was saying this. It was a jurisdiction matter. It's a jurisdiction matter. That's what I'm saying. It's a subject matter
Sir,
jurisdiction.
Here's the problem with you arguing jurisdiction. I am a lawyer, so I understand what jurisdiction means.
Uh-oh. You're in front of a lawyer. You're in front of a lawyer. Uh-oh, let's hear this.
I'm not sure you do. The accusation is that you're driving around on 2nd Street in the city of Fenville, meaning in Allegan County, and that you're doing so when your driving privileges with Secretary of State have been suspended or revoked. Because this is the county. Yes?
Objection, Your Honor. I travel. I don't drive.
Okay.
I have no
Sir,
contact
here's
with
what
nobody.
we're doing, Mr. White.
Oh, I forgot. He was traveling. He doesn't drive. Ladies and gentlemen, when you step into your vehicle, whether you got an automatic or electric or I know the P stands for park. I know the R stands for reverse. I know the N stands for neutral. What does D stand for? Somebody let me know what D stands for. Maybe I'm trying to understand what does D stand for? Because I don't see a T there. Oh, D stands for driving. Drive. That's what the D stands for on the gear shaft. Drive. So driving a motor vehicle was the method you employed in your travel. I get it now.
You are no longer able to be arraigned by Zoom. What I'm going to do is adjourn this. I'm going to adjourn this, and you will get notice at your address there. You will come in and we will arraign you in person. I'm telling you that I'm not going to give you a personal recognizance bond. Sir?
It has to be before we can
Mr.
proceed.
White.
Before you can proceed, it has to be
Mr.
addressed,
White.
Your Honor.
Because we are on the record, I'm going to make this infinitely clear. You're going to get notice to appear in front of me. You have two choices. If you do not appear, I'm going to put out a bench warrant for your arrest. If you do appear, We will have this conversation again about arraigning you to see if you understand the charges, but you are not getting a PR bond. You will need to bring with you $300 cash or surety, or you will be in jail. Do you understand those two options, A and B?
That's a violation of my constitutional rights, Your Honor.
Well, no, it isn't, sir. So we're all set.
So you had a chance to go through the simple proceeding and get a PR bond, but you stuck to the sovereign citizen script, dug a ditch for yourself. Now you have to pay $300. Remember I told you following the sovereign citizen script put you in a worse position than what you began with? This is a classic example of it. He's now in a worse position than what he began because now he has to pay $300 to get out versus just being PR'd over Zoom. But this is what the sovereign citizen script and the methodologies do. They leave you off worse than what you begin with.
For today, we're done talking. We cannot make any progress. You will be asked to come in person for arraignment. You can either choose to come in for arraignment or you can choose to not be here. If you choose to not be here, a warrant will be entered for your arrest. And if you do choose to be here, make sure you bring that $300 because you're not getting a personal recognizance bond. But we are done with this hearing. I'm going to go ahead and release you. Thank you.
When's my date?
All right. So right off the bat, you can hear it. The sovereign citizen script comes out immediately. The whole name correction. All right, let's roll the next footage.
Oh, looks like HP is in the waiting room too. So we'll bring him in. All right, good morning, sir. Give me one moment.
Good morning.
Highland Park. Oh, is that Officer Monroe? Hello, Highland Park? Okay, we're gonna wait. Your name, sir, for the record.
I'm at your Roman Sister Trust legal fiction corporate entity defendant. That's what you want.
Okay, he already started off with a bunch of babbling. That's it.
I am one of
Okay,
the
well, this,
sovereign people.
okay. All right, so this is for Eric Joseph Martin. And officer, can you tell me the person that's standing before you, who they've been identified as far as your records?
Yes, Your Honor. This is Mr. Eric Martin.
Okay.
I object to that, any presumption that I'm a legal fiction corporate entity. I am a living man whose name is spelled capital E lowercase RIC of the capital M lowercase ARTIN family, one of the living people.
It doesn't matter if your name was spelled on a goddamn Titantron in all caps. It's you. It has no legal significance. Oh, your name is in all caps. It's not you. Corporations' names are not spelled. Humans are not spelled like that. Look at the English language in the dictionary. Oh, they don't spell it like that. Okay, you still gonna swipe that goddamn credit card, ain't you? Your name is spelled in all caps there. But let me guess, when it comes time to pay it, that wasn't you that spent the credit card. That was your all caps that spent the credit card. Even though you were the only one that enjoyed the use and benefits of the card, it was the all caps. So don't sue me now after I used up the goods and services and used the available credit. Nah, I don't got to pay it back, even though I enjoyed the goods and services that came from the swipe. Nah, you got to go after the all caps. But once again, you never see these arguments until the balance due is more than the available credit.
Living on the land, not the corporate entity defense.
Okay, sir. All right, it's time to listen right now. Thank you and good morning. The court is calling case number 282-257-13-64001. The people of the state of Michigan versus Eric Joseph Martin. Appearances, please.
Jasmine Martin, P 86378, appearing on behalf of Mr. Martin.
Your Honor, who indicated that he wishes to represent himself, pro se.
Okay. All right, so Mr. Martin, this is an arraignment. And it's the court, never advises the individual to represent themselves, but you do have that right. You do have an attorney that's here that had an opportunity to speak with you. What's your position as it relates to this arraignment? So you'll need to know how to follow court procedure if you want to represent yourself.
I have a motion I want to make on the matter at the bat. I'll move to dismiss based on lack of probable cause. My sister just told a lie saying I put my hands on her. I told the cops, no, I did not. That is not fact sufficient for the belief, as the U.S. Supreme Court said, and if I remember right, it's Beck versus Ohio or Ohio versus Beck. It's a U.S. Supreme Court case. Defining probable cause is fact sufficient for the belief. There is no fact for the belief. There is no probable cause. I was arrested illegally. I want the cops charged also for arresting me illegally, which is assault.
Mr. Martin.
You see, when you get to this age of the sovereign citizen, no one can tell you anything. You just sidestep them and let them walk themselves right off the cliff.
Hold on,
Mr. Martin.
It's kidnapping.
No. What we're going to do is, because I want to tell you this, you could challenge the complaint. You'll have a probable cause hearing, and you'll have an opportunity to confront your sister at the preliminary examination. If she's not being truthful and the court hears that, then your matter will be dismissed if the court doesn't find probable cause. And if the court does, then the matter will be bound over. But at this juncture, I'm just arraigning you, sir. And that's all I'm gonna, entertain today. I'm not entertaining any motions relative to dismissal. The probable cause has been established.
I object.
It's arraignment. You can object, and your objections are noted for the record, okay? But I'm just arraigning you. I'm just gonna set a bond, and you'll challenge those matters at the next court hearing, okay?
But I have a right still to challenge it now because the officer filled out the complaint form. He's lying by saying he believes I committed. He can't just go off her word and say, "Oh, I believe he committed a assault or whatever or a crime." He's committed perjury just by doing that. I shouldn't be arrested, let alone still be held here. That's what I'm saying. This is all illegal, violation of due process rights. So, you shouldn't just be referring to a future date, whatever. Yes, we know that's true, but I'm saying as of right now, though, the issue is still ripe now to decide. It was no probable cause. I shouldn't have been arrested. I should be here now. The charge is dismissed. There is no evidence here.
Talk over me, Mr. Martin.
My sister caught lying before on video, which in another case was dismissed in my favor for her same lying self, and she was on video caught lying. This is why the judge dismissed her. So she really has no credibility.
Listen to the court right now. You'll have a chance to take care of those matters later. You'll address all those issues. The court is not trying to be rude. I'm going to arraign you. So I'm going to tell you what you're charged with. It indicates in the complaint that on 6/12/2025 at 9074 Clippard in the city of Taylor, indicates in count 1 that there was an assault or an assault and battery upon Lisa K. Martin. Sir, that is a misdemeanor that carries 93 days and/or you could be fined $500. You also have in count 2 a charge of domestic violence. That is also a 93-day misdemeanor. It indicates that you did make an assault or an assault and battery upon Lisa K. Martin. Again, these are just allegations. They're charges which you have an opportunity to challenge. This is an arraignment. I am going to enter a not guilty plea on your behalf. And officer, do you have any information relative to Mr. Martin's background?
Ma'am, they previously had a lot of domestics with each other. He does not have any ongoing cases at this time, though.
Okay, so Mr. Martin, I understand that you were living at that location, but the court's not going to permit you to return there. You're going to have to find another place to go while these charges are pending.
That's the house I live in. I don't lose my due process right. It violates my due process. I can't live there because she makes up a lying allegation. I do not lose that right. That's my right.
You have a pretrial that's scheduled for June the 23rd. You have a pretrial scheduled for June 23rd at 9 o'clock. There is a no contact provision, and you cannot return to the Clippard location. And if you do, sir, that'll be a violation of your bond and you will end up back before a judge in Taylor to address that.
And you'll
So
be
thank
committing
you and have a
federal
great
crime,
day.
Violating your oath of office, you'll be forfeiting your job. That's violating my constitutional right. I do not lose my right to be free just because someone tells a lie with no evidence. That's why I said this case is dismissed now. There is no evidence. There is no probable cause. You do not have the right to tell me I can't go here or go there or be at my only house that I have a right to be at, or leave the state and all the rest of the bull crap orders you judges like to just do traditionally. Like it's okay. It's violating people's human rights. It's violating our constitutional due process. You judges are going to stop this with a class action lawsuit. I'm going to make you guys stop this habit that you're doing. So you might stop it now. Like I said, I'm not. It's not going. You're not going to get away. I'm going to get away with violating my due process rights. Telling me I can't be at my house.
I'm done with this matter. Thank you, Mr. Martin.
House to go to anyways.
Okay, I'm done.
What is her name? Correct. What is her name?
Okay. Have a good day, Mr. Martin, sir. Take care. All right, we're done. Thank you, officer. Take care.
Okay, so what you've seen here is another example. When they don't get their way, now they want to sue the judge. They always want to sue the judge when they don't get their way. They always want to sue the judge when they don't get their way. This is the last video of the day. Then I have a document. I want you, it's only one page. And then we're going to wrap it up. Shout out to everybody that's in the building. Shout out to everybody that's still here. You know, once again, if you're still here, then there's no doubt in my mind that
you're rocking with the best. You're rocking with the best.
Shout out to TikTok. Shout out to YouTube. Y'all been in the building for 4 hours. That's how we do it. Now, this is a tenant case. Not so sure. It's kind of going viral already. Came across my timeline. This will be where I'm seeing it for the first time with y'all. Let's get it.
Mabry versus Jessica Williams.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
Y'all, I know it's exciting. I know it's rejuvenating. I know any win builds confidence. It gives you the ability to want to keep pushing more and take on bigger goals and tasks and challenges. I understand that. So shout out to the people that are winning these, these little credit card cases. People who are winning on technicalities. People who are winning on them violating your FDCPA claims. Shout out to those who are winning, these little arbitration agreements. I mean, it's nothing wrong with them. A win is a win. But I know, like because I have an update from the live stream the other night, and I actually retrieved the case from Tempest Marine. Everything in the Supreme Elite Team University is how the system works. The good, the bad, the ugly. This is how the system works. And if you need any type of clarification to really know if I'm talking about, you can look at my receipts. Because I use practical law. I don't use pseudo law. I don't talk about common. I use practical everyday law that every attorney uses every day. I can scalp these people using the everyday law. I don't have to go back deep into the 1800s. I don't got to shout constitutional law. I don't got to challenge jurisdiction. I don't need to do none of that. They gave me the rules. to play the game. And before I started playing the game on this level, I made sure I understood the rules to the game.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume. War stories in the fine lines.
Let me explain something to everyone. A debt buyer, when a credit card arbitration for a credit card, nevertheless, those are wins. I mean, those are wins. I'm not gonna say they not wins. One of the common themes about these spaces and what separates my wins from all these other gurus is the wins that we get on my side, no disrespect, it over these credit card debt buyer technicality win overshadows them because the stakes are higher on my side of this game. You can win a credit card. It's not hard to win a credit card dispute, especially in a debt buyer case. And I don't want people to get the false sense of confidence that the tactics that they use in a debt buyer case, they're going to be able to use in a large automobile purchase case or mortgage case. The stakes are higher. And once again, on my side, I'm gonna use me because I don't want anybody to feel offended. I don't wait to be the defendant. All in these spaces, everybody is the defendant. When is anyone going to be the plaintiff? Because when you're the plaintiff, you have to prove your case on the merits. You're not going to win by technicality as you can win as the defendant. When you actually know what you're talking about and your claims are on a professional level, your wins do not come by technicalities. They come by the merits of your claim, the resolving on the merits. And when your merits are ironclad like mine, more than likely, the case is going to result in a settlement. It won't even see trial in many cases. Maybe some outlier cases, but for the most part, it will be foolish for them to want to take the claims that we raise as the plaintiff in trial. I have a mortgage client. Guess what? When we file the lawsuit, if we can't resolve this issue behind the scenes, he's going to be the plaintiff. That makes a difference. Not going to be the plaintiff, he's going to be current on his mortgage by the time he files a lawsuit. So when you're current and you're the plaintiff, you have way more leverage. I'm not expecting everyone to duplicate me. Very rarely will you see a situation like mine with credit acceptance, how it went down. Very rarely you'll see that. It's okay. Very rarely you'll see that. When you send your documents to them via email and then they stop collecting on their own without a court order. And then you follow up with a lawsuit. Still, they didn't reinstate collection. So they stopped collecting. I filed it July, what is it? I made my final payment July. I sent the last payment to him and said, if you want any more payments, you got to meet me in the federal court. You got to meet me in the ring. Because I was already current up to that part. So I stopped paying. You know what happens when you just stop paying? And the only way they're not going to collect is you have to prove from a legal professional standpoint that you can proceed on the merits when you get to court. That's the only way, the way I can see it. And not only did they stop collecting, I filed the lawsuit August 25th. I sent them the email August 15th. I did not make August payments. Actually, I didn't make another payment after July 1st. And they took me off auto pay. They put the account on NA status. And then I filed the lawsuit. So from August to January 28th, no payments were made and there was no demands for payments. Everything was on hold. And then when they made their appearance, we went immediately to the settlement. We had conversations about they're going to try to invoke the arbitrations clause and all this, but it wasn't all the in-betweens of what I did, the motions I filed, what I put on the documents, my version of securitization and my use of state law and federal law and my citation of case law and my strategic strategy on how to word things, understanding the nuances and the types of claims that are being raised. I'm not expecting everyone to have that outcome, because that outcome is less than what 3% of people are ever going to get from a pro se standpoint. Like, let's strip it all down and get to the reality. Do you always want to be having to defend against someone trying to sue you for non-payment? Is that really life? Is that like, let's look at it. No, I'm not trying to be funny. Do you always want to be in a position where you are not paying and now you got to find a way to get out of it? Or do you want to be in a position where you're raising the issue, you're on the attack, and in the end, you leave with the asset and the property entitled to it without having to pay and the account being zero? Isn't the object is to support your legal claims and walk away with the asset? I haven't seen pretty much nobody walking away with assets out at the end of the day. I mean, if we're just doing this to not be responsible for debt and credit card suing, because everybody named mama are to credit card, but I see very few people talking autos and mortgages because those are very different ball games. And I understand, and Tempest Marie admitted, or Tempest Law response, depending on which day of the week it is, she admitted that she's not at that level to deal with mortgages yet. So she's staying in her lane. That's cool. But I'm talking about for you other so-called successful people. Your version of success is different from my version of success, because I don't want you to get it twisted. Like, with your, like when y'all show me your little debt claims, your debt claim wins, like I didn't even have to go to court as a defendant to get this. I got this wiped away by just sending them a document. And autos and mortgages, because those are the two main assets that we're going to acquire in our lifetimes. Those are where majority of our bills will go. It's going to go to your mortgage, it's going to go to your car note. It's the two biggest necessities that we need today. We need transportation and we need a roof over our head. The stakes are higher in those situations because a lot is on the line. A lot is on the line. A credit card, you can win a credit card just by them not following through on the suit. You can win a credit card by them not showing up for a hearing. You can win a credit card or a debt by a case just by them not having the proper documents and records. Like, it's not really hard at all. But even in a debt by case, let's say you win that, cool. You don't owe the debt anymore. But at the end of the day, how are you taking back your piece of the American pie? Because there's no title, no assets. What the reality is just a line of credit you got and you didn't pay it back and you found a loophole to get around the obligation. That mindset is not building generational wealth, as they like to call it. That mindset is not doing nothing for you, but let you believe that you can continue to do the same things you're going to get out of it. So the only thing you're really saying for real is, I'm going to get this line of credit on my face and then I'm not going to pay it back. And when they try to sue me, I'm going to use these loopholes. Even that won't work every time. But what I'm trying to say is all wins are not the same. Whatever they told you, they lied to you. They lied to you. No, I'm telling you, they lied to you. Let me just say that. The way I look at wins is you getting the asset free and clear. And then you can do whatever you want with it. You want to transfer it into a trust? Because I see a lot of people online today still talking about transferring mortgages into a trust or putting the mortgages in your trust name and you haven't paid off the mortgage or you haven't had the account set off to the point where you can transfer the mortgage or the property or the title into the trust free and clear. Most people try to assign the mortgage to their trust so they can have a third party interest to stage off and complicate the foreclosure proceedings. See, over here, when you transfer property into a trust after dealing with me, it's because you own it outright. And one of the things that they talk about in this space so much is how to get out of this, how to get out of that, how to get out of this, how to get out of that, how to get out of this. But what they're not talking about is true ownership. how to own things outright, how to walk away from the table, not owing the debt, but still keeping the property and getting the title to it. See, they don't want to talk about that. That's the only level that I'm on. If it's not that, I could give a rat's. I don't care about the own nothing but control everything. Let me tell y'all this, y'all. When people say that, they're taking the original term and meaning out of context. See, when they say own nothing but control everything, transferring assets into a trust. You know what the problem with that is, y'all? What was the Rockefellers? When they said the own nothing but control everything, what people want to skip over is they already own the assets before they were placed into the trust. Putting assets into a trust is a good legal structure. But when you don't own the asset that you're putting in the trust, the courts are going to pierce the corporate veil. It's not going to magically wipe the debt away. It's not magically going to wipe the tax obligations away. Actually, the trust pays way more taxes than regular individuals. Remember, in a mortgage, in an auto, it's not always so much about the title itself. It's about the security interest. That's all trust is really set up for, to transfer the security interest. When I have a security interest, or my accrual trust receivership has a security interest and legal rights to my truck, that means the trust has a superior lien, meaning creditors cannot pierce the veil because I legally assigned the asset to the trust, meaning there were no liens on the assets before I signed it to the trust. That meets the court standards, meaning creditors, agencies, they can't go after it for anything. And when the trust has the security interest, now the trust can pledge that title. The trust can make all whatever moves is necessary for the benefit of the beneficiaries. That's how you play the corporate wealth game. Not so much about the asset itself per se. In the corporate world, what every rich person understands, who are wealthy, who are successful, they understand that the right to receive payment is more powerful than the payment itself. Cash flows, consistent cash flows is more valuable than having $100,000 at one time. It's more valuable. So when you look at these securitization trusts, let's say they got about 50,000 in this pool. So they got about 30,000 in this pool. They got 40,000 in this pool. They are creating receivables. Why do you think they don't mind letting you walk away with the house and vehicle right now, rather than you buying it outright? Because as long as they have you paying in monthly installments and got the contract that evidences, and they have a security interest in the property and have a lien on it, they now have a license to print money. That's all what it is on the secondary market. It's a license to print money. So you still hear people talk about the Federal Reserve in our mix and the Federal Reserve in our business. I immediately know that they have no clue on how the system operates. Securitization is no different. I'm gonna use this analogy that I use in the Supreme Elite Team group. The securitization is nothing more than an extension of the game. All right, so you got the wholesale plug. He got all that stuff. That's the wholesale. That's where they go get the money. Now, there'll be banks that are set up just for the purpose of issuing lines of credit. Banks set up, or investors come pull all their monies, institutional investors, bam, right? So let's say they got 10 billion to lend out. So my Supreme Elite Team bank sits down with the acquisition corporation, like, hey, yo, so I bet we need about 500 million because we've already did the advertisement. People already know to come to the banks to get a loan. We already know that we don't have to go look for them. They're going to come to us. But if you look on our balance sheets, why would we want to use our own assets to fund these loans? It's too much risk. Hell no. We're not going to fund our own loans off of their loans off our balance sheet. Why the hell? They may not pay. I bet this is what we're gonna do. We're gonna go to the plug, right? We're gonna get 500 on our face. And then we're gonna originate the loans with the people. And then we're gonna send it over to them. We're gonna jack up the interest rates because we gotta make a cut too. So that's just like, dude, the plug got selling me zips for 150, but I sell the zips to you for 50. So that's a $200 flip. That's $200. And then I deal with the people. So when I got it, when they need to pay me back, I deal with them so I can round out the money to pay the plug back. So the acquisition corporation gets the 500 M's, right? I bet out this 500 M's. All right, hold on. Hey, plug, we gonna give y'all these mortgages. What type of mortgages do y'all want? All right, let me give you the professional. And if you hear anybody else say this, you know they got it from me. Because the only way you would know is if you would know somebody that works behind the scenes. So let me tell you what was told to me, person that actually processes these mortgage payments to Fannie Mae and the investors. Oh, y'all gonna learn when I say I'm connected to professionals. I'm really connected to professionals. Y'all gonna believe me when I say it.
You're rocking with the best.
When I say I got them on speed dial, I'm not lying. All right, so when there's a minimum, so all right, the investors, they want credit scores between 620 to 720. If you get the 620, 650 range, we don't like to take those because it's more money and interest. If we get people with credit scores of 750 and 800, it's less interest. We really don't want them. Bet, we got you. A typical minimum credit score for a conventional mortgage in the U.S. is 620, while government-backed FHA may accept scores as low as 500 to 800, 500 to 580. Hey, we want people with credit scores between like 650, probably no more than 720, because when we get really 620 and 650, because when we get in those range, that's more interest for us. That's the more we can get paid off. If we get credit scores like 720, 780, that much interest. So you can find people within that range that would be able to accept it.
You're rocking with the best. You're rocking with the best.
That boy is good. It's the minimum credit score. Exactly. It's Bank of America, 620. Like this. See, this is what I had to learn before I started teaching. Where all this goes. See how that? You see, when you see all these gurus, it'd be like 4 little flow charts, 4 little points in the Federal Reserve there. They took your money, took the application, gave you money off the... No, that's nowhere near how it goes. It has nothing to do with none of that. You got the transfer, eligible rates, receivable loans, loan obligors, services, loan agreements, eligible trades and receivables, servicer, periodic distribution of collectibles, conduit, and service providers.
Ladies and gentlemen, we are live!
I want y'all, let's see if I could do it like this. All right. Now, I'm supposed to be debating Ali Najee. It's not my words, but I just doing this right now because the debate, when we have it, I would say when people want to debate you on something which you've already been successful on, I mean, it is what it is, but it really shows that the Dunning-Kruger effect. Not only that, I will say this. When you have real receipts and people don't want to believe or don't have the receipts to compare with yours, now they want to question your receipts. So Ali Najee's, his content is that, let's pull it up. My title that I just got based on the settlement says sedan instead of SUV. I have a SUV. This title is related to the SUV. Whether it says sedan or SUV, sometimes those could be clerical errors from the DMV. But the VIN number is what matters. When you run the VIN number on this title, it's going to match the VIN number on my truck. As a matter of fact, people in my group actually ran the title check. And people know my group. They know I had that truck for 2 years. They know what my truck looked like. But even still, even when you got receipts, even that gets questioned. So let's read Y'all might want to pinch the screen because we're gonna read along. He's going back and forth about his upcoming mortgage defense case in California. And I did tell him, for the people's sake, I hope he does win. But the way his arguments are framed and what he's trying to tell me, I don't think Alan Najee is going to win that mortgage case because I think he thinks he knows too much for his own good. So let's listen to this.
I'm going to just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because Remick tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
And bibbity bobbity boo is y. Put them together and what have you got? Bibbity bobbity boo, x plus y equals y, x equals 0. The song is badly written.
And everything that you said has been argued before and overruled. You're speaking to the choir. When I was researching that, you were still a teenager. The question is, did the borrowers pay? Did they not pay? It doesn't matter who's enforcing when you're in default. Even if the trust is closed, they can kick it back to the lender and the lender has to repurchase it. So what if the lender repurchased it? Now it's their outright mortgage. See, you talking about the trust closed. It doesn't matter.
You're rocking with the best.
Context. I'm going to play what he said one more time, and then we're going to read this case.
I'm going to just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because Remick tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
Remember when I said what you know has nothing to do with how you argue in court? And this is one of the biggest mistakes that rookies make when defending mortgages. They're always trying to tie non-court issues into a court issue. Tax remix, that has nothing to do with the obligation of the debt. It has nothing to do with enforcement. If they're violating the tax right, then the only thing that's going to happen to them is they're going to pay 100% taxes on the disqualified mortgages transferred into the trust. That's the only thing that's going to happen. They're going to pay taxes at the entity level on those mortgages. That's it. But somehow, that's a legal defense. So forget what I said. Let's see if has anyone raised this claim before, and let's see how it fares. Because he may be on to something. But let's get into it. Remember I told y'all there was winning on the securitization arguments? All you had to do was just challenge an assignment and mortgages were being thrown out left and right. Remember when I told you what happens when everybody starts to do the same thing? They find a new way to shut those arguments down because the system can't take those many losses like that. Remember, the system always prevails. Like the judges, the courts, everybody knows that securitization and secondary market funds the bloodline of American financing. Without that, we have no economy. You know that, right? And this for all these mortgage gurus who get excited by pulling up cases from 2011, 12, 13, 14, like they're going to win on those arguments today. Let me see if I can. You died. I can't get his name right for nothing. Owned a residence in Los Angeles County. In February 2007, he borrowed $1,802,500. He borrowed $1,802,500 from Impact Funding and secured the loan with the deed of trust against the residence. Impact Funding is named as the lender and MERS as the beneficiary. The deed of trust provides that MERS is acting solely as nominee for lender and lender successors and assigns. And Yehudi's promissory note, together with the deed of trust, could be sold one or more times without prior notice to Yehudi. And y'all do know when you sign a deed of trust, you know they can transfer that as many times as they want. You know you can't. They don't have to inform you that they're doing it.
It's just the new servicer and the new creditor. 29, 2007, Impact Funding sold Yehudai's promissory note and other promissory notes to a certain securitized investment trust, the ISA Trust. Deutsche Bank is the trustee of the ISA Trust, which is formed under New York law pursuant to a pooling and service agreement. Newsflash, all of these securitization pooling and service agreements are going to be governed under New York law. Why did they choose New York law to govern these pooling and service agreements? Because it's most favorable to the lender. In New York law, you definitely can't challenge defects in the pooling and service agreement. And New York is the money capital of the world. Now you see why they chose New York? Because you can't even bring up no pooling and service and defects, definitely not New York. You can't even bring that argument up worldwide anymore anyway.
The trust in my client's case has been closed for 3 years. Remick tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust.
Like I'm not the teacher's teacher. The PSA, in order for a loan to be included in the ISA trust, it must be transferred into the trust by the closing date of March 29, 2007. So the closing date is the 90 days. So, and they get a little grace period between probably 100 days, 120 days, depending on the structure. So the day you close on your loan is the startup date for the trust. Within 90 days of you closing, according to their own agreements, the mortgages have to be into the trust. If it's not, from a tax standpoint, remix standpoint, it just means that they're going to get double taxed. It doesn't mean that you still don't have to pay. You notice how everybody is still using these things as methods to get out of a debt? Right now, this is what these are his words, not mine. More than 2 years after the ISA trust closing date, MERS as nominee for Impact Funding recorded an assignment of deed of trust purporting to assign to Deutsche Bank as trustee of the ISA trust all beneficial interests under the deed of trust together with the promissory note secured by said deed of trust. Footnote. Respondents are Impact Funding, Mortgage, MERS, Deutsche Bank as trustee on a PSA related to Impact Secure Assets Corporation, Mortgage Pass-Through Certificate, Series 2007-2, and Bank of America. 2, a securitized investment trust is created by pulling the loans into a trust and selling to investors the right to receive the mortgage interest and principals, aka the right to receive payment, aka receivables. My definition is in line with the judge's definition. That boy is good. The terms of the trust and right to obligation of the parties are set forth in a pooling and service agreement. The 2009 assignment is dated as August 31st, 2009, signed on October 15, 2009, recorded in Los Angeles County on October 22nd, 2009. On February 12th, Deutsche Bank, as trustee for the ISA Trust, recorded a substitution of trustee naming Recon Trust Company, N.A., Recon Trust, the trustee under the deed of trust. Once again, whenever you see that movement on a recorded deeds with a mortgage, whenever you see a substituted trustee, you best believe that a foreclosure is imminent. The same day, Recon Trust recorded a notice of default and election to sell the property pursuant to a deed of trust. What did I just say? Whenever you see a notice, that movement, that changing substitution of trustee, what did I say? A foreclosure is imminent. What happened on the same day after they substituted trustee? Same day. I told you, bro, I know this stuff like the back of my hand. 3 months later, Recon Trust recorded a notice of trustee sale. On June 15, 2012, Recon Trust conducted a trustee sale, sold the property to Deutsche Bank as trustee for the ISA Trust. In his second amended complaint, Yehudai alleged that the 2009 assignment is void because it occurred after the ISA's trust closing date and that Deutsche Bank's and Recon Trust actions, including the trustee sales, are void because they are derived from the void 2009 assignment.
The trust in my client's case has been closed for 3 years because Remick tax tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust.
He asserted causes of action for negligent misrepresentation, slander of title, fraud, quiet title, and declaratory injunctive relief in violation of Business and Professional Code section 17,200. Yahadi sought damages and equitable relief, including orders nullifying and rescinding the foreclosure sale, cancellation of notice of default and trustee sale, and judgment quieting title to the property. The trial court sustained the respondent's demurrer to the entire pleading without leave to amend, and thereafter entered a judgment of dismissal. In his second amended complaint, Yahadi alleged that the 2000 assignment is void because it occurred after the ISA's trust closing date. Najee Allen, he's in California. California Supreme Court case. Appellate court case. And represents that his claims depend on his alleged allegation that the 2009 assignment is void. Based on that representation, in the absence of relevant arguments, we do not consider these additional allegations. One of the biggest mistakes that you never make in court. And this was a lawyer that made the mistake. This is one of those fly-by-night lawyers jumping on the securitization wave. If you don't raise it, what do I say in the group? You wave it. I told you, y'all, this is not for everybody, y'all. I teach the 2% stuff. I teach the 2%. And this is why many people with the 2%, this is why many people, when I say many people, will not win. You won't see a title in their name anytime soon. We treat the demurrer as admitting all material facts properly pleaded, but not contentions, deductions, or conclusions of fact or law. We also consider matters which may be judicially noticed. Further, we give the complaint a reasonable interpretation, reading it as a whole in its parts in their context. When the demurrer is sustained without leave to amend, we reverse if there is a reasonable possibility that the defect can be cured by the amendment. Yahudai's contention that the 2009 assignment is void. This is the hallmark of all these gurus' arguments today regarding mortgages and the securitization of them. This is the hallmark of them. Every single guru online today is going to make this argument. Besides me, Yahudai's opening brief on appeal, he acknowledged that the viability of his claims, as well as the proposed new cause of action for wrongful foreclosure, turns on his ability to challenge the 2009 assignment. This challenge is based solely on the premise that the 2009 assignment is void because it occurred after the ISA trust closing date establishing the PSA. Our Supreme Court addressed contention, a similar contention in Ivanova. Remember, Alan, when I was like, you sure you got cases post-Galaski that says the same thing? You sure? I didn't tell him this case because this kills Galaski. This case right there, Ivanova. We went over that case in my master netting class. This case kills it. In that case, plaintiff secured a loan with a deed of trust against her property. As in the present case, the loan was sold to Deutsche Bank as trustee for an investment trust. I thought securitization was illegal. I thought securitization was so illegal. I heard gurus keep saying securitization is illegal. I'm not going to play the semantics word games with legal or lawful, but I thought they said securitization was illegal. The court's not saying it's illegal. The courts keep making references to it. Under the terms of that trust, the closing date for the transfer of loans and deeds into the trust was January 27, 2007. Almost 5 years after that date, in December 11, 2000, the plaintiff's lender executed an assignment of the deed of trust to Deutsche Bank, a trustee of the investment. Deutsche Bank then caused plaintiff's property to be sold at a foreclosure sale. The plaintiff in Ivanova alleged that the assignment of her deed of trust into the investment trust was void because it occurred after the investment's closing date. The trial court sustained a demurrer to the complainant, and this court affirmed. The Supreme Court reversed and held that the plaintiff could state a cause of action for wrongful foreclosure if the assignment of the deed of trust was void and not merely voidable at the behest of the parties to the assignment. Explained that only the entity holding the beneficial interest under the deed of trust, the original lender, its assignee, or an agent of one of these, may instruct the trustee to commence and complete a non-judicial foreclosure. None of that says borrower. If a purported assignment necessary to the chain by which the foreclosing entity claims that power is absolutely void, meaning of no legal force or effect whatsoever. The foreclosing entity has acted without legal authority by pursuing a trustee sale, and such an authorized sales constitutes a wrongful foreclosure. Meaning, if the parties to the agreement says, nah, this is void, nah, kick this back, we don't want this, nah, there's too much defect, send it back, and they still go sell it, then yes, the assignment's void. But none of that hits to a borrower's right to assert that argument. None of it. The Ivanova court did not give the borrower the right to assert that argument. We know. It's a hard pill to swallow. I know what they really want, y'all. They want a humble teacher. They want a teacher who's going to be soft and tell you the sky's going to be blue every day. And you're going to win even when all the evidence points that you're going to lose. And when you lose, it's not your fault. It's the system's fault because they don't want to be exposed and they don't want the truth out there. That's what happens when they lose. It's the system's fault. It's not your fault. You didn't study. You didn't interpret case law correctly. No, that wasn't an issue that you don't understand the court rules. You don't understand rules of evidence. You don't understand securitization like you think you do. You don't understand the nuances and complexities of mortgages. No, it's because they don't want securitization to be exposed. An assignment that is merely voidable, by contrast, does not support a wrongful foreclosure action. And 99%, besides the Supreme Elite Team University, everybody else out there who is making these arguments, the assignment is merely voidable. California law, the Ivanova court explained, does not give a party personal standing to assert rights or interests belonging solely to others, aka the investors. When assignment is merely voidable, the power to ratify or avoid the transaction lies solely with the parties to the assignment. The transaction is not void unless and until one of the parties takes steps to make it so, meaning the investors had to instruct the manager of the trust to say, nah, void this. It's the only way it's void in California. A borrower who challenges a foreclosure on the ground that the assignment to the foreclosing party bore defects, rendering it voidable, and thus be said to assert an interest belonging solely to the parties to the assignment rather than to herself. See Osco Galaski versus Bank of America, which Mr. Najee wanted to cite as well. Who died is such a borrower. Say it again, Judge. Who died is such a borrower. Significantly, the Ivanova did not consider or decide whether the assignment of the plaintiff's deed of trust to the investment trust after the trust closing date rendered the assignment void and not merely voidable. That question was a matter to be determined after remand. And guess what? They still ain't touch it because they can't touch it. And Ivanova still lost her house because they can't touch that. So that argument, Chavalino, the courts are not going to invalidate it. Want to know why?
Because millions of assignments take place worldwide after the closing date. And remember when I said, when you fly too close to the sun, you get burnt? You know what that means? You cannot pass a law that is going to invalidate every normal day practice on the secondary market. It's not because it's right. It's not because it's wrong. It's because we represent a subset of American people. The average American does not think like us. They're not interested in fighting. They'd rather pay their bills. They're going to go to these people for loans and they're going to pay their loans back. They're not taking this role. So there are millions of people who rely on the same system that most people out here are trying to destroy. So they're not going to touch that argument, because I can find 1 out of every 3 securitization trusts who has a late assignment. That is the normal practice. They're never going to do it all on time, but the courts are never going to make a distinct ruling on it because it's going to jeopardize the overall system. The system always wins. Picture is bigger than your anecdotal current situation. When you fly too close to the sun, you get burnt. His Second Amendment complaint, you see how they just skip right over that? Whether the assignment into a trust late was void and not merely voidable, it was decision to remand on demand, and they still ain't touch it. You notice how this court ain't touch it? No court is going to touch that. UDI alleged that the 2009 assignment is void under New York law, which he alleged governs the ISA trust because it occurred after the closing date specified in the PSA. He asserts that under Ivanova, the allegation is enough to survive the murmur. We disagree, although we must accept the truth of Yehudi's factual allegations when reviewing the ruling on the murmur. We are not required to accept the truth of his legal conclusions. And that is what many mortgage gurus can't understand. Your truth, knowing what happened, knowing the closing dates, none of that matters in court. We disagree. We are not required to accept the truth of its legal conclusions. Remember I said they like to make legal conclusions? Instead of making your claims and throwing it up in the air and let the judge finish the alley-oop. Hey, judge, we feel went like this. And the judge is like, well, damn, yeah, it couldn't go any other way. I see what you said. But many teachers are going to make legal conclusions. In opposition to the murmur, Yehudi relied on Galaski, the same thing Alan Najee keeps posting, to support his assertion that the 2009 assignment is void. In Galaski, the plaintiff's loan was pooled with other loans and transferred into an investment trust formed under New York law. Like Hudai, the plaintiff alleged that the purported assignment of his note in deed of trust to the investment trust was ineffective because the assignment was made after the trust closing date. To determine whether there was a legal basis for concluding that the trustee's attempt to accept a loan after the closing date will be void as an act in contravention of the trust document. The Court of Appeals looked at a New York statute which provides if the trust is expressed in an instrument creating the estate of the trustee, every sale, conveyance, or other act of the trustee in contravention of the trust is void. Quoting New York Establishment Powers and Trust Law, Chapter 7, verse 2.4. In applying this statute, the court relied on a then recent decision by a New York trial court, Wells Fargo Bank versus Irobobo, another case that I've read, which involved a mortgage that had been transferred into an investment trust after the trust closing date. The Irobobo one court stated that acceptance of the note and mortgage by the trustee after the date the trust closed would be void. Based on Irobobo 1 in a bankruptcy decision that followed Irobobo 1, Galaski concluded that plaintiffs' factual allegations regarding the post-closing date attempts to transfer the deed of trust into the investment trust are sufficient to state a basis for concluding the attempted transfers were void. And I told Alan Najee, you're relying on Galaski, but I'm telling you, we're not in the age of Galaski anymore. And he was citing me all cases in which I had case law after the dates of those cases to invalidate. It's all about the current case, not the prior case. After Galaski was decided, a New York Intermediate Appellate Court reversed Irobobo 1 in rejecting the trial court's view of New York law. The higher court explained that the borrower in that case
was a mortgagor whose loan is owned by a trust does not have standing to challenge the mortgage assignee's possession or status as assignee of the note and mortgage based on purported non-compliance with certain provisions of the trust. See, the difference between me and everybody else that's calls herself a teacher, I utilize this stuff for my own self. The trustee of the investment trust in that case was thus entitled to summary judgment on his action to foreclose the mortgage. This is post-Galaski, which Galaski relied on Irabobo. So when Irabobo failed, Galaski falls by the wayside by default. Subsequent cases have consistently rejected Irabobo 1. Want to know why? Because the system is too big. Hundreds of millions of mortgages are assigned to trust after the closing date. You think they're going to shut that down? In reference, Jepson, 7th Circuit, 2016. New York courts consistently have held that an assignment that fails to comply with the terms of a trust agreement is merely voidable and not void. Corecroft, HSBC Bank, rejected borrower's reliance on Irabobo 1 in light of reversal Irabobo 2. Ferguson versus Banker, New York Mellon, 2015. Based on Irabobo 2, courts construed New York law such that violation of a PSA would render challenge assignment of deed of trust at most voidable, but not void. Rajaman versus Deutsche Bank. Under New York law, unauthorized acts of trustee and investment trust were not void, but voidable. Butler versus Deutsche Bank, 2014. Even before Irabobo 2, the vast majority of courts to consider issues have rejected Irabobo's 1 reasoning, determining that the acts of a trustee in contravention of a trust may be ratified and are thus voidable, meaning they can correct the mistake. Salvador Supra, in contravention of any trust ratified. The bankruptcy court case Galaski cited has received similar negative treatment. Rzovskaya versus Deutsche Bank, August 1st, 2014. Kufos, U.S. Bank, 2013. Henry Stanworth, Eastern District of Virginia, my district, bankruptcy, 2016. I told you, when many people start winning on the same argument, they all huddle up and find a new way to shut it down. They gave everybody 2011, 12, 13. They gave everybody 3 years. Starting 2014, they said, nah, that argument is dead. I told you. See, I followed the procedural posture of each court in each district, and I started to see the turn in 2014. From 2011, 2012, 2013, I said, okay, everybody's spanking on these arguments. Once I got to year 2014, I said, too many people are starting to win. Too many people are starting to win. They done changed it. Like, I do this in real life, not online. I reap the benefits of what I teach in real life. Ain't no better feeling than putting in that hard work and walking away debt erased, entitled to the asset. Oh, man. All because you understand how the system works. The rejection of Irabobo 1 is based on sound reasoning. Under New York law, unauthorized acts by trustee may generally be approved or ratified by the trust beneficiaries. Remember when I said, why do you think they use New York trust law? Under Irabobo 1, however, a stranger to the trust will have standing to assert that the unauthorized transaction is void, thereby giving the stranger the power to enforce with the beneficiary's right of ratification. The stranger's right under Irabobo 1 to declare transaction and void would thus conflict directly with the beneficiary's right to ratify the transaction. This conflict is avoided by rejecting Irabobo 1 because a trust beneficiary under New York law retains the authority to ratify a trustee. Ultra vires act, such as a late transfer, the act must not be void. It must merely be voidable.
The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I can explain it to you.
You ain't got to explain it to me. You got to explain it to the judge. Because the decision upon which Galaski relied for its understanding of New York law has not only been reversed, but soundly and overwhelmingly rejected. We decline to follow Galaski on this point. Uh-oh, Alan Najee, because you're relying heavily on Galaski. Uh-oh. Standard Bank versus JP Morgan. Rejecting Galaski because New York case law upon which Galaski relied has been overturned, which I tried to explain to you, Alan. Galaski has been shot down. Based on the authorities cited above, indicate a post-closing assignment of a loan to an investment trust that violates the terms of the trust renders the assignment voidable, not void under New York law.
I'm gonna just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because Remick tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
You're rocking with the best.
Our Supreme Court's decision in Ivanova approved of Galaski's holding that a plaintiff has standing to assert a cause of action for wrongful foreclosure when a purported assignment necessary to the chain by which the foreclosing entity claims that power is absolutely void. That means only the investors, the beneficiaries, can render it void, not the borrower. The court stated, however, that Galaski's further holding that the assignment of a deed of trust to an investment trust was void because it occurred after the investment trust closing date was not before the court. The court and it expressed no opinions as to Galaski's correctness on the point. They're not even going to touch it. The reversal of Iribobo 1 and the judicial response to it occurred after Yuhade filed his second amended complaint in his opposition to the debarment. Yehudai now contends that New York law is irrelevant and has no role in this case. Oh, you was just signing it. Now it don't work no more. It's irrelevant. He points to a choice of law clause in the deed of trust, which provides that the deed of trust is governed by federal law and the law of the jurisdiction where the property is located, i.e. California. Even if this clause governed the question whether the assignment is void, Yehudi offered no citation to federal or California authority other than Galaski to support his assertion that the 2009 assignment is void because it was made after the ISA's trust closing date, because you're not going to find a case after Galaski. That's the whole point. If you were before Galaski, that's that 2011 to 2013 wave where you won all those arguments. When 2014 hit, nobody wins all those arguments anymore. But hey, I don't know what I'm talking about. I'm just a person who has already been successful in a non-judicial state. Already been successful in a non-judicial foreclosure. That's all who I am. But besides that, I don't know nothing else. Mr. Najee, I've already been successful in what you're trying to accomplish. But I will give you some advice. I didn't make none of the arguments that you plan on making. Therefore, we reject it. Arguments made without reasoned argument and citations to authority may be treated as waived. Y'all know what that means? When you just bring your claims, but you have no case law to back up your assertions, that should be an indicator that a lot of these sovereign citizen arguments have no merits. Okay, let me tell you this. If you make an argument in court, but you have no case law or authority to back up your argument, it doesn't mean nothing. You haven't stated no claim. When I raise arguments, like when that mortgage, I probably raised about 13, 14 arguments. I had case law to support all 13, 14 different arguments. But it also contains that he should not have to prove that the assignment is void. Why? That's your whole argument. Now contains he should not have to prove the 2009 assignment is void. The respondents, he argues, should bear the burden of proving the validity of the 2009 assignment. And that's the problem. You never look for the other side to prove your claim. You're the plaintiff. See, when everybody doesn't want to be a plaintiff, they got to be defended. When you're the plaintiff, you got to prove every single case, every single element of your case 100% spotless in order to win as a plaintiff, especially pro se. The arguments I raised with credit acceptance, you see those in class action, securities, and investor lawsuits. You would never see those arguments as a pro se. No one puts a law complaint together like me. Pro se, no one does. He cites the cases in which a plaintiff purporting to be the assignee of a contract right had the burden of proving it actually held the contract right it was suing to enforce. Rockefeller's Tidal, Neptune Society. Here, however, Deutsche Bank has sued no one. Yahadi, as the plaintiff is challenging a non-judicial foreclosure, has the burden to prove it was wrongful. I just said it. You're the plaintiff. And this is why only the select few are ever going to be the plaintiffs and succeed. When you're the plaintiff, you got to prove it. It ain't like being a defendant in the credit card debt case and you win by they didn't show up to court, or you win by a technicality, or they just dropped the case because they don't want to waste the time or money. The debt ain't really worth much. They was probably hoping you'll get a default judgment, something like that. But when you're the plaintiff in a mortgage case or auto case, and you especially take them to federal court, federal courts are strict. You best believe that federal judges are very sharp and they're very strict by the rules. And the reason why a lot of pro se people don't win in federal court at that is because they don't follow the rules are very strict. Now, you'll get your motions liberally construed as pro se, but you're not going to get exemption from the rules. If you do not know the court rules, do not step into a court. California law does not support Yuhaidi's claim. As even not cited, the deed of trust is inseparable from the note it secures, and it follows it even without a separate assignment. You know what that means? You know what that means? There's no need for the wet ink note signature. They don't have to. Whenever the note is signed, the deed of trust follows with it. I assigned the note to Justin. The minute I signed the note to Justin, the deed of trust follows it automatically. That's how courts start treating it now. So remember that 1854 Supreme Court case? You can't bifurcate the note. They separated the note from the deed. Yeah, that's in the early 1900s. Now, when I signed the note, the deed automatically follows. See, but they would know that. They read case law. It just says it right here. California, even article said the deed of trust is inseparable from the note it secures and follows it even without a separate assignment. See, this is where we get to. This is where people's arguments start to fall apart. What they believe is true starts to fall apart. And I know people that work behind the scenes on this stuff. So we have an advantage over here because we're going to be privy to a lot of things that the average pro se litigant would just never be privy to because they're nowhere near in that world. I'm closely connected to that world in real life. Hey, what's up, partner? Hey, I just have a quick question. The brother for Fannie Mae, right? I want us three to get on the call. I want to see if he can make an appearance with at the Supreme Elite Team University. I want to see if just like 15, 20 minutes of his time. If he just make an appearance.
Cool.
All right. It starts Friday, but we'll do it for probably the second or third week. We'll do that as a. I want to talk to him before so I can have that as the like a special guest type situation.
Okay.
All right. Yeah, and the only thing we're just going to discuss the behind the scenes, just with the just the little transfers of the notes and the payment structures to the investors. That's all. Just a little.
Okay.
I bet that. Yeah.
Cool. Yeah,
So just let them know we can all get on the three-way and go over the parameters. So just be a speed dial away. Yeah, it's just.
Jeff Gamble.
Mr. Gamble, how you doing, sir?
I'm doing well, thanks.
This is Lamont Thomas.
Yeah. Good.
Hey, nice talking to you. I just wanted to let you know personally, I appreciate your help.
with the matter of resolving this with credit acceptance. I did receive the title. I appreciate the fast expedition on that, but just wanted to give you a thank you, man. I appreciate your hard work, man.
No, I'm glad we were able to work it out.
Yes,
and you were a big part of that process too.
Yes, most
You know,
definitely.
Just sit for a bit and the momentum when people are working towards the goal
Yep.
really helps.
Yes,
helps
sir.
The process.
Yes, sir.
I too am thankful for your role in that as well. But I really appreciate the cause.
Yes, sir. Maybe one day we can go head out to a restaurant and I can just pick your brain a little bit, man, because your record is an exceptional, man. Now, for real, your record is an exceptional, man. For real. I follow a lot of your work, man. You're exceptional. I give you credit, man. So maybe we can do that some other time, right? Off the record or something.
Appreciate that offer.
Yes, sir. Yes, sir.
It was nice working with you. Really
All right. Thank you, Mr. Gamble. I know you're busy, man. I'll see you later, man.
All right. Thanks very much. Take care.
All right.
All right. Bye-bye.
That was the attorney for credit acceptance.
You're rocking with the best. You're rocking with the best.
Seasoned class action litigator. He's a seasoned class action litigator. He's a litigator for real, Jeffrey Gamble. Seasoned class action litigator. Oh, I build connections everywhere I go. I build connections with elite professionals everywhere I go. How do you do that? You just a regular. Because I understand the game and they understand that I understand the game. So when you understand and know the game, you get treated differently. Instead of coming with, where's the blue wet ink signature? It's fraud. They took my home. And when you get to settlement, you're not trying to, I want money. I'll settle. I want the proceeds for the note. I want the security. You don't understand professionalism and settlements and how the business works. And knowing that if you ask for money instead of the asset, they're going to fight and say F you because giving money is akin to admitting guilt. They don't ever want to admit guilt. This is why I propose that no admission of guilt on both sides. That's what made credit acceptance way more than settlement. Because one thing, when you get on professional status with it, you have to protect the same system in order for you to get what you want. That's how the game goes. Call me a sellout or what, but that's how the game goes. And I'm not here to rewrite the rules to the game. I just follow protocol. And that's how you win. I played a big role in my settlement. I could have forced them into a fight and won. I could have forced them, but why? Is that really the right thing to do? Why over push? You know you got them dead to rights. Why over push? Don't they offer times to settle with you? Hey, you're severely behind, but we'll settle this for this. Don't they offer chances to settle? What's the bigger goal? Trying to expose some, extract money out of them, or play the game to win? There's always going to be opportunity to get money out this. But when you start chasing money in this as your only sole goal, you always end up chasing your tail. Thus, if the note was timely conveyed to the ISA trust, as Yahadi alleged, so was the deed of trust. Although the conveyance of the note may have been separated in time from the execution, recorded and physical transfer of the instrument reflecting the assignment of the deed of trust, the gap does not alter the legal fact that the deed of trust and the right to foreclose was, as a matter of law, transferred along with the note. U.S. versus Thornburg, 9th Circuit, 1996. Even if a party holding the deed of trust instrument fails to hand it over to the note holder, has the right to like I said. The bifurcation, the deed of trust must follow the note. Those are old, outdated arguments. Mendez versus D1 Investments, 2005. Button-Up versus Wells Fargo, 2011. And you know what I think? You know what the Fannie Mae, the one that works on behalf of the investors, that processes the payments to the investors, deals with the collateral agent, deals with behind the scenes. You know, I asked him a question. I said, hey, I'm going to ask you a question. This is what I believe. This is what I researched. This is what I think is true. I said, the deed of trust is BS. It's hot air. It's a smoke screen. It's the note that really is the real deal, ain't it? He said, you are absolutely right. The deed of trust ain't nothing but a piece of paper. It's the note. And it's a guy that works behind the scenes with him. And that's what I figured out through my study. I said, the deed of trust is a smoke screen.
You're rocking with the best.
Everything that I teach in my group has been confirmed by the top professionals in this field. and it played out in my lawsuit. So my understanding is on top professional level. What do you think happens when we step inside of a courtroom with it? Yahadi further contends that the language in the deed of trust confers upon him as the borrower the right to sue to assert non-existent of a default or any other defenses to acceleration and sale. Yahadi has not, however, asserted the non-existence of a default, and its only purported defense to foreclosure is that the 2009 assignment is void. Even if the language in the deed of trust might have provided Yahadi with standing to assert a defense to prevent a foreclosure, it does not help him here. Yahadi also argues that the deed of trust is an adhesion contract that does not use conspicuous and clear language to warn him that he has no power to challenge an invalid assignment of his loan. This is how it goes. From a professional standpoint, this is how it goes. They use a trust law to siphon our property from us. They use accounting to hide what's really going on. And they use contract law to stick us with the debt. Once I understood those things and how they go about doing it, then I understood that their only line of defense is the initial complaint in the attachment of the contract, in the note or the deed of trust or the auto contract. And they want to immediately try to get a summary judgment in there. And they're going to fight so hard at the beginning stages, because the longer the case proceeds, that's when their case starts to fall apart. They have no other line of defense but the contract. Wanna know why? They want to stick you and stay right on the contract. Wanna know why? It's because if they don't, they'll be exposing what's really going on behind the scenes. And it's not the fact that they're exposing what's going on, but when you understand and you also know what goes on behind the scenes, you'll understand that you never really owe what they say you owe. They never expect you to pay what they say you got to pay. And they don't even account for them receiving the amount that's stated on the contract. They don't even, the contract is BS. They only expect to get a percentage of that. And that is what they expect to get for you. And that is what they go by. So anything else that you pay over that number is all extra to them. Trust me, I put this system together, and everything I can prove it in court. See, that's the whole difference right there. No theories. Everything I say, I can prove it in court, no matter the situation. And this is why I love being the plaintiff. Now you see why I love being a plaintiff? Because I can prove everything in court. If I 15 arguments, those are my go-to. I got about 15 arguments in the chamber, and I can prove all 15. And finally, Yahadi contends that he should be permitted to amend the case to add a cause of action for wrongful foreclosure. This proposed cause of action, however, it was similarly dependent upon the allegation that the 2009 assignment is void because it was made after the ISA's trust March 2007 closing date. Because he has not led sufficient facts to establish that critical allegation, the proposed new cause of action will also fail as a matter of law. Don't even matter what you argue, it's still going to fail. The judgment is affirmed. Respondents shall recover their costs on appeal.
I'm gonna just try and break this down clearly to you. The trust in my client's case has been closed for 3 years. They cannot tie up any loose ends with that. Why? Because RAC tax law prevents them from transferring any assets into the trust that aren't qualified mortgages and that are after the cutoff date and 90-day grace period for the trust. So they cannot tie up the loose ends. This is as clear as I could explain it to you.
And that's when I knew he was a rookie.
Got sauce in my hand. She rolling the dice, got luck in that van. Smoking that leaf, going global stand. On my wrist like a stage, I can't glance. You look like you wanna let go straight. I thought so, okay. I'm back in this symphony stuck on a bench. What's up? I thought so. Okay, yeah.